Good morning, ma'am. What's your name?
Valerie Elizabeth Hamilton and Brigade.
Then you have two cases. In both cases, you're picked up on charges for failure to appear. The first case, the bond is set at $1,500. The second case, the bond is $250. Thank you, ma'am. The next person we'll call is Leon Addison.
President approaching.
What's your name, sir?
Leon E. Addison.
Okay, sir, you picked up on an out-of-county warrant. Bond is set at $2,000. Thank you, sir. Next person is Beatrice Diaz.
President approaching.
What's your name, please?
It's Beatrice Maria Diaz.
Then get charged with battery, domestic violence. Did we have anything from pretrial release on this case?
No, sir, she doesn't qualify for pretrial release.
Okay.
They said I do.
I'm going to set bond in this case in the amount of $1,000 with the special condition that you have no contact with the victim involved in this case. And if you all live together, you'll be allowed to go back to the residence one time to pick up belongings with law enforcement. Thank you.
Thank you, Your Honor.
Mitchell Fester.
President approaching.
What's your name, sir? Sir, you're charged with trespass, the structural conveyance, bond set at $250. Thank you, sir.
Your Honor, he qualifies for direct pretrial release.
State have any objection to that?
One moment.
Mm-hmm.
No, Your Honor.
So I'm going to release your pretrial release at this time. Trevor Good.
President approaching.
What's your name, please?
Trevor Good.
You're charged with battery. I'm going to set bond in the amount of $1,000 with special condition that you be released to the pretrial release program. With special condition, you have no contact with the victim involved in this case. And also that if you all live together, you cannot live with that person. You can be allowed to go back one time with law enforcement to retrieve any belongings. Thank you. John Gorman.
President approaching.
What's your name, sir?
John Bragg, Jude Gorman.
Okay. You're charged with grand theft. Bond set at $500.
And Your Honor, Mr. Gorman had earlier advised whether the court would consider RORing him.
No, sir. No, ma'am. I'm sorry.
Have a seat, sir. Thank you.
Alan Lopez Marquez.
Lopez? Your Honor, I believe he's on his way.
You say he's on the way, you said?
Yes, Your Honor. He was in a different pod and they were doing count in that pod. May we leave him for last?
Okay, well, I'm going to move to somebody else then, and we'll go. Melvin Manning.
Manning, President approaching. And Your Honor, I do have information for the court. It has come to my attention that Mr. Manning has previously been found incompetent to proceed. Defense would respectfully request from the court whether the court may ROR Mr. Manning.
Okay. What's your name, sir?
Melvin Manning, sir.
Mr. Manning, you're charged in the first case with possession of cocaine with intent to sell, deliver, and possession of drug paraphernalia. And you also have a warrant for a charge of grand theft. State wish to be heard as to what the public defender's office just requested.
We would oppose.
Well, on the possession of cocaine case, I set bond at $1,000. Possession with intent to sell, I set bond at $2,500. Possession of drug paraphernalia, $500. As to the warrant, I'll leave it at $2,000. No contact also.
Your Honor, he's out on conditional release on the Osceola County case, which is the same case he was found incompetent, which is 21 CF 1372.
I'm not going to take any action with that case.
Thank you.
Thank you for letting me know.
Have a seat, Mr. Manning.
Joseph Medina.
He requires a Spanish interpreter.
Okay.
Approaching.
Don't I hit it? This one? I don't see it on here. I thought I hit it over here first. Let me see. Now, I could, I don't see nothing over here to hit it with. Oh.
Interpreter.
Good morning, Your Honor. Jaime Sotomayor, certified federal interpreter, not sworn yet today.
You solemnly swear that the interpretation you give here today will be the truth, so help you God, sir.
I do.
All right. We have a gentleman at the podium in Osceola County. I believe this is Mr. Joseph Medina. Is that correct, Madam Public Defender?
Yes, Your Honor.
Tenemos al caballero Joseph Medina.
What's your name, sir?
Joseph Medina.
Su nombre completo, por favor.
Joseph Medina.
So you're charged with the offense of DUI.
Usted está acusado de manejar bajo los efectos.
It appears to me from the paperwork you qualify for straight pretrial release. Is that correct?
Me parece que usted cualifica para ser liberado directamente con las condiciones de la Oficina de Antelación al Juicio.
That's correct, Your Honor.
Es correcto, señoría.
So I'm going to release your pretrial release in this case.
Lo voy a liberar entonces con las condiciones de la Oficina de Libertad anterior al juicio.
Okay, ma'am. Madam Public, well, sir, that's all we have for you.
Thank you, Your Honor. Tome
Eso,
asiento, por favor.
eso es todo con usted. Se puede sentar. Do we have a case number for that case, Your Honor?
No, we don't have a case number for it.
That's okay.
Madam, the interpreter, just hold on a second. I'm going to try to call the other Hispanic person that we need an interpreter for in Osceola County. Madam Public Defender, who is that person?
Luis Velez, he's at the end of the page before the resets. Luis, por favor, venga.
What is your name, sir?
Su nombre completo, por favor.
Luis Vélez, sir.
Luis Vélez.
Sir, you're charged with the offense of fleeing or attempting to elude law enforcement officer with lights and sirens activated.
Muy bien, usted está acusado del delito de escapar o de huir de un oficial de la policía con la sirena y las luces encendidas.
I'm set bond in the amount of $2,500.
La fianza va a ser $2,500.
Your Honor, would you like pretrial release attached to that? He qualifies for direct PTI.
Yes, I'll with that conditional pretrial release also.
Él cualifica para las condiciones de libertad con la Oficina de Antelación al Juicio, así que vamos a incluir esas condiciones.
Thank you. I believe that's all we have for the interpreter for Osceola County. Is that correct, ma'am?
Your Honor, it would also be Alan Lopez Marquez, the individual that we're waiting for to come from the pod. However, if we do receive him by the end of the docket, then we'll go ahead and recall him. If not, then I will reset him till tomorrow.
Okay, so for the interpreter, we'll call you back when we need you.
No problem, Your Honor.
Thank you, sir. Okay, the next person I have is Nicole Onque.
Yes, Your Honor. President approaching.
What's your name, please?
Nicole Onque.
Okay, you're charged with several offenses, so I'm gonna go through them slowly. You have one count, well, you got 1, 2, 3, 4, 5 counts of burglary of an unoccupied vehicle. They have bond set at no bond. I'm gonna set bond in each one of those counts at $2,500. You have 3 counts of petty theft, greater than $100 but less than $750. Bond in all 3 of those counts will be $500. You have 2 counts of grand theft. Bond is at $1,000 in each one of those counts.
And Your Honor, just to be clear, the court had imposed a $2,500 bond on all the burgs, correct?
That's correct.
Each one of them.
Yes, ma'am.
Okay, thank you, Your Honor.
Your Honor, she does qualify for direct PTR. Would you like
Base-
bonds on it or a PTR?
No, I'm gonna leave with the bonds, ma'am.
Okay, thank you.
Thank you for letting me know.
Thank you, Your Honor. Have a seat, Ms. Onque.
Gloria Ortega Pina.
President approaching. Usted necesita intérprete, correcto? Your Honor, she also requires a Spanish interpreter, and the individual that we were waiting for, Alan Lopez Marquez, just arrived.
Okay, I'll call the interpreter.
Thank you.
Hi, Mr. Sotomayor, certified federal interpreter again. 1 second while I connect to the headset.
Okay.
We're ready, Your Honor.
Wait, this,
Headset.
yeah, this is still Osceola
No problem.
County.
Yeah,
Okay.
no problem.
What is your name, ma'am?
¿Su nombre, señora?
Gloria Magali Ortega.
Mariam Magali Ortega.
Ma'am, you're charged with the offense of battery.
Usted está acusada de agresión.
And Pete Trial, at least I see you have some information for me on this case.
Y la Oficina de Antelación a Juicio tiene alguna información para mí en este caso.
Yes, Your Honor, she qualifies for PTR with a bond.
Ella cualifica para ser liberada bajo las condiciones de la Oficina de Antelación a Juicio con una fianza.
And I also see that the victim wants contact with the defendant.
Yes, Your Honor,
Y también veo que la víctima quiere tener contacto con la acusada.
that is correct.
Now,
Eso es correcto.
I'm set bond in the amount of $1,000 with a special condition that you be released to the pretrial release program.
Muy bien, le voy a imponer una fianza de $1,000 con la condición especial de que va a ser liberada bajo las condiciones de la Oficina de Antelación a Juicio.
You will be allowed to have no hostile contact with the defendant, with the victim in this case.
Y se le va a permitir tener contacto no hostil con la víctima de este caso.
Which means no arguing or fighting.
Lo que significa que no pueden tener discusiones ni peleas.
Okay, thank you.
Ok,
Thank you.
muy bien, gracias, eso es todo.
And Madam Public Defender, what was the next case we supposed to call for the interpreter?
Alan Lopez Marquez.
Okay. What's your name? What's your name, sir?
¿Su nombre, caballero? Alan López Márquez.
Okay, sir, you were charged with no valid driver's license.
Usted está acusado de manejar sin licencia válida.
I'm set bond in the amount of $250.
La fianza va a ser $250.
Thank you, sir.
Gracias, eso es todo.
For the interpreter, I think that's all we have, sir. No, I'm saying just for Osceola County, that is.
That's correct,
Right.
Your Honor.
Okay.
We still have Orange.
Yes, sir. We're still working on Orange.
Okay, I'll be standing by for Orange.
Okay. Timothy Price.
Your Honor, can we go ahead and reset him? We had to send him back due to behavior, and also it has come to my attention that he has been found incompetent to proceed, and I believe he's on conditional release in another case.
Okay, you want to reset him for when? Monday?
Tomorrow, Your Honor. I will
Reset
set it
it.
tomorrow.
Yes, ma'am. We'll set them for tomorrow.
Thank you.
Miguel Soto Acosta.
Present and approaching.
What's your name, sir?
Miguel Angel Soto Acosta.
So you got picked up on an out-of-county violation of probation warrant. Your bond is no bond at this time, sir.
Tome asiento.
Kyle Thompson Henry.
Present and approaching.
What's your name, sir?
Kyle Thompson Henry, Your Honor.
So you're charged of trespass and occupied structure and set bond at $250. Thank you, sir. Eduardo Vasquez.
Present and approaching.
What's your name, sir?
Eduardo Vasquez, sir.
So you picked up on a failure to appear. Bond is set at $5,000, sir.
Thank you, Your Honor.
Jose Antonio Perez.
Your Honor, he refused yesterday and refused today. I'll go ahead and waive his appearance. However, defense does not have a copy of the police report.
Well, I think that means you need to reset him and they need to bring him by any means necessary.
Thank you, Your Honor.
That's so I can put that in the order. They bring him by any means necessary. He can't run to jail down there. All right. Okay. Let's see. We'll bring him back tomorrow. Okay. This is Gordon Vincent Harrison Smith. I don't know which one of those last or first name.
Yes, Your Honor. He also refused. I'll go ahead and waive his appearance.
Okay. His bond will be stayed at $250.
Thank you.
Your Honor, if the
Wait a minute.
court is willing to address a case that was reset,
Whatever.
I'm sorry, it was addressed on November the 9th. The judge previously gave her RR on her charge of possession and gave her a $250 bond for her charge of paraphernalia. She's saying that she cannot afford the $250 bond. Would you entertain RR on her on that charge as well?
I don't know who you're talking about, ma'am. You got to tell me who you're talking about.
Her last name is Blaine, first name Deborah, or we can address it tomorrow if you don't have the information.
I think that'd be better because none of us have any of the information.
Okay, thank you.
Okay. Now, on this one here, the last case, the Gordon Smith,
Yes, Your Honor.
there are several different, I didn't realize this. One is set at $250, there's a failure to appear, and the bond is set at $500 on that.
Thank you.
So I just want,
Judge, I couldn't hear you with all the noise.
the bond on this last case with
Yes.
Gordon Smith, there are two separate cases. One is loitering and prowling, failure to appear is $250 bond, and then there's another failure to appear, and the bond is $500.
It's just the one case.
Oh, it's just one case? Oh, so it's a total of $700?
No, it's just 500.
Your Honor, according to what defense has, it looks like it's just one case. It's case number 22MM1324. It is a loitering and prowling. It was a failure to appear, and bond is set at $250.
Well, from what we see, his bond is set at $500. So I'm gonna leave it at the $500 though. I was right, you were right, it's one case, but it's $500.
Okay.
All right.
Thank you, Your Honor. And then for Mr. Perez, we'll just reset him to tomorrow. And may defense have the paperwork associated with Mr. Perez?
I think it's a warrant. Madam Clerk, can you let me look at that again?
No, Your Honor. Jose Perez.
I don't have an objection.
Yes, if it's a warrant, I can address it now, because he refused again, so I can waive his appearance. If the court prefers for him to be brought tomorrow, we can proceed tomorrow.
Let's bring it tomorrow.
Okay? Thank you.
Yeah.
Your Honor.
There's a victim here for somebody.
Ortega Pena Gloria from Osceola, her victims here.
We got a victim from Osceola County, on the Osceola County case that's here.
For
And,
which case, Your Honor?
I think they said the name. We're looking it up now.
And Your Honor, we would need a Spanish interpreter for Ms. Pena.
Yes.
Okay. We'll call him back. This is Gloria Ortega Pena.
President approaching.
Let me call the interpreter back.
Thank you.
Connected again, Your Honor.
We're still back on Osceola County. This is a case we called earlier, Gloria Ortega Pena. We have a victim that's here in Orange County, so we're calling that case back again.
Muy bien, estamos llamando el caso de la señora Ortega porque tenemos la víctima aquí. Una vez más, vamos a entrevistar a la víctima.
Now, for the interpreter, I don't know if you needed this person needs an interpreter or not. Do you need an interpreter?
Yes, please.
We have an individual here that's testifying. It's gonna have. I'm assuming they're gonna testify something that we need an interpreter for. Can you do that too?
Yes, sir.
Okay. Raise your right hand, please.
Por favor, levante su mano derecha.
You solemnly swear that the testimony you're about to give here today will be the truth, so help you God.
¿Usted jura solemnemente que el testimonio que va a dar aquí será la verdad con la ayuda de Dios?
Sí.
Yes.
Mr. J, did you want to inquire? Since I'm assuming it's a state witness.
Can you tell us your name, please?
Por
Edwin,
favor, díganos su nombre.
Edwin Carrera Borges.
Hermín Carrera Borges.
What is your relationship to Gloria Ortega Pena?
She's my wife.
Que
He said he sees his wife, so I understood that.
Okay. And do you have a position on what the conditions of release should be for this charge?
¿Usted tiene alguna posición en cuanto a qué condiciones de libertad se deben imponer debido a este cargo?
No, ninguna.
No, none.
Is there
Your Honor, may
any?
defense inquire? Oh, I apologize.
Well, let the state finish though.
Is there anything you want to tell the judge about the conditions of release?
¿Hay algo que usted le quisiera decir a este juez sobre las condiciones de libertad?
No, estoy de acuerdo. No quiero tener contacto con ella y nada más. No me siento en peligro ni nada.
No, I just agree with her being freed. I would like to have contact with her, and I don't feel endangered or anything.
Thank you.
I think the public defender wanted to have a.
Yes, Your Honor.
Go ahead.
Señor, ¿usted pagaría la fianza
I'm,
para...
I'm,
Hold
I'm sorry.
Don't do it that way. Ask it in English,
I
and then we
apologize,
have
Your
an
Honor.
interpreter go.
I speak Spanish, so I was thinking in Spanish. I'm sorry. Are you going to pay the bond for Ms. Peña?
Señor, ¿usted es quien va a pagar la fianza de la señorita Peña?
Yes.
Can you afford
Yeah.
$1,000?
¿Usted puede cubrir $1,000?
Yes. Can I pay with credit card?
He said something, Mr. Interpreter. I don't know what he said. I couldn't hear him.
It was English. He said, "Can I pay with credit card?"
Defense does not know the manner of payment. However, can you afford a $1,000 bond?
No sabemos si esa forma de pago está disponible, pero usted puede pagar una fianza de $1,000.
Yes.
Anything else, ma'am?
No, Your Honor, not at this time.
Okay. I think that I had released pretrial release with the condition of a bond of $1,000 with the special condition that you all have no hostile contact with each other.
Muy bien, pues me parece que ya yo le había impuesto a ella una fianza de $1,000 con las condiciones de la Oficina de Libertad anterior a juicio, con la condición especial de que no hubiera ningún contacto hostil entre las partes.
Thank you, sir.
Thank you.
Así que muchas gracias, caballero.
I believe that's all we have in Osceola County.
That's correct, Your Honor. At what time would the court like to begin tomorrow?
Well, I don't know. I won't be here, so I don't want to tell you who. That's another judge, so I don't know what time they start. I'm assuming you supposed to start at. I'm assuming you start at 11 o'clock tomorrow.
Thank you, Your Honor. And one second, it has come to my attention that perhaps two more individuals were just called in. 1 second.
Well, we don't have no paperwork for them.
Your Honor, I apologize. They were all called.
Okay. Thank you. Have a good day.
You too, Your Honor.
By the way, Your Honor, Your Honor, sorry to interrupt. I don't have your name.
Whose name?
Your name.
Reginald Whitehead.
Judge Whitehead?
Yes, sir.
Thank you, sir. I just didn't have it here.
Bond is set at $500. You also were out on bond on case number 2022 MM000546 on count one of of criminal mischief, count two, trespass or obstruction, and count three, resisting an officer without violence. You ROR'd on that. I'm going to revoke those RORs and the bond in this case for getting a new law violation. Your new bond is, in that case, in count one, the criminal mischief would be $1,000, the trespass $1,000, and resisting without violence $1,000. Thank you. What do I need to do? Oh. That's on this one here. Yeah, that's it. Well, are they home? Oh. We have the interpreter on the line for him. What's your name, sir?
你好，您叫什么名字？我是您的翻译。
外华。
外华。
爱
华。
对。
So you're charged with battery, domestic violence.
你的指控是实施家庭暴力。
对。
Correct.
So I'm gonna set bond in the amount of $1,000.
稍微有点摩擦。
He does qualify.
是1000。
I'm going to, well, strike that, ma'am. I'm going to release him to pretrial release.
好的，我会释放，就是前庭释放。
With the special condition that you have no contact with the victim involved in this case.
条件是跟这个受害人不能够有联系。
You also cannot live with the victim, so you'll be allowed to go back with law enforcement officers one time to retrieve any belongings.
你也有一次性的可以去在监护下拿一些个人物品出来，一次这个机会。
Thank you, sir.
谢谢。
I think that's all we have for the interpreter, right? That's all we have.
Oh, okay. Thank you for your sound services, Your Honor. Have a nice day.
Thank you.
Thank you.
What's your name? Hold on one second. I know how to hang it up. So. Is the interpreter still there? No, he's not there. interpreter on the line?
I'm on the line.
Okay, thank you. What is your name?
Thank you. My name is Michelle Beauvoir, and my ID number is 390461.
You're charged with battery domestic violence.
OK, ou accusé de violence domestique avec batterie.
For the interpreter, we have a witness that's going to testify, so I'm getting ready to ask him what his name is now. What is your name,
Okay,
sir?
all right.
Christophe Capi. Christophe Capi.
Okay. Christophe Capi.
Jay, you want to inquire him?
What is your relationship with Miss Mars?
Madame.
Qui relation? Oh, it is my wife.
And do you have any anything you'd like to tell the judge before he sets the conditions of her release?
But besoin pour manger à la caille, besoin pour la caille parce que bagay moun qui pour état moun yo faut qu'on travaille.
I want her to go home because there's nobody to stay with the children, and I have to go home. I have to go work.
No other questions?
Brother Finna, have any questions?
Yes. Are you in fear of your wife?
I'm sorry, can you repeat that? Are you?
Do you fear your wife?
Est-ce qu'on peut madame?
No.
And you want her to return home,
No.
correct?
Yes.
Et vous voulez le retourner la caille?
Oui.
No further questions, Your
Yes.
Honor.
Is he qualified for pretrial release? I mean, minimum set bond in the amount of $500 with the special condition that you have no hostile contact with your husband, no arguing or fighting.
OK, so kounya bel mettez à $500 et que sous condition qu'on pas bataille avec Mario.
No, banan ba ça.
No, I'm not going to do that.
I think that's all we have. Thank you.
Okay, all right.
What's your name, sir? I think we're finished with the interpreter.
Oh, okay, all right. Thank you. Have a nice day.
You too.
Bye.
Okay.
Good morning to you all. What's your name, the inmate? What's your name, sir?
Anderson Falk.
I can't hear you.
Anderson Falk.
Okay.
Joseph Knapp on behalf of Mr. Falk.
Okay. You got picked up on a charge of fleeing and attempt to elude law enforcement officer, driving while license suspended or revoked, and attaching a tag not assigned to a vehicle. The bond on that tag charge is $250. Driving while license suspended bond is $2,500. Just give me just a moment. Let me look at his fleeing. You said bond in the amount of $5,000 to that.
Your Honor,
Yes, sir, Mr. Chair.
he's out on bond for 2 counts of DUI manslaughter and 2 counts of vehicular homicide. CF 20-14933. It's the state of Florida's position that the bond should be revoked on those counts in that case due to the nature of the new offense.
Your response from you, sir.
Your Honor, we would request that you take no action on the CF case. That case has been pending for over 2 years. And also, if the court does decline to modify the bond to just double the bonds on the original case, as he did previously with other cases today.
Well, I just got that case number here. It's 2020 CF 0149339, and he was out on bond. So I'm going to revoke those bonds on both counts, the DUI manslaughter.
It's 4
It's
counts.
2 counts of DUI manslaughter and 2 counts of vehicular homicide. Based on the new law violation, I'm going to revoke the bond and not setting a new bond, sir. Leave it at no bond.
Thank you, Your Honor.
What's your name, young man?
Blake, sir.
Okay, Mr. Blake, hold on one second here. Blake, the first case I have was possession of controlled substance, bond is set at $1,000. You also have a battery, dating violence. Bond is gonna be set at $500 with special condition, you have no contact with the victim involved in this case. You have another charge of violation of domestic injunction. You set bond in the amount of $5,000 with special conditions, you have no contact with the victim, sir. Thank you. What's your name, sir?
Christopher Griffin, sir.
Okay, so you have several cases. The first case I have here is the possession of ecstasy or MDMA, bond is set at $1,000. Possession of cannabis under 20 grams, bond set at $100. You have a battery domestic violence. Set bond in the amount of $1,000 in this case. A special condition, you have no contact with the victim involved in this case. You got another separate battery, domestic violence. Set bond in the amount of $1,000 in this case. Special conditions, you have no contact with the victim. You have a third battery, domestic violence. Bond is set at $1,000. Special condition, you have no contact with the victim, sir. You also have being in a park facility after hours. Bond is set at $250 today. Thank you, sir. What's your name, sir?
Mr. Johnson, sir.
Johnson, you're charged with the offense of aggravated assault with a deadly weapon. Set bond in the amount of $10,000 with a special condition that you have no contact with the victim. Count 2, battery domestic violence, bond set at $1,000, a special condition, you have no contact with the victim. False imprisonment, count 3, will set bond at $2,500. Count 4, battery by strangulation, domestic violence, set bond in the amount of $5,000, special condition, you have no contact with the victim. You have, yes, ma'am. Mm-hmm. You have another case, it's trafficking in MDMA, bond is set at $50,000. Count 2, possession of drug paraphernalia, bond set at $500. Possession of cannabis less than 20 grams, bond set at $200. I'll set it at $500. I'll leave it stay at $500. Thank you, sir. What's your name, sir?
My name is Rosenda Bongok, sir.
Okay, so you're charged with battery domestic violence. Ma'am, what's your name?
Sarah Bongok.
Okay, Ms. J.
Morning, ma'am. Do you have anything you would like to tell the judge about the conditions of release before the judge sets them?
I want a contact with him. I need him to be home. I am here to take him from here to go home. No hostile contact.
Anything from the public defender?
Yes, Your Honor. So from my understanding, you're not in fear of your husband, correct?
No, I'm not in.
And you would like for him to return home?
Yes, I am.
No further questions, Your Honor.
What about pretrial release? Your Honor. So I'm set bond in the amount of $1,000 with a special condition that you have no hostile contact with your wife. That means no arguing or fighting, sir. All right, thank you.
Thank you, sir.
All right. What's your name, sir?
Rodney Day Jr.
Day, you're charged of battery domestic violence. Just give me just a second. Okay, sir. You said bond, is he qualified for pretrial release, counsel? Sir?
Your Honor, he is on active state probation as a VFOC detainer.
I'm gonna set bond in this case in the amount of $1,000. Special condition, you have no contact with the victim involved in this case, sir. Thank you.
One moment, Your Honor.
What's your name, please?
Valentina Galvez.
You're charged with battery of domestic violence. What's your name, sir?
Angel Rivera.
Okay.
Anything you'd like to tell the judge before he sets conditions of release?
I just want her to come home. It was a whole misunderstanding. I didn't expect things to get to where they are right now.
Anything?
No, Your Honor.
Okay. And you say she qualifies for pretrial release?
Yes, Your Honor.
Now I'm gonna release your pretrial release with special condition that you have no hostile contact with the victim involved in this case. That means no arguing and fighting between the two of you all. All right, thank you.
Thank you, Your Honor.
Mm-hmm. What's your name, sir?
My name is Jose Rafael Ariano, sir.
You're charged with battery, domestic violence. Just give me just a moment, please.
Yes, sir.
All right, thank you. So I'm gonna set bond in this case in the amount of $1,500 of special condition. You have no contact with the victim involved in this case. It means you all can't live together.
Your Honor, can he get a one-time return with law enforcement?
Yes, ma'am.
This person does, Your Honor. The next person.
Okay, thank you.
One moment, Your Honor. He has a question.
What's your name, sir?
David Melendez.
You're charged with battery, domestic violence.
Yes, sir.
Ma'am, what's your name?
Veronica Rivera.
Okay.
Ma'am, is there anything you'd like to tell the judge before he sets the conditions of release?
Yes, I want no contact.
I can't hear you.
I want no contact.
You want no contact? Are you afraid of him? Is that a yes?
Yes.
Thank you.
Anything from,
No, Your Honor.
okay, he does, you said qualified for pretrial release? I'm going to set bond in the amount of sir, I want you to make sure you listen to me now. We'll set bond in the amount of $1,000 with special conditions to be released to pretrial release program, but you can't have any contact with the victim at all, sir. All right,
No
thank you.
problem. Sounds good to me.
Can he also get a one-time return, Your Honor, with
Yep.
law enforcement?
Yes, I give you one time to go back to law enforcement officer to retrieve your belongings.
No, because you're doing wrong. Turn this way like I asked.
Thank you, ma'am.
Can I go now?
Qualifies, Your Honor.
Okay. What's your name? You're charged with battery, domestic violence. What's your name, sir?
Jesus Hernandez.
Okay.
Is there anything you'd like to tell the judge before he sets conditions of release?
It was all a misunderstanding. I even told a police officer that I didn't fear for my life and anything.
and I want her home.
All right, she qualifies for pretrial release in this case. I'll release a pretrial release with the condition, ma'am, you have no hostile contact with the alleged victim in this case, which means no arguing or fighting between you all. Thank you. What's your name, sir? So you're charged with battery, domestic violence? You qualify?
No, Your Honor. Oh, I'm sorry. Is this Sabati? Your Honor?
Yes.
Yes.
Yes, he does qualify.
I'm gonna set bond in this case in the amount of $1,000. With special condition, you be released to the pretrial release program. Have no contact with the victim involved in this case.
Your Honor, in regards to this case, can we just do PTR without a bond? He doesn't have a criminal history.
State, any objection?
1 second.
It's 2 counts. Where is that? It's on here. Oh, that's why they put 2 counts there. It's 2 counts too. I didn't realize, I thought it was just 1 count, but it's 2 counts of battery. When I was reading it, I thought they were talking about 2 different people, but.
He does qualify for PTR on both counts, Your Honor.
Yeah, I just want to hear what the state had to say.
I'm just gonna, I'm seeing Florida arrest history for violation after an injunction, so that gives me pause.
Well,
I don't see any convictions, Your Honor. If it's just an arrest, there's no convictions, no felonies, no misdemeanors, and no failures to appear.
I'll release a pretrial release on each count with special condition, they have no contact with either victim, and that he be allowed to go back one time with law enforcement officer to retrieve any belongings.
No bond on that, Your Honor?
All right.
No bond on that?
I'm not gonna use it, just this PTR, yeah. Oh, this shit. What's your name, sir?
Good morning, Your Honor. My name is Orlando Candelario.
Okay, so you're charged in count 1 with burglary of an occupied conveyance, bond set at $3,500. Count 2, battery on the security officer, bond set at $150.
Your Honor, I have a question.
Now, I don't know if I need to be the one to answer that question, but you might want to talk to your lawyer.
Yeah. Thank you, Your Honor.
I'm so sorry, Your Honor. What was the bond for count 2? I didn't hear that.
Oh, goodness, I don't, Madam Clerk, what was the bond I just did? 150.
Okay, thank you.
Thank you, ma'am.
No problem.
What's your name? I can't hear you.
Okay.
You're charged with carrying a concealed firearm. Count 1, $2,500 bond. Count 2, possession of methamphetamine, bond set at $150. Thank you, sir. What's your name, please?
Benny Daniels.
Daniels, you got arrested on the charge of possession of cannabis under 20 grams, bond set at $250. Possession of cocaine, bond set at $500. And resisting an officer without violence, bond set at $500. You are?
Your Honor, in regards to his out-on bond cases, no information has been filed on either case. Will you be able to take no action?
I'm not inclined. He just was arrested back, it was in March, not March, September, so I'm gonna look at this. He has 2 cases. 2022 CF 006027. Fairly recent arrest, so no, I'm gonna revoke the bond on both counts, possession of cocaine and possession of cannabis, since it's similar to these. I'm gonna set a new bond in the amount of $1,000 and $1,000 on each count. He then has 2022 CF 010692. Possession of cocaine and possession of cannabis, revoke the bond, set a bond at $1,000 in each count. Thank you.
Yes, okay, so sorry. And in regards to, I'm so sorry, Your Honor, in regards to the possession of cannabis, that's, you said $1,000 and the possession of cocaine is 1,000 as well?
Yes.
And the resisting officer without violence is 1,000 as well? Okay,
Yes,
thank
ma'am.
you. You have bond. And all of them. Did you? And set a new bond.
What's your name, sir?
My name is Joseph George, Your Honor.
George, right?
Joseph George, yes, sir.
So you're charged with aggravated assault with a firearm. I'm gonna set bond in the amount of $2,500 with a special condition that you have no contact with the victim and possess no firearm, sir. Thank you.
Thank you, sir.
What's your name, sir? You're charged with possessing methamphetamine or MDMA, bond set at $1,000. You also will charged with being in park after hours, bond set at $250. Thank you, sir. What's your name, young man?
T. Gray.
Gray, you charged with grand theft, third degree of motor vehicle, bond set at $1,000.
Your Honor, Mr. Latique qualifies for PTR.
State.
Who? Who was it?
Mr. Gray, Latique Gray.
Oh, this one. I thought we were going back. All right. Given his criminal history, the state would oppose.
Your Honor, being that his last conviction was in 2021, I would ask for PTR.
What was that conviction for?
Let me double check.
11-17-21, possession of youth alone, ×2, and unlawful possession of personal ID.
I'm gonna leave the bond at $1,000. Whatever I said the bond was, it was 1,000, that's what I said, okay.
Your Honor, I removed the first appearance detainer for a FAD for this next person. It was the same case number he's in on today. So I took that out on the next.
You talking about the next person?
Yes, sir.
Okay. What's your name, sir?
Richard Herbert.
So you're charged with grand theft, third degree of motor vehicle. Is he qualified?
No, he does not, Your Honor.
Bond set at $1,000, sir. Thank you, sir. What's your name, sir?
DeAndre Holmes.
Mr. Holmes, you're arrested on charge of possession of cannabis greater than 20 grams. Bond set at $1,000. Trespassing the conveyance, bond set at $150.
He does qualify for PTR, Your Honor. Do you have any objections to him being released PTR?
Based on what I read, I'm gonna leave it at what it said.
Okay.
Thank you, sir.
Okay, thank you.
What's your name, sir?
Lorenzo Cornelius Madison.
So you're charged with burglary of a dwelling. Bond is set at $5,000.
Your Honor, in regards to this case, I did have a PC challenge. I did not see how he's able to be charged with burglary of a dwelling because in the police report, they mentioned that he did not attempt to steal or strike the alleged victim. And for a burg dwelling, he had entry entry into a place to remain with the intent to commit a crime. And there, I did not see no intent to commit any crime, Your Honor. And he did allege to the officers that someone was chasing him with a weapon, Your Honor.
State.
Judge, that's an affirmative defense. I believe the entry into the home at 3 in the morning gives rise to certain inferences under the statute.
Well, I don't find probable cause for this case. Now give the state 24 hours to find probable cause. We can recall this case.
24 hours. Okay, so tomorrow.
What's your name, sir?
Kenneth McGill.
So you're charged with possession of cocaine, bond set at $1,000, possession of drug paraphernalia, bond set at $100, and you also had an open container, bond set at $250.
Didn't charge me with that, sir.
Well, that's the paperwork I got, sir. Unless I read it wrong. Yeah. Okay. What's your name, sir?
Anthony Richardson.
Mr. Richardson, count 1, you're charged with possession of controlled substance without a prescription, bond set at $1,000. Count 2, resisting officer without violence, bond set at $500. And grand theft, third degree of motor vehicle, bond set at $1,000. Thank you, sir.
Your Honor, Rivera Elizabeth, mental health.
Okay, so we can reset this one.
I don't mind waiving her appearance, Your Honor.
Okay, and bond we set at $1,000 on the drug charge, or well, on the MDMA charge, and then $500 on the possession of cannabis charge. What's your name, sir?
Smith.
Okay, so you're charged with offensive possession of methamphetamine, bond set at $1,000. It appears you were out on bond. In case of possession of methamphetamine and also possession of drug paraphernalia in case number CF 2022-007845. You were released ROR in that case. I'm gonna revoke the ROR as to the count 1, possession of methamphetamine within 1,000 feet of a place of worship or business. You set bond in the amount of $2,500. Possession of drug paraphernalia, bond set at $1,000. Thank you, sir. What's your name, sir? So you were picked up on a charge of destruction of evidence, bond set at $150. Possession of cocaine, bond set at $1,000. It appears you're out on a driving while license suspended charge on a bond in case number 2022 CT004095. I revoke that bond and set a new bond in the amount of $2,500.
Judge, I'm also here on a child support purge. What can you do about it?
I couldn't quite understand you.
On the child support purge.
Uh-huh.
I'm not.
So what are you telling me that for?
How much do I have to pay to get that child support purge?
Oh, I don't have no idea. I don't know anything about child support, sir. If it's a purge, you should get something in writing. I don't know.
Do you set a bond in regards to that case or no?
On the child support case?
No, I just say, I just on here. And
I said bonds on all these cases.
Okay.
It didn't say anything about no child support on these cases, did it?
I don't have any child support, Your Honor.
If it's a purge amount, it should have an amount that he has to do to purge out. But
Okay.
I don't see anything where I would arraign him on that.
Okay.
The out on bond was $1,000, Your Honor.
2,500. Mm-hmm. What's your name, sir?
Demond Thickpen.
Thickpen, you're charged with carrying a concealed firearm. Bond set at $4,000. Possession of a weapon by a convicted delinquent. Bond set at $5,000. Possession of a weapon or ammunition by a delinquent, bond set at $5,000.
He does.
Trying to see if I can get those reducted.
Doesn't meet PTR qualification.
Yeah, sorry. I was going to say that as well. He does qualify for PTR on all counts, Your Honor.
Yeah, but I'm not gonna put him on PTR release with these kind of charges. So I deny the request.
One moment, please, Your Honor.
Mm-hmm.
Your Honor, is it possible if you can cut the bonds in half? He's unable to pay the amount that was set.
Let me see these charges again. I deny the request.
Okay, Your Honor. One moment, please.
No one else qualifies for PTR. The rest.
What's your name, please?
Malashe Watson.
You're charged of first-degree murder with a firearm. Bond set at no bond. Count 2, robbery, bond set at $1,000.
Your Honor, in regards to this case, she has to fill out the application for indigency so we can represent her. Can she fill that out for 1 second, please, Your Honor? Okay. May I approach, Your Honor, to hand this to the clerk?
Yes, ma'am. I'll appoint the public defender's office representative.
Thank you, Your Honor.
What's your name, sir?
Javante Alcius.
Okay, I had Brendan Williams. Did that person bond out? Okay, thank you. So you picked up on a failure to appear. Bond is set at $150 in one case. Another second failure to appear, bond is set at $150 also. Thank you. What's your name, sir? Good to hear you.
Micah Brooks.
Brooks, you're charged with driving while license suspended or revoked. Bond set at $1,000.
Your Honor, we're asking if client can be released ROR in regards to this case.
State wish to be heard.
It does not appear that it was a financial suspension. It says that it's from reckless driving, DUIs, so we would oppose.
I don't see any history of failure to appear or any felonies, Your Honor.
I said bond at $500. What's your name, please? Picked up on a charge of possession of cannabis less than 20 grams. Bond is set at $500. I'm not going to, address the cases out on bond on this case. Thank you.
I apologize. One moment, please, Your Honor.
Mhm. Do you know which, is any particular judge this belongs to? I'm gonna take it. I need to use it for something. You tell them I took it. Tell them I take it to their ass. What's your name, please?
Rico Alo.
So you charge of trespass on property after warning, bond set at $500. Trespass on occupied structure, bond set at $500. Criminal mischief, bond set at $1,000. Thank you.
Yeah.
My wife needs something like that to step on because she can't use. What's your name, please?
Thigpen. Lauren Thigpen.
Charge of trespass on property after warning, bond set at $500.
Your Honor, I don't see any criminal history for her. Is it possible she could be released ROR?
State. Wish to be heard.
No objection.
Release RR.
Thank you.
What's your name, please? Charged with the, well, you got an out-of-county warrant, bond is set at no bond.
Sorry, who was that?
It's an out-of-county warrant. This is, Wallace, right? Yeah.
So Indian.
Okay, thank you.
Probably 24, 40 hours, it depends.
What's your name, please?
Robert Lucas Luciano.
So you have a charge of violation of probation, bond is no bond. A second charge of violation of probation, bond is no bond. Third charge of violation of probation, bond is no bond. And then you have a petty theft with 2 prior convictions, bond set at $1,000. Thank you, sir. I believe that's all we have. Okay.
Question. Roman Carroll. Oh, already, thank you so much.
I'm supposed to sign this here.
That was handled yesterday?
I know what it says. But it's funny, then they put my name, Judge.
Your Honor?
Yeah.
Your Honor, with the one you give 24 hours, is that gonna be, he's able to bond out, or is that a reset?
It's a reset.
Thank you.
Yeah.
Thank you.
Oh. No, I was gonna throw him at the door. Who's my judge?
State of Florida versus James Butler. Good morning, Mr. Butler.
Morning, how you doing?
I'm well, thanks for asking. Mr. Butler, you're here with us based on an allegation of trespass on property after warning. I'll appoint the Office of the Public Defender. I do find probable cause for your arrest. Unfortunately, you don't qualify for pretrial release, but I'll set bond the amount of $150.
Your Honor, I'm sorry. The state did convey an offer, they have to give you a pen, an offer of an adjudication of guilt credit time served in order to resolve the case today, as well as court costs. And Mr. Butler did want to accept that offer and enter a plea of no contest.
All right, looks like the last known conviction was way back in 2016.
Yes, Your Honor.
All right, thanks. Have you got some paperwork completed?
Yes, Your Honor, he's signing the plea form.
May we swear in Mr. Butler, please?
Yes, ma'am.
Mr. Butler, I've just been handed a piece of paper that indicates that you want to resolve your case by entering a plea of plea of no contest to the misdemeanor allegation of trespass on property after warning. That's a first-degree misdemeanor. Is that what you wish to do?
Yes, sir.
You understand you have a right to have a jury trial, and at the jury trial, the state would have to prove those allegations against you beyond and to the exclusion of every reasonable doubt. You'd have an attorney at the trial. You could have presented your own witnesses or a defense, could have testified or remained silent. You understand, and that trial would have been recorded. You could have appealed anything that happened during the trial. Do you understand you're giving up all of those trial rights? Because if I accept your plea of no contest this morning, I'm just going to impose the sentence that's been agreed upon. We're not going to be having a trial. You understand that? Anyone forcing you or pressuring you into making this decision?
No, sir.
Anybody make any promises other than what we just talked about?
That's all.
Under the influence of any alcohol, drugs, or mental issues that causes you difficulty making this decision?
No, sir.
Court accepts your plea of no contest, finds that you appear to be alert, intelligent. You've had access to Ms. George, albeit briefly this morning. And are you satisfied with her help?
Yes, sir.
She worked you out a pretty quick deal. Indicated to me no one has forced you or pressured you into making this decision. You do so of your own free will. You will be adjudicated guilty of the misdemeanor of trespass on property after warning. You're going to go to the court here in Orange County. I'm going to give you a period of 24 months, two whole years to make those payments. Make periodic payments when you can. You won't have an issue with them. If you don't make any payments and they can't find you, they could request to suspend your driving privileges. Do you understand?
Yes, sir.
You'll have 30 days from today's date to appeal this judgment and sentence. If you wish to do so, you must do it in writing. Can't afford an attorney, won't be appointed for you. You are going to be released today based on this resolution. You're not going to be allowed to go back to that to the hospital at 601 East Rollins. Do you understand?
Yes, sir.
Okay. All right. If you show back up there again, they're just going to arrest you and you're going to go right back in. So definitely don't do that. Good luck, Mr. Butler.
Thank you.
Okay. Thank you. Which case? When? Han Zhang. Right. Do we have an interpreter with us?
Yes,
Ooh, we can just barely hear you.
I apologize. Is it better now?
Yep, we can hear you a little better. We're maxed out on our end. If you could get as close to your microphone as you are able. If you'll please identify yourself for the record.
Sure. This is Yan, ID number 256266, Mandarin.
Madam Interpreter, if you'll please be sworn.
Sure.
Do you solemnly swear to translate from Mandarin to English, from English to Mandarin to the best of your ability?
I swear.
Thank you.
Thank you. The case is the State of Florida versus Han Zhang. The case number is 2022 MM7595. Mr. Zhang, good morning.
您好，张先生，案例号码2022 MM7595。
是的。
Yes.
Thank you. Mr. Zhang, your attorney, Mr. Brown, is present.
赞先生，您的律师 Brown 先生在场。
对。
Yes.
You were arrested based on an allegation of battery domestic violence.
您被捕原因是家暴打人。
是的。
Yes.
I find probable cause for your initial arrest.
根据您被捕的很可能的原因。
The court is going to set a monetary bond in the amount of $1,000 plus some conditions.
法庭设置一个保释金1000块钱，而且有其他的条件。
See that we have a witness present.
现在我们有一位证人。
Ma'am, do you need the assistance of an interpreter?
Yes.
Madam Interpreter, we have a witness present. Could you assist us with her interpreting?
Sure. Yes.
Ma'am, would you please tell me your name?
请这位女士说出您的姓名。
Finalizing.
Ms. Tirigli, we are going to place you under oath.
现在请您发誓，
Can you raise your right hand, please?
请您举起右手。
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
在主的名义下，您是否发誓，今天您做的证词是真实的，而且全部是真实的？
是的。
Yes.
Ms. Tirigli, you are listed as the victim in this allegation.
第二个李女士，这次指控里边，您是受害者。
Have there been any past instances of domestic violence between you and Mr. Zhang?
您和张先生之间在以前有没有任何家暴情况、家暴的事件？
没有。
No.
Do you have a cell phone or a means of communication if you feared further acts of domestic violence?
如果今后还有任何的家暴情况发生的话，您是否有一个手机或者是其他的报告的手段？
有。
Yes.
Do you wish to have contact with Mr. Zhang?
您是否想和赞先生保持联系？
是的。
Yes.
Hostile contact.
您要求有联系，那么法庭同意所有的联系都不能够有任何暴力倾向。
了解。
I understand.
Do you live here in Florida or are you visiting?
您是在佛罗里达居住，还是说您到这里只是暂时停留？
暂时停留。
Visiting.
All right. When do you return home?
什么时候您会回到您的家？
下周三。
Wednesday next week.
All right. Are you flying?
您会坐飞机回去吗？
是的。
Yes.
You and Mr. Zhang live together when you return home?
您回到家里之后，您和张先生会住在一起吗？
不会。
No.
If the court allows contact, do you have any fear of having contact with Mr. Zhang?
如果法庭允许您和张先生接触联系的话，那么您对接触和张先生的接触联系有没有任何惧怕？
完全没有。
Absolutely no.
Mr. Brown, any questions of the witness?
Just one question.
现在Brown先生要问证人一个问题。
Judge Michael Brown, on behalf of the defendant. Ma'am, do you wish the prosecutor to go forward with this case?
请问这位女士，您是否想让监管人员继续处理这个案例？
不希望。
No.
Nothing further, Your Honor.
没有其他问题了。
Ms. Eugene, any questions for the witness?
No, Your Honor.
没有问题要问见证人。
Ms. Tirigli, I understand your wishes at this time. The state will make the decision as to whether they are bringing charges or not.
蔡日高丽女士，我知道现在您的想法是什么，然后现在我们决定是不是会提出指控。
The court finds probable cause and will set bond in the amount of $1,000 with the following conditions.
法庭作出以下
Mr.
保
Zhang,
释金金额1000块钱，而且有附加条件。
Mr. Zhang is to have no hostile contact with Ms. Tiragelli.
赞先生和 Terry Golly 女士接触的时候，不能有任何的暴力倾向。
了解。
I understand.
Any additional requested conditions of bond state?
No, Your Honor.
Judge,
保释金和条件成立。
Mr. Brown?
as you can see on the charging affidavit, his address is in New York, and based on her testimony, they're going to be returning on Wednesday to New York. May he be allowed to travel home to New York?
在证词事上，被告的地址是在纽约。那么，在下星期三，允许被告以飞机方式飞回自己的家。
I place no travel restrictions as a condition of a bond. That will be a discussion between he and his bondsman.
The interpreter apologizes. Can you repeat, sir?
Yes, there's no travel restrictions. If he posts the bond in its entirety, he will be permitted to return to New York while the case is pending.
Thank you. 在这个案例正在处理过程当中，没有对被告有任何的履行方面的限制。
If he engages a
交了保
bond,
释金之后，可以回到自己的纽约的家。Sorry, sir.
sorry about that. If he engages a bondsman, that will be a discussion between he and the bondsman.
如果需要联系保释金公司的话，那么被告和保释金公司做出协议。
Anything further, Mr. Brown?
No, Your Honor, may be excused.
Yes. Ms. Eugene, anything further?
Nothing
from the
further
state?
from the state. Thank you.
Thank you for your testimony, ma'am.
这位女士，多谢您的证词。
谢谢。
Thank you.
Madam Interpreter, thank you very much for your assistance.
Judge, stay safe.
是。
Thank you,
Thank
Judge.
you.
Tina Mitchell?
On behavior status, Your Honor.
Okay. I'll appoint the Office of the Public Defender to represent Ms. Mitchell. Ms. George?
And I will waive, Your Honor.
We'll accept the waiver. Ms. Mitchell is, I find probable cause for her trespass on property after warning bond set in the amount of $500. She may not return to the Claricona Resorts. State of Florida versus Jessica Altador.
My apologies, Your Honor. On the Vietnamese, or he's on the move up, or we're gonna stand down on?
Yeah, we'll have to. Altador, good morning. You're here, bless you. You're here on two separate cases, 2022 CF 12200 and 2022 CF 13124. I will appoint the Office of the Public Defender to represent your interests on both of those cases. As to 2022 CF 12200, Judge Jewett has already found probable cause for that allegation. The court in that case is going to set bond in the amount of $3,500 with the conditions that you have no contact with the alleged victim and that you not return to the scene where this is alleged to have occurred, which is the Western Willow Terrace address. As to the new allegation in 2022 CF 13124, court finds probable cause for that allegation. Bond will be set in the amount of $2,500 with the special condition that you have no contact with Mr. Dedrick Walker, and you will not be returning to that location, which appears to be
Your Honor, can
the
I also
Western Willow
ask,
Terrace.
I apologize. Your Honor, can I also ask for no weapons, no firearms?
Of course. As a condition of your bond, you're going to possess no weapons or firearms. The court will allow you to return one time to the Western Willow address to get some personal property. If that is necessary, you'll need to coordinate that with law enforcement, who will accompany you. Thank you. Okay. Okay. We've got one more interpreter case, and then Mr. Gigliotti, I'll take your case next. Thank you for your patience. We know who Mr. Gigliotti is. Mr. Gigliotti, will you come up and let the clerks know who your client is?
Yes.
So we can get them sequenced in. All right. Do we have an interpreter with us? Do we have an interpreter with us?
The Vietnamese interpreter on the line, Your Honor.
Good morning. If you will please follow the directions of the clerk and be sworn.
Can you raise your right
Yes,
hand,
Your
please?
Honor. Yes.
Do you solemnly swear to translate from Vietnamese to English, from English to Vietnamese to the best of your ability?
Yes, I do, Your Honor.
Please state your name for the record.
Nghe.
Thank you.
You're welcome.
All right. Good morning, Mr. Nguyen.
Yes, sir.
Chào buổi sáng ông Nguyễn.
Dạ, chào bà chị.
Hello.
Dạ, chào bà chị.
Hello, Your Honor.
Mr. Nguyen, you were arrested based on an allegation of trespass on a property after you were warned not to.
Ông Nguyễn, ông bị bắt giữ là do vấn đề vi phạm vào trong cái khu vực đó mà ông cấm không được vào trong cái khu vực đó.
Không phải. No, không phải. Tại vì nó rây trệt em, nó cứ gọi police hoài, nó nói là tất cả Florida 20 triệu người rây trệt em và ăn cắp của em chén cơm mỗi ngày, nguyên cái Florida rây trệt em, ăn cắp chén cơm của em mỗi ngày, ăn cắp từng hộp cơm của em mỗi ngày, tất cả người Florida bao vây em mỗi ngày để ăn cắp từng hộp cơm của em, không cho em ăn cơm.
Could you, so loud. Can you please advise the client that today's purpose is only for setting bond, that I would advise him not to speak about the facts of the case?
Hôm nay cái mục đích của cuộc điều trần hôm nay là chỉ nói về vấn đề tiền bảo lãnh. Do đó xin vui lòng đừng nói bất kỳ những sự kiện nào về hồ sơ.
Nếu mà chị nói về hồ sơ, em sẽ go outside, give big trouble for United States. I give United States big trouble. But I'm go home right now. But you say that. When I go home, I give United States big trouble. But you say that. I don't care who you are. Just you. I give you just big trouble. But I'm go home. But you say that.
Madam Interpreter, can you interpret for me?
But you say that. Just big trouble.
Your Honor, he
I don't care what
said
you say.
in
When I go home, you big trouble. The whole United big trouble for one hour. I'm go home.
he said it in English, so I
don't care
will
what you say.
try to repeat it.
Gotcha.
If I go outside, you will make a big trouble an hour later. If I go outside.
Yep. I come back to the jail. Yes, I do. I say yes. I go back to the jail. Yes, I do. I go back home, come back for 1 hour.
That idea.
Go back to the jail and then come see him again.
Okay. I'm going to
Thank you.
Hold on. You're entitled to a bond. You don't have to post it if you don't wish to. I will set a bond in the amount of $500.
cái tiền bảo lãnh của ông nếu như ông không muốn, nhưng tiền bảo lãnh của ông là 500 đô.
I don't care. 5,000, I don't care. Million, I don't care.
I'll appoint the Office of the Public Defender to represent Mr. Nguyen's interests.
5 million, I don't care.
No return?
Tôi sẽ chỉ định một luật sư của chính phủ để bảo vệ cho ông.
Okay, okay, no problem.
And he's not to return to the scene where this is alleged to have occurred.
Và ông không được quay trở lại cùng cái địa chỉ đó.
Em sẽ
Rồi,
quay
em
lại
ra.
ngay bữa nay luôn. I come back today. I come back. I turn around, come back today. And I'm going to come see him today again too. Okay, come on.
Thanks, Mr. Nguyen.
Okay, thank you.
Madam Interpreter, thank you for your help.
You're welcome, Your Honor, and thank you for using our service. Have a good day, Your Honor. Goodbye.
State of Florida versus Nicholas Isernia.
Morning, Your Honor.
Good morning.
Jim Gelati for Mr. Isernia.
Mr. Gelati, good morning. Mr. Isernia is here with us based on an allegation of battery, domestic violence related by strangulation, obstructing justice, intimidate, threaten a witness informant, and battery domestic violence related. It appears that Judge, can't read the signature, well, I know that one of my colleagues found probable cause for counts 1, 2, and 3. That may have been Judge Whitehead when he was covering a division. The allegations contemplate a bond in count 2 in the amount of $1,000, a bond in count 3 in the amount of $1,000. And the court will be considering conditions of bond as to count 1. I note that we have a witness present.
Yes, Your Honor.
Mr. Gelati, do you wish to present some witness testimony, or?
Yes, Your Honor, if I may.
All right, thank you. Ma'am, we're going to place you under oath.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, to help you God?
Yes.
Thank you. Please state your name for the record.
Amy Watson.
Ms. Watson, are you in fear of Mr. Isernia at this time?
No.
Would you like him to be able to come back to the marital home and have non-hostile contact with you?
Yes.
Thank you. Your Honor, I have no further questions of her.
Thank you. I've got some additional questions. Have there been any past allegations of domestic violence?
In the past, yes.
Okay, was that here in Florida?
Yes.
All right, thank you. Were those prosecuted through the criminal justice system?
No.
Do you have a means of communication such as a cell phone or a home phone that you could call law enforcement if you were concerned of further acts of domestic violence?
Yes.
Are there any children in the home?
3.
All right. How old are the children?
11, 10, and 6.
All right, thank you. Were drugs or alcohol a component of these allegations?
Alcohol, yes.
The most contact or the most protection that the court is able to afford at this point in the proceedings would be an order of no contact. The court, based on your responses, is going to interpret that you are requesting to have some contact, and the court would order that as non-hostile contact. You understand that you guys would be on the honor system, and that is a lesser amount of protection than the court's able to afford. I'm not in a position to second-guess your desire to have contact and have him return to the family home. I'm going to allow the state of Florida to ask any follow-up questions if they find that to be necessary.
I don't have any questions, Your Honor, but there have been at least 6 other instances of domestic violence with the same victim going back to 2011. I understand that the witness has testified that she would like to have contact, but just based on the number of prior incidences, and as she said, none of them have been prosecuted, At this time, I would ask for no contact. If for no other reason, then there be a cooling off period, Your Honor.
Last word, Mr. Jelani.
Your Honor, I would say that him sitting in jail has been sufficient cooling off. I do respect the state's position, but those cases ended up the way they did for a reason. I would just ask the court to consider Ms. Watson's testimony and allow non-hostile contact.
Just a moment. Court's going to require that Mr. Iserna and the alleged victim in this case maintain separate warrant residences while this case is pending. The court will allow non-hostile contact between the two for ease of coordinating visitation. The court will allow Mr. Iserna to return to the family home one time with law enforcement to get some personal property while this case is being sorted out. Mr. Iserna, no hostile contact means exactly what it sounds like. You may not have any screaming matches. You're not to put your hands on your wife without her permission. You may not cohabitate, and you are to maintain separate residences at this point. And as I said, you may return one time with law enforcement to get some personal property as the case is pending. Do you understand those conditions of bond?
Yes, sir.
All right. Thank you.
Your Honor, what is the bond on count one?
Count one is going to be set in, see qualify. I don't have a face sheet on this one. Do we know if he'll qualify for pretrial release?
He qualified, yeah.
He does? Court's going to set bond in count one in the amount of $500 as to counts 2 and 3 in the amount of $250. Those conditions will be as a condition of pretrial release. So bond plus pretrial release. Thank you.
Thank you, Your Honor.
Gerardo Betancourt. Good morning, Mr. Betancourt.
Morning.
Mr. Betancourt, you are here with us based on an allegation of battery on a person 65 years of age or older. Do you find probable cause for your initial arrest? I will appoint the Office of the Public Defender to represent your interest.
And,
Bond is-
Your Honor, he does qualify for pretrial release. In addition, I would ask for pretrial release and a one-time return with law enforcement as it appears they reside together.
Court will release Mr. Betancourt on pretrial release with the special condition that he have no contact whatsoever with the alleged victim in this case. That's Estrella Gerald. Will not be allowed to return to the location where this is alleged to have occurred at Dunstable Circle. He will possess no weapons or firearms. He may return one time with law enforcement to get some personal property while this case is pending.
Your Honor, can I also ask for no drugs, no alcohol?
Mr. Betancourt is to consume or nor possess any alcohol or drugs as a condition of pretrial release. Straight PTR. Thanks. State of Florida versus. Ms. Glover, you are here based on an allegation of aggravated assault with a weapon, with a deadly weapon, without intent to kill. I do have read the charging affidavit. I do find probable cause for your initial arrest and will appoint the Office of the Public Defender to represent your interests. Court is going to set bond in the amount of $3,500 with the special condition that you are not to have contact with the listed victims, which are multiple. State, do we have a list of the victims alleged in the charging affidavit?
No, Your Honor.
Yeah.
It's incredibly poor writing. Your Honor, there also appears to be a co-defendant who was also arrested.
Right.
I don't know if you want to make it a condition that she also not have contact with a co-defendant. The co-defendant is Wayne Jones.
Mr. Jones was arrested in a separate incident, a separate case, same incident. The court is going to order no contact with victims 1, 2, and 3. Ms. Glover will not be allowed to return to the Crawford Drive address.
And Your Honor, I would ask that she be allowed to return I believe the only victims that.
My children.
They took her children.
And placed them with my aunt.
And they placed them with her aunt. So no one else lives in the house but her. So I would ask that she be allowed to return to the home.
Your Honor, the way we usually handle that is to ask for separate residence. Therefore, if the victims are still there, she cannot reside. If they are not, then it's not an issue.
Okay. All right, so there will be no contact with victims 1, 2, and 3. She shall maintain separate residences from victims 1, 2, and 3, and the co-defendant. She'll have no contact with the co-defendant, Mr. Jones.
Your Honor, the only other thing is DCF was notified if she could comply with any DCF plan.
Ms. Glover is to comply with any DCF investigation, and I'll appoint the Office of the Public Defender to represent her.
I apologize. No weapons, no firearms.
So ordered. State of Florida versus Selena McCree. Ms. McCree, good morning. You're here with us based on an allegation of aggravated battery with a weapon that is alleged to be dating related. I have taken a look at the charging affidavit. I do find probable cause for the allegation. Your bond is going to be set in the amount of $3,500 with the special condition that you have no contact whatsoever with the alleged victim, Conrad Davison Jr. You're not going to be allowed to return to the 5 Flags Boulevard address. I'll allow you to return one time with law enforcement to get some personal property if you have personal property there while the case is pending, and I will appoint the Office of the Public Defender. Thanks. State of Florida versus Francis Samedi. Good morning.
Okay. Good morning.
Mr. Samedi, you are here with us based on an allegation of aggravated battery upon a pregnant person. I have read the charging affidavit, and I do find probable cause for that. Candelario, I have found probable cause for the initial arrest. I will be considering conditions of bond, including contact with you, and if you live together, what your thoughts are as to continuing to cohabitate. Have there been past instances of domestic violence in the past?
No.
Actually, I actually wanted to come here and say that this was a false accusation over the phone. He never put his hands on me. There was never any type of domestic violence. I tried telling the police officer that, but the police officer, insisted that he needs to obey by the phone call, and still arrested him. But he never put his hands on me, not once. This was over on the phone. I had someone actually decided to call and lie and said that he smacked me, and that's something that never happened.
Understood. Taking the allegations in the charging affidavit as true, which I must at this point, I have found probable cause. Your wishes and thoughts will be considered by the state, but ultimately it will be their decision as to whether they choose to bring criminal charges or not. Do you have a means of communication such as a cell phone if you were concerned about further acts of an unwanted touching?
Yes, I have a phone.
Right, thank you. Do you have any fear if the court considered allowing contact between you and Mr. Samedi?
No.
Do you have any fear for your minor children if Mr. Samedi returned to the family home?
No.
Ms. Eugene, any questions of our witness?
No, Your Honor, I'm just standing up for comfort.
Gotcha. Ms. George?
No questions, Your Honor.
Hold on just a second. Ms. Eugene, is there a history, do you see any prior criminal history?
Oh, criminal history, yes, Your Honor. Other acts of domestic violence, no. The only conviction I see are for traffic offenses, Your Honor.
All right. I note the allegation on the affidavit is an unwanted striking her on her cheek with his finger.
No.
He's going to set a bond in this case in the amount of $1,000. Ms. Samedi, you're in the best possible position to recommend to the court whether you wish to have, I'm sorry, Ms. Candelario, you're in the best possible position to recommend to the court whether you wish to have contact or not. I am going to allow no hostile contact between you two. I will allow Mr. Samedi to return to the Cimarron Boulevard address should he and you choose to go that route.
Your Honor?
Yes.
Does he qualify for PTR? Because he didn't do anything. He's actually in jail innocent over a phone call that someone lied upon.
He does not. And I don't know why that is.
Due to the charge, Your Honor.
Yep, it's the type of charge, and your current situation makes this a felony allegation, and he does not qualify for PTR. So it's going to be as bondable and under those conditions. Mr. Samedi, you understand you cannot have any hostile contact with Ms. Candelario. That means no putting your hands on her without her permission, no verbal arguments, no threats in person or through social media. All right, good luck to you guys.
Thank you.
Mr. Bennett?
Yes.
Good morning.
Good morning to you, too.
Mr. Bennett, you are here with us based on an allegation of obstructing justice, tampering with a witness, and battery domestic violence related. I have taken a look at the affidavit, and I do find probable cause for that initial arrest. So I could qualify for pretrial release. I am going to release you on straight pretrial release with the special conditions that you not have contact with Judith Bennett. You're not going to be able to go back to the Concord Street apartment while this case is getting pending, so no return. I will allow you to return one time with law enforcement, get some personal property while this case is pending, and appoint the Office of the Public Defender to represent your interests. Do you understand those conditions of pretrial release?
Yes, I do.
Thank you. PTR. Mr. Lewis?
Yes. Yes, sir.
Good afternoon.
Good afternoon, sir.
Mr. Lewis, you were here with us based on an allegation of battery domestic violence related. I have read the charging affidavit. I do find probable cause for your initial arrest. Court's going to appoint the Office of the Public Defender. Court's going to set a bond in the amount of $1,000 plus the following conditions. You are not to have any contact with the alleged victim in this case.
I have a question.
Yeah, I'll answer your question in just a minute. Let me get through the rest of the conditions. So no contact with Demetria Jones for the moment. You're not going to be able to return to the Lee Road address. I will appoint the Office of the Public Defender to represent your interests. Now that I've appointed an attorney, it's probably good to run that question through your attorney first.
Your Honor, my client is stating that the alleged victim does not live there, that she's only been staying for a week. As I explained the fact that you only have control over him, which is what the no contact order in place is for him, that we can't force the victim to move out. I don't know how to confirm.
I don't know. I don't either. He doesn't qualify for pretrial release, or I'd have them verify.
Your Honor,
You have it?
we can just do maintain separate residence with a one-time return. When he returns with law enforcement, if she's not there, then he can stay.
All right, Mr. Lewis, the court's going to amend the conditions of your bond to you are to maintain separate residences from Ms. Jones. I'll allow you to return one time with law enforcement, get some personal property. If Ms. Jones hasn't vacated, I can't kick her out. So if she's there, you can't be there. Do you understand?
I do, Your Honor.
All right.
She doesn't live there.
Okay, she's gone, then I don't have a problem with you being there. But if she's there under that roof, you cannot cohabitate together. And there's not much I can't fix that situation. So there's a process to evict somebody, I suppose, but that's going to be the conditions of your bond. Good luck. State of Florida versus Yvette Martinez. Ms. Martinez, good afternoon.
Hello.
Ms. Martinez, you are here based on an allegation of battery, domestic violence related.
Your Honor, it looks like she qualifies for pretrial release. I would ask for pretrial release in this case.
I'm going to agree with that recommendation, release Ms. Martinez on pretrial release with the following conditions. I know this is a family member. Has PTR had any contact with the alleged victim? No, Your Honor. At this point,
Yes, they do reside together, Your Honor.
okay. Time being, without any input from the alleged victim, it's going to be no return to the Lake Orlando Parkway address. Allow her to return one time with law enforcement, get some personal property while this case is getting worked out, and the trial judge can revisit that decision if necessary.
Thank you.
Thanks.
Got it. It's okay. Get some stuff with law enforcement. You gotta call the police.
State of Florida versus Leanne Minshew. Ms. Minshew, good afternoon. Ms. Minshew, you are here based on an allegation of battery domestic violence related for the issue with your sister. I have read the charging affidavit. I do find probable cause for your initial arrest. You qualify for pretrial release. You are going to be released on the pretrial release program. I will appoint the Office of the Public Defender. I'm going to consider conditions of your pretrial release. I note that we have a witness present. Ma'am, your name, please?
Deborah Clark.
Ms. Clark, if you would please raise your right hand and follow the clerk's instructions.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record. I'm sorry.
That's right. If you'll, now that you're under oath, if you'll give us your name one more time.
Deborah Clark.
Thanks, Ms. Clark.
You're welcome.
All right, you are listed as the victim in the case. Do you and your sister reside together?
No.
All right, thank you. Do you wish to have contact with your sister, Ms. Minshew?
Yes.
Have there been any acts of domestic violence in the past?
No.
You have a means of communication to contact law enforcement if you fear further acts of domestic violence?
I do.
Any follow-up questions, Ms. George?
No, Your Honor.
Any follow-up questions?
No, Your Honor.
Ms. Minshew, the court is going to release you to the pretrial release program. The court will allow you to have non-hostile contact with your sister. That means exactly what it sounds like. No putting your hands on her, no loud arguments, no threats in person or through social media. Do you understand?
Yes, sir.
The court is going to order that you not possess or consume any illegal substances as a condition of your pretrial release. Ms. Clark, was alcohol a factor in this allegation?
No, sir.
What's that?
No, sir.
No, got it. All right. Thanks. Any other requested conditions?
No, Your Honor.
All right, thank you. The pretrial release folks will be talking to you soon.
Thank you.
Yes,
Thank
ma'am.
you.
Mr. Babatunde?
Sir.
Did I get close?
Babatunde, yeah.
Yes. Mr. Babatunde, you have two matters with us. The first is an allegation of like battery domestic violence related. I have read the charging affidavit and I do find probable cause for that arrest. Bond is going to be set in the amount of $1,000 with the special condition that you have no contact with.
I already have one. Do you want me to show
Hold on just a sec. Let me get through it and then I'll appoint the Office of the Public Defender and then I'll give you a minute to talk with them.
What did you say?
Said I'm gonna discuss some conditions of bond. I'll appoint the Office of the Public Defender. Then if you have a concern, you can let Ms. George know.
As well?
All right, so I understand that the
Sister?
alleged victim is a family member. That would, I don't know if the victim is identified. The victim is not identified by name, but it's a sibling of Mr. Babatunde, so I suspect that he knows who that is. He's to have no contact with the alleged victim. He's not going to be allowed to go back to the Martin Ridge Loop address while this case is pending. I'll allow him to return one time with law enforcement to get some personal property while the case is pending. He's also out on another case. Unfortunately, that is a similar type offense. That is in 2022 MM 465. I'm going to revoke bond on that case, and currently bond will be set in the amount of none. I'll appoint the Office of the Public Defender on both cases. Thank you. State of Florida versus William Weege.
Yes, sir.
Is it pronounced Weege?
Weggy.
Weggy? My apologies. Good afternoon. Mr. Weggy, you are here with us based on an allegation of battery domestic violence related. I do find probable cause for your initial arrest. We'll appoint the Office of the Public Defender to represent your interests. Court is going to set a bond in the amount of $500 plus pretrial release conditions. Those conditions being that you have no contact with Hannah Wege. You're not going to be allowed to return to the Hatherton Circle address except for one time with law enforcement to get some personal property while this case is pending.
Your Honor, can I also ask for no drugs, no alcohol?
Court is going to order that you possess nor consume any drugs or alcohol as a condition of your pretrial release. Good luck.
Okay, I'm sorry, Your Honor, and that was 500 plus PTR? Is what you said?
Yes.
Yeah, I did. Let's, does he qualify for straight pre-TR?
He does, yeah.
Your Honor, I would just ask for a bond. He does, he works for Spirit Airlines, so he's gonna be traveling a lot for work. I just ask that you just set a bond, as opposed to him having to check in with pretrial monthly due to his, employment, and he has no history.
Court will set a $1,000 bond plus the conditions of no contact, no return, except for one time with law enforcement, get some personal property.
Your Honor,
drugs
DCF
or
was
alcohol. Sorry?
DCF was also notified of this incident. If he could comply with any DCF plan. If you look about 3 lines up from the bottom, it says DCF will be conducting a follow-up investigation.
Defendants to comply with any DCF investigation as a condition of bond. Thank you. Fifth floor violence related. Another judge has already found probable cause for that allegation. That would be Judge Jewett. I have read the affidavit, and we'll be setting bond in that case in the amount of $1,000 plus these special conditions that you not have any contact whatsoever with the alleged victim, April Warren. You won't be able to go to the Botany Court address except for one time with law enforcement to get some personal property. At the time of your interaction on that warrant, you picked up a new allegation that is an allegation of resisting an officer without violence. I do find probable cause of that allegation. Your bond in that case is set in the amount of $1,000. I'll appoint the Office of the Public Defender on both cases.
How much?
Hold on just a sec, there may be an additional condition.
200.
The condition contemplated by Judge Jewett was possess no weapons or firearms and follow any DCF plan, if any. Those will be added as conditions of your bond. Thank you, Madam Clerk. Is it pronounced Arce or Arce? Arce. Mr. Arce, you are here with us based on an allegation of possessing fentanyl. I do find probable cause. Bond in that case is going to be set in the amount of $1,000, and the Office of the Public Defender is appointed. State of Florida versus Robert Blackwood. Mr. Blackwood.
Your Honor?
Yes.
I'm not on the same page. Which cases are you hearing now?
Felony section.
Just straight felony? Thank you.
Mr. Blackwood, you have two issues with us. The first is 2022 CF 13116. That is the new law offense alleging a possession of fentanyl, possession of cocaine, possession of drug paraphernalia. I do find probable cause for those allegations. Bond in count 1 is going to be set in the amount of $1,000, count 2 in the amount of $1,000, and count 3 in the amount of $500. I'll appoint the Office of the Public Defender to represent your interest on that case. There's also a pending warrant. Judge Lattimore has already found probable cause in it's agency case number 2022-60405. That is an allegation of grand theft, third degree, and criminal mischief. Bonding count 1 set in the amount of $1,000, and bonding count 2 set in the amount of $500, for a total bond amount of $1,500. Unfortunately, you were out on pretrial diversion on 2021 CF 9034. State, any requests regarding the diversion case?
Generally not, Your Honor. When they are in pretrial diversion, I leave it up to that program as to what it is that they do with the defendant.
Court will take no action as to your diversion case. So you are bondable currently. State of Florida versus Jaden Johnson. Mr. Johnson, good afternoon. You are here with us based on a warrant. Judge Lattimore found probable cause for carjacking with a firearm. That carries no bond. You're going to remain on no bond, and I will appoint the Office of the Public Defender to represent your interests. If bond is considered in the future, it will come with no contact with the victim, no possession of firearms or weapons. Thanks. State of Florida versus Wayne Jones.
Morning.
Afternoon now, Mr. Jones, believe it or not. Mr. Jones, good afternoon to you as well. You are here based on an allegation of aggravated assault with a deadly weapon without the intent to kill. I have read the charging affidavit along with your co-defendant. Do you find probable cause for your initial arrest? I will appoint the Office of the Public Defender to represent your interests. The victims are identified as victims 1, 2, and 3. You're not going to have any contact with them. You're also not going to have any contact with the co-defendant in this case, and I forget her name. Give me just a minute.
Nicole Glover.
Thank you. While this case is pending, you're not having any contact with Nicole Glover. You're also not going to be able to return to the Crawford Drive address. I will appoint the Office of the Public Defender if I didn't previously announce that. Thanks.
Your Honor, I apologize. I missed the bond amount.
I did. Here one.
That's because I didn't announce it. Bond is set. What did we do on Ms. Jones's case? All right, Mr. Jones will get a bond in the amount of $3,500 as to the new law offense. Does Mr. Jones have a VOP?
On view VOP.
Mr. Jones, unfortunately, you're on probation. The court's going to find an on-view violation of that probation. The case number is 2014 CF 6351. Based on the allegations, you qualify as a violent felony offender of special concern based on the new law offense. So you're not entitled to bond. You're going to stay on no bond while the new case is getting sorted out. And I'll appoint the Office of the Public Defender on your VOP case as well. Thanks. State of Florida versus Javante Joseph. Mr. Joseph, good afternoon. You're here based on a warrant arrest. Judge Barber has already found probable cause for aggravated battery with a motor vehicle, leaving the scene of an accident and leaving the scene of a crash with injuries. She has assigned bonds in each of those counts. Bond in count 1 set in the amount of $15,000. Bond in count 2 set in the amount of $15,000. Bond in count 3 set in the amount of $15,000. For a total bond amount of $45,000, with the special condition that you not return to the scene, have no contact with victims or state witnesses, and I'll appoint the Office of the Public Defender to represent your interests. Thanks. State of Florida versus Christopher Lewis.
Your Honor, Christopher Lewis is currently on mental health status.
Okay. I assume he's been seen on the other charges, and this is an add-on charge for damaging the patrol car. There was a laundry list of things that he was arrested for.
Yes, Your Honor, and if you'll point, I will waive the appearance.
Court's going to appoint the Office of the Public Defender on Mr. Lewis's case. Find probable cause for the new allegation of criminal mischief for damaging the patrol car. Set bond the amount of $1,500. State of Florida versus Omar Mesqueda. Good afternoon, sir.
How you doing?
Sir, you are here based on a warrant for failing to appear. That was a allegation that you failed to appear for pretrial on October 12th, 2022. Based on that information, Division 20 issued a warrant for your arrest. It does come with a bond. That bond's in the amount of $5,000, and I'll appoint the Office of the Public Defender to represent your interests. Thanks. Good afternoon, Mr. Palmer. Mr. Palmer, you are here based on a warrant arrest. Judge Whitehead looks like found probable cause for 5 counts. Count 1 was the allegation of burglary of an unoccupied conveyance. Count 2 was an allegation of grand theft. Count 3 was an allegation of criminal mischief over $200 under $1,000. Count 4 was an allegation of dealing in stolen property. And count 5 was an allegation of fraud for something alleged to have happened back on June 28th and 29th of 2022. Whitehead assigned bonds in each count. As count 1, bond is set in the amount of $2,500. Bond in count 2 is set in the amount of $1,000. Count 3, $1,000. Count 4, $2,500. Count 5, $2,500 for a total bond amount in the amount of $9,500. And the Office of the Public Defender is appointed on your case. There was also a new allegation at the time of your arrest. Looks like that was case number 2022 CF 13117, and it alleged 2 counts: possession of methamphetamine, possession of cannabis. I find probable cause for those allegations. Bond in count 1 of that case is set in the amount of $1,000, and count 2 in the amount of $500. Office of the Public Defender is appointed on that one as well. Thanks. State of Florida versus Jeffrey Sheffield.
I gave you the paper, call the number.
Sheffield, good afternoon. You were arrested based on an allegation of possessing cocaine and trespass on property after warning. I have read the charging affidavit. That case number is 2022 CF 13122. Bond in count 1 set in the amount of $1,000, and bond in count 2 is set in the amount of $250.
Your Honor, my client is out on bond
See that?
in 2022 CF 8566 AO. However, he was arrested July 23rd of this year, and no information has been filed to date, so I'd ask that you take no action.
That is correct, Your Honor. Formal charges have not been filed.
Okay. That's an exceedingly long time to be without an information being filed. I'm going to follow the suggestion of the defense and not take an action on the old case. That was 2022 CF 8566. I'm not sure that case is viable. I'll appoint the Office of the Public Defender on the new case. Thanks. Possession, trespass on property after warning. 250. Thanks. Mr. Smith.
Your Honor, due to jail weather restrictions, inmate Smith was unable to be transported from an out-of-facility.
All right. Mr. George, I'd be willing to appoint the Office of the Public Defender and accept a waiver if that's your decision.
Yes, Your Honor.
Mr. Smith has two cases with us. One is 2022 CF 13108. One is 2022 CF 13109. I know Mr. Smith is not present due to no fault of his own. Court's going to find probable cause on each of the three counts and each of the cases. Bond in count 1 as to 13108 will be set in the amount of $3,500. Count 2 in the amount of $150. Count 3 in the amount of $150. And counts 1, 2, and 3 in 2022 CF 13109. Bonds will be stayed in the amounts of $3,500 as count 1, $150 as count 2, and $150 as to count 3.
Your Honor, I ask defendant be not allowed to return to any Cube Smart.
So ordered. Defendant may not return to any Cube Smart business. Mr. Williams? State of Florida versus Benjamin Williams. Good afternoon, Mr. Williams.
Good afternoon, sir.
Mr. Williams, you're here with us based on two misdemeanor allegations, the first being resisting an officer without violence, and the second is failure to provide an ID. Taking the facts in the affidavit as true, which I must at this point, I find probable cause, I'm going to lower your bonds in both counts. Bond in count 1 is going to be set in the amount of $150. Bond in count 2 is going to be set in the amount of $150. And I will appoint the Office of the Public Defender to represent your interest. Thanks. State of Florida versus Roman Carroll. Good afternoon, Mr. Carroll. Mr. Carroll, you're here with us based on an allegation that you failed to appear for trial back on October 24th in Division 82. Based on that, they issued a warrant for your arrest. They did set a bond in your case, and that's set in the amount of $1,000. And I'll appoint the Office of the Public Defender on your case if not previously appointed. Thanks. State of Florida versus John Watson. Mr. Watson, good afternoon.
And there is, Your Honor, an offer to resolve Mr. Watson's case.
Let me take a look at Mr. Watson's.
The offer would be an adjudication credit time served and no return to 7506 Alamo Avenue, as well as court costs. And if you'd like to accept it as a plea of no contest, Your Honor.
Okay. Officer, he's got something going on in Seminole County. Do we know what that is?
Looks like an open container.
County ordinance violation. All right, has Mr. Watson done his paperwork?
No, Your Honor, due to the hurricane, we didn't have anyone. I'm the only one that appeared. Our, social worker did not come because of the weather conditions.
Gotcha. You
But
said he
usually-
wishes to resolve his case?
Yes, Your Honor.
Yeah, did he do that paperwork?
Oh, oh, okay.
Thanks. Got it. Mr. Watson, we're going to place you under oath.
Raise your right hand, please. Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God? You have to answer out loud. Thank you.
Yeah, Mr. Watson, you're kind of soft-spoken. I'm going to need to hear you, and because we're recording your responses, so if you'll get nice and close to that microphone. I've been handed a document. The document looks like this. It has a signature on it. Did you have a chance to sign this document?
No, I don't believe so.
By pleading no contest to the allegations against you. Is that what you want to do?
Yeah.
The allegations are trespass on property after warning and resisting an officer without violence. You've got a right to have a jury trial as to those allegations. At the jury trial, the state would provide you with an attorney. They would take a look at the evidence, confront the witnesses. You could have presented your own witnesses and evidence. You could have testified at your trial or remained silent. You could have had your trial recorded and appealed any error in the trial. You understand you're giving up your trial rights because if I accept your plea of no contest, I'm just going to impose this sentence right now and we're not going to be having a trial. You understand that?
Yes.
Has anyone forced you or pressured you into making this decision?
No.
Anybody make any promises other than what we just talked about?
Didn't hear anything.
No?
No.
Under the influence of any alcohol or drugs that are causing you difficulty understanding the process? Taking any medications?
Yeah, I take allergy pills and something from else.
Okay. Is that affecting the way that you're thinking here this afternoon?
No, just tired.
Based on our discussions, I find that you appear to be alert and intelligent. You've had an opportunity to think about this decision and discuss things briefly with one of our attorneys. Are you happy with the attorney's services? Are you happy with your attorney's services?
Yes. Yes.
Seems like she worked quick for you. You've indicated to me no one's forced you or pressured you into making this decision, and you do so of your own free will. I'll adjudicate you guilty of trespass on property after warning and resisting an officer without violence. You're going to be sentenced to the time that you have already served. You're going to agree not to return to 7506 Aloma Avenue. There's a trespass warning waiting for you, so if you go back there, they're going to arrest you again. Do you understand?
Yes.
You're going to owe some court costs. I think that's $273. So you owe $273 in court costs. I'm going to give you 2 full years, 24 months to make payments to the clerk of the court collection program over in Orange County Clerk. As long as you send them a couple bucks every once in a while, that you won't have an issue with them. If you don't pay and they can't find you, they could request to suspend your driving privileges. Do you understand?
Yes.
You have 30 days from today's date to appeal the judgment and sentence. If you wish to do so, you must do it in writing. Can't afford an attorney, won't be appointed for you. Your sentence will run concurrently, meaning at the same time as to both of your cases, both of your counts. Should be released today, Mr. Watson. Don't go back to Aloma Avenue. Good luck. Sean Hamilton? Good afternoon, Mr. Hamilton. Mr. Hamilton, you have a on-view violation of probation. I took a look at the affidavit, and I do find probable cause for your initial arrest. Based on your designation, you're going to stay with us on no bond, and I will appoint the Office of the Public Defender to represent you, and they can get you in front of the trial judge and see if this can get sorted out. Thanks. Mr. Heintzman?
Johnny Huntsman is currently on medical status.
Okay. This is a no bond VOCC. Do you want to waive or would you like a reset?
No, Your Honor, I will waive.
Appoint the Office of the Public Defender to represent Mr. Heitzman. He has a he has a warrant for violation of community control by Judge Wilson that has no bond. He's going to remain on no bond. Thanks. State of Florida versus Mr. Hill. You, Mr. Hill? Thanks,
Your
Mr.
Honor, I apologize. Do you only have one violation of community control for
Sorry
Mr.
about
Heitzman?
that. Going too fast. Mr. Heitzman also had a second case. He failed to report and a violation of condition D, that you changed residence without letting your probation officer know. Based on that information, Judge Wooten issued a warrant for your arrest. I'll appoint the Office of the Public Defender to represent you. Judge Wooten issued no bond. You'll remain on no bond till you can get in front of him, let him know what's going on. Thanks. State of Florida versus Gregory Mullins. Mr. Mullins, good afternoon.
Good afternoon, sir.
You are here based on an allegation that you violated your probation. I'll give you as much information as I have. It was a violation of Condition E, that you picked up a new law offense sometime on November 1st, and violation of special condition that you have no hostile contact with an alleged victim. Based on that information, Judge Navarro issued a no bond warrant. You're going to remain on no bond, and I will appoint the Office of the Public Defender to represent your interest. Thanks. Mr. St. Fleur, good afternoon.
Good afternoon, sir.
Mr. St. Fleur, you have two cases with us. One is 2021 CF 13127. One is 2021 CF 124. Those are allegations of violation of community control. Judge Calderon received an affidavit from your probation officer alleging a violation of Condition A that you failed to report. There were some additional allegations of the violation, but I don't have, I'm sorry, violation of Condition B, that you weren't home when you were supposed to be, a violation of condition that you failed to comply with the instructions of your community control officer, and failing to maintain an hourly accounting with your community control officer. Based on that information, Judge Calderon issued no bonds on both of your cases. Going to remain on no bond on both of your cases. I will appoint the Office of the Public Defender to represent you on both of those.
Your Honor, he has 3 cases.
Let's see the two. Sure do. Nope. Sorry, you have a third case. That was 2021 CF 8036. Same situation, same allegations, same bond amount of none, and I'll appoint the Office of the Public Defender on that case as well.
Thank you, Your Honor.
Thanks. Mr. Solitaire?
Yes, sir.
Is it Solitary?
Sotolaire is close.
Sotolaire?
Thank you.
Thank you. Mr. Sotolaire, good afternoon. You are here with us based on an allegation that you violated your probation. I'll give you as much information as I have. It was an allegation of violation of Condition 29, accessing internet or computer services without the consent of your probation officer. Based on that information, another judge, that was Judge Alvaro, issued a warrant for your arrest. That's a no-bond warrant. You're going to remain on no bond until we can get you in front of him, and I will appoint the Office of the Public Defender to represent your interest. Thanks.
Thank you, Your Honor.
Yes, sir. I have Coraline Vandersloot is the next.
Your Honor, due to jail weather restrictions, she was unable to be transported from out of facility.
Thank you.
And I will waive, Your Honor.
I'll appoint the Office of the Public Defender. Ms. George, thanks. I'll accept the waiver. Ms. Vandersloot was arrested based on an on-view violation of her probation. That was for probable cause being found in a new law offense while she was on probation. That's case numbers 2022 CF 8422. That on-view violation will have no bond. Mr. Wilson? Good afternoon, Mr. Wilson.
No.
Mr. Wilson, you were arrested based on an allegation that you violated your probation. The information that I have is it alleges a violation of Condition E, that you picked up a driving while license suspended case, a violation of Condition D, that you left the county of residence. Based on that information, Judge Navarro, issued a warrant with no bond. You're going to remain on no bond. I will appoint the Office of the Public Defender to represent your interest. Thanks. The last of the cases I have in the stack. Anyone have any unresolved cases that we
Nothing from the state.
yet to address?
Nothing from defense, Your Honor.
Thank you, everyone, for slogging in on this morning and all the good work. The regular e-duty judge will be back tomorrow.
Yes.
Thank you.
Drive safe, Your Honor.
You as well. I think the worst of it's behind us.
Hopefully.
All right, we are back on the record. We're gonna start with our gentleman. Gregory Almond is first.
Here you are.
Good morning, give me 1 second. So you're charged with driving on a suspended license. Do you understand your charge?
Yes, I do.
Your bond is $1,500. You shall not violate any laws on auto bond. Are you able to make bond?
Yes, Your Honor, my daughter's arranged for it.
Okay. Your next court date will be November 22nd at 8 a.m. Have a good day.
Thank you.
You're welcome.
Yes, sir. Yes, sir.
Are you Thomas Ball?
Yes, ma'am.
You're charged with public indecency. Do you understand your charge?
Yeah, but they didn't read my rights, and also they were
I
trying
asked
to.
you, do you understand your charge?
Oh, yes, ma'am. Excuse me, yeah, ma'am.
Your bond is $10,000.
They said gave me a piece of paper saying my bond was.
They said your bond was $2,000. I always have the
Yeah, ma'am.
discretion to change the bond. I reviewed the file, and a $2,000 bond is way too low for what you've been described to have been doing. The court has discretion to change the bond. My job in bond is to determine if you're going to be a high rate of reoffending or if you're going to be a flight risk. That's what bond is associated with. Bond is not to punish you, but I do have a right to assess if you have a chance of reoffending or a chance of being a flight risk. I assess all of that based on the allegation, and your bond is $10,000. You shall not violate any laws or auto bond. Are you able to make bond?
I can't pay that, man. That's why I was asking for a bond reduction. Like, I'm not a flight risk, or I'm not gonna do it again. This is I don't call trouble. I ain't been in trouble in like 10 years. I'm not like a reoffender to cause something or a flight risk. I'm not gonna jeopardize my freedom to have some fake temporary freedom, like a flight risk. So I was just trying to figure out, like, why would you raise my bond? And this jail is more of a risk because.
Okay, thank you. I've already heard your argument. Your bond request is denied. Your next court date will be November 22nd at 8 a.m. on 201. Have a good day.
So how much was the bond account? Can I ask her a quick question? We were talking about my bond, sir? Please.
You don't want to pay attention.
She just said 10,000 with the bonding company, man. How much that'll be? Because the lady was nice enough to write down the price for the bonding company right here. So I just want to know if you nice enough.
Have a good day. Jamari Brown.
Wait, you gonna let her violate my rights? Come on this way, sir. Come on, let's move this way, sir. Sir, please. No, sir.
So you gonna do me? You gonna violate me on live TV like that, man?
I'm live. I'm not violating your rights, sir. You've been given a bond. Have an amazing day. Jamari Brown. Okay, have a great day, sir. God bless you. Jamari Brown. Yes.
Yes.
You are charged with aggravated assault. Do you understand your charge?
No, because I was walking down the street.
Let me stop you. Gentlemen. Aju,
If you come to no respect,
Aju.
you out of here. You understand? Yes, Judge.
Mute the camera, please. Gentlemen. Mute the camera. I still hear them. You can turn the camera back on. I can't see them. Mute the audio. Let them see me. Gentlemen, I know you probably are tired. It's been a long morning. I know we are on Zoom. Please don't think that you shall be able to disrespect the court because we are appearing via Zoom. You will respect this forum, or you will be held in contempt. We are going to go forward orderly and respectfully. I'm going to ask you all a question when I bring you before me. That question will be, do you understand your charges? The question is not, are you guilty? The question is not, did you do what they said you did? The question is not anything related to the charges on your case. You do not have a lawyer here to represent you. It will not be in your best interest to start talking on a live recorded stream without your lawyer present. And you will not interrupt me. When I ask you, do you understand your charges? If you say no, I will read the warrants or the warrant application aloud. I will then tell you whether or not I've granted a bond and what your bond amount is. At the end of all of that, you will be allowed to ask me a question that is relevant to your charge or your bond amount. You will not be permitted to argue your innocence because this is not the forum for that. Now that I've said that clearly, anybody who intentionally violates this order and starts to try to interrupt me or talk over me will not have court today, because I will find that you are doing that for the purpose of stalling court and disrespecting the court, and your case will be reset to tomorrow. I have an orderly courtroom. I'll respect you all, and you all respect me. Please unmute, Aju. Do you all understand?
Yes, ma'am.
Thank you. Mr. Brown, you are charged with aggravated assault. Do you understand your charge? It is alleged that on November 4th, that you threatened to shoot the victim, Monica Dennis, while she was standing at the bottom of her stairs getting ready to go to work. It is alleged that you instructed her to leave the residence before you shoot her ASS. While standing at the top of the stairs with a black handgun pointed downward. Ms. Dennis stated she became scared, fearing for her life, and fleeing the residence to call the police. It is alleged that you admitted to committing this offense, stating that she is not your real mother. It is alleged that you were located a mile away with the firearm that was described. It is alleged that that gun had no serial numbers and it was attached to your person. You all once lived together in Clayton County. You do not have a bond at this time. Should you get a bond, you shall stay away from Monica Dennis and not return to the address on Laramie Road. You shall not violate any laws while out on bond, but as stated, as of right now, you do not have a bond. I have appointed an attorney to represent you. Your next court date will be November 21st. Have a good day. Daryl Freeman,
Yes, ma'am.
you are charged with 2 felony counts of violation of the Georgia Controlled Substances Act. You are charged with possession of marijuana less than an ounce. You are charged with use of possession of drug-related objects. You are charged with carrying a concealed weapon and drugs outside of their container. Do you understand your charges?
Yes, ma'am.
Give me one moment.
Property?
We're back on the record. Mr. Freeman, on the 2 drug charges, your bond, on each drug charge, your bond is $7,000. The misdemeanor charge, your bond is $1,500. On the possession of drug-related objects, your bond is $1,500. On the carrying a weapon, concealed weapon is $5,000. And on dangerous drugs, your bond is $7,000 for a total of $29,000. You shall not violate any laws out on bond. Are you able to make bond?
I don't know at this time.
Your next court date is going to be November 21st at 8 a.m. in room 201. Have a good day.
Thank you.
Ernest Fuller. Sir, you are charged with criminal trespass. Do you understand your charge?
No, ma'am.
It is alleged that on November 4th, you were at the atrium area of the Hartsfield-Jackson Airport. That security and staff had asked you to exit because you were causing a verbal disturbance by yelling at guests and staff. It is alleged that you left but shortly returned, that you did not have a plane ticket, and that you were not employed by any company at the airport, and that you were charged with criminal trespass. Your bond is $3,500, and you shall not violate any laws on bond. Are you able to make bond?
Your Honor, they locked me up for preaching the gospel, and they tell me I committed a crime.
Are you able to make bond?
No, I'm not. I travel. I've been to 12 cities.
Let me
3
stop you.
states, and I've been to ground.
Let me stop you. Thank you, sir. Your next court date is November 21st at 8 a.m. in room 201. Have a good day.
Are you telling me I'm going to be here to November 20 something?
Come on this way, sir. Come on this way.
Go to hell.
I thought he said he was preaching the gospel. Did I hear that right?
I thought I heard that.
Tyreek McKenzie. But you know, I'm a real Christian, so I'm not gonna hold him in contempt because he was rude to me. Because you know, that's what somebody that's nasty would do. But I don't know anywhere you can tell the judge to go to hell and not get held in contempt, but I'm gonna let that one slide. Mr. McKenzie?
Yes,
Give me
ma'am.
one moment.
Okay.
It's real easy to talk stuff while you over there and while I'm here too. I noticed that. I'm not impressed. Tyreek McKenzie, good afternoon, sir. You were charged with battery and criminal damage to property in the second degree. Do you understand your charges, sir?
Yes, ma'am.
Okay, give me one moment.
I mean, 20. I mean, 24. Nobody take them back and shit out of the tree. If you stick them on, I didn't take them on.
I took his ass out of here. He's making too much.
Okay, Mr. McKenzie, you said you do understand your charges, correct? Uh-oh, it's muted. I'm sorry. Please unmute. I can't hear you, sir. You said you do or don't understand your charges.
You have.
Yes, ma'am, I understand my charges. I had an argument with my mom that went left.
I understand.
Yes, ma'am.
Shit is corrupt. Shit is corrupt. And I'm tired of you having to play with my freedom. I'm thinking you have to play with my freedom. You don't know the law.
Excuse me, Arjun, why is he still there?
No, we're escorting him out, Judge.
Thank you.
We're taking him out. He's gone.
Thank you.
You're welcome.
Your battery is a misdemeanor. Your bond on that charge is $3,500. The criminal damage to property is a felony. The bond on that charge is $5,000 for a total of $8,500. You shall stay away from Deanna Lawson and you shall not return to 461 Old Dixie Way in Forest Park. It was indicated that that's a shared residence. As such, you can go with the sheriff's escort for the limited purpose of retrieving your property. However, you may not go back to that property for any reason until this matter is resolved or the condition is modified by another judge. Do you understand?
Yes, ma'am. Will I be able to go get my stuff, my clothes?
Yes, with the sheriff's escort. That's what I said earlier. You can go with the sheriff's escort. That's the only way you can go, and you cannot go for any other reason.
And 8,500, will I get it back?
That depends on how you pay it. Remember earlier we talked about the different ways you can post bond? That depends on how you pay it.
I have a debit card on my property that has that on it.
Okay, so it depends on how you pay it, sir. Your next court date will be November 22nd at 8 a.m. in room 201. Have a good day. Minnie Bar Navarro.
Yeah, I might do it. She said I could.
Give me one moment.
Have a seat. Have a seat. You understand English? Let's have a seat. You came from what? India. You are India. No, you came from the housing. Come on. You came from the housing. So you came from the housing. What's your name? Housing. Never been born. Listen up. If you came from the housing, you go to the housing in that. From the housing, you can take it to India. If the housing is going to line up right. You came from the housing, line up and go to the housing. You can get from intake when on the glasses. When you get over there, you make a left, a right, you don't say intake view. Okay. Oh, save one. And I have saved one too. You want to go. Yeah. See if I can get a number to call so it can go down. Yeah, you have to go first. Yeah, how will it play? Yeah, yes, you have to go there first before they will take send you out and then lock it in. Yeah, you have to keep careful. Yeah, I can go back. Yeah, you go back to that again and then go to the program. Yeah, you have to report to everyone. It doesn't matter like that. You don't have to. Okay. You understand? Yes. You need to go back to the section. Yeah. The airport. The airport. Public intoxication.
We're back on the record. Mr. Navarro,
Yes.
You are charged with obstruction of an officer, DUI, open container, fleeing from police, license violation, reckless driving, expired tag, impeding the flow of traffic, failure to exercise due care, driving on the wrong side of the road, improper lane change, seatbelt violation, and violating a traffic arrow. Do you understand those charges?
Yes. Yeah.
For the obstruction, your bond is $3,500. For the DUI, your bond is $5,000. For the open container, your bond is $500. For fleeing from an officer, your bond is $3,500. For a license violation, your bond is $1,000. For reckless driving, your bond is $1,000. No tag, your bond is $500. Impeding traffic, your bond is $500. Failure to exercise due care, $500. Improper lane change, $500. Driving on the wrong side of the road, $500. Seatbelt, $500. Traffic arrow, $500. For a total of $18,000. You shall not violate any laws on a bond. Are you able to make bond?
Can you pay? Well, how much is that? Yes or no? Can you pay? Yeah. Yeah. That's all. Yeah. Yes, I can pay.
Your next court date is November 22nd at 8 a.m. Have a good day.
Have a sit down, brother. Sit down over there. Come on, son.
Jeffrey Perry,
How you doing today?
I'm well. How are you, sir?
Okay, man.
Okay.
And then when you.
Give me 1 second, Mr. Perry.
Yes, ma'am, no problem.
Miss Mary, I just realized, was I going too fast with Mr. Navarro? Did you get all that?
A little bit, but I got it.
Okay, I'm sorry. I forgot I got you helping me today. I'm gonna slow down. I'm sorry.
That's all right. I got it though.
Okay.
This is it? Yeah, that one is the three going back to America, the three. Is another son. Where they are, y'all going back to 7? Yeah, they're going to 7. You don't need to walk in. Someone go to 5, someone go to 1, 101. They know the contract. Come on, guys. One to
Jeffrey Perry,
Ma'am.
you were charged with theft by shoplifting. Do you understand your charge?
Ma'am. Yes, ma'am.
Your bond is $2,000. And you shall stay away from wholesale food. Your next court, and you should not violate any laws on a bond. Do you understand those special conditions?
Yes, ma'am.
Your next court date will be November 22nd at 8 a.m. in room 201. Have a good day.
You too, man. Thank you.
You're welcome. Thank you. Felix Potts.
Yes. Yes, ma'am. Yes, ma'am. Let me say it again. It's yes, ma'am, no, ma'am, yes, your honor, no, your honor. All right, we're not on the street, all right? Let's be respectful. This is a court, please.
What is his name?
Felix Potts, Ponce.
Okay.
Mr. Pond, am I saying your name correctly?
Yes.
I'm saying your name correctly?
Yeah, parts.
Okay.
Or sponsors.
I'm sorry.
Robin?
Am I saying your name correctly?
Yes, yes, ma'am.
Okay. You were charged with public drunk. Do you understand your charge?
Yes, ma'am.
Your bond is $1,000 and you shall not violate any laws out on bond. Are you able to make bond?
Yes.
Your next court date will be November 22nd at 8:30 a.m. in room 201. Have a good day.
Thank you, ma'am.
You're welcome. Mr. Savage, is that you? You, Mr. Savage?
Yes, ma'am.
Give me 1 second. So you're charged with a felony count of violation of the Georgia Controlled Substances Act. You're also charged with theft by receiving stolen property, which is a felony, possession of a weapon during the commission of a crime, a felony, and possession of a firearm by a convicted felon. Do you understand your charges?
Yes.
Give me one
Yes,
moment.
ma'am. Yes.
Give me one moment.
Yes. Go back in the shooting. You go in the center. You can walk down with all this. The listen from them? Yeah. The dude in there, going crazy. So like, you want us going back? I know that you're back in there.
Mr. Savage,
Yes, ma'am.
in reviewing the file, the court is not authorized to give you a bond on these charges. All these charges are felony charges and you are currently on probation. Your next court date will be November 21st at 8 a.m. in room 201. Have a good day.
You too.
Thank you. Mr. Sparks,
Yes, ma'am.
give me 1 second. If you can, pull your shirt up for me.
I was about to say, this how.
I understand, it's not your fault. No, no, no. I'm not mad at you. Mr. Sparks, you are charged with criminal interference, interference with government property, obstruction of an officer, unlawful possession of firearms, theft by receiving stolen property, and financial card transactions. Do you understand that?
Yes, ma'am.
Give me 1 moment.
Oh. They won't training. They won't training.
All right, Mr. Starks, for the criminal trespass, your bond is $6,000. Interference with government property, your bond is $6,000. Obstruction of an officer, your bond is $5,000. Unlawful possession of a firearm, your bond is $5,000. Theft by receiving stolen property, your bond is $2,000. And for the financial card transaction, Your bond is $6,000 for a total of $30,000. Are you able to make bond?
Nah, no, ma'am, but thank you.
You're welcome. Should you make bond, you should not violate any laws out on bond. And your next court date is gonna be November 21st at 8 a.m. in room 201.
No. Man. Hey, I'm in court, bro. I'm in court. Yeah, please be respectful.
Does anybody need, were they talking to me?
No, man.
Okay.
I'm sorry.
No worries. Have a good day, sir. Ms. Barry, did you get that?
I did.
Okay, great. Thank you. Jalen Wade,
Yes, Your Honor.
you were charged with theft by taking. Do you understand your charge?
Yes, Your Honor.
Give me one moment. Your bond is $8,000 and you shall not violate any laws while out on bond. Are you able to make bond?
Yes, ma'am.
This is a felony. The next court date will be November 21st at 8 a.m. in room 201. Have a good day.
Next.
And Mr. Williams?
Yeah.
Give me one moment. Mr. Williams, you are charged with aggravated assault, simple battery, criminal trespass, and interference with government property. Do you understand your charges?
I do.
You say yes?
Yes, ma'am.
Give me a moment.
The first one and that one. I tried to do this stuff, man. That shit don't go that way. Some of them, right? Yeah, we got the paperwork. You got an item.
Mr. Williams, on the aggravated assault, you do not have a bond. Ms. Mary, that's pursuant to 17-10-1. On civil battery, your bond is 5,000. Criminal trespass, your bond is 5,000. Interference with government property, you do not have a bond pursuant to 17-10-1. That just means you're based on your status as a suspended sentence. You do not have a bond at this time. Your next court date is gonna be November 21st at 8 a.m. in room 201. Have a good day.
Okay, thank you.
You're welcome.
All right, Judge, we have the 3 fugitives. I'll bring all of them
Thank you.
right here. You guys come on, line up, just line up. Just right there. So you can see. Talk to everybody. There you go. Next person. All right. Come on, this way a little bit. Okay, all right, that's good.
Before me, I should have Otis Washington, Marshall Lawson, and Antonio Bates. Good afternoon, gentlemen. I appreciate your patience.
Good afternoon.
It's been quite a morning, haven't
Yes, you know.
it? Okay, give me 1 second. All right, we're back on the record. I want you gentlemen to listen up because this is a little bit different than what you've heard earlier. You are here for what's called an extradition hearing. My voice is very hoarse. Can y'all hear me okay?
Yes, ma'am.
For each of you, fugitive warrants have been issued for your arrest. You do not have charges pending against you here in Clayton County. You have been brought to court today because you have charges pending against you in a different state, and that state is requesting that you return to answer for your charges. Mr. Washington,
Yes, ma'am.
the state of Florida has a warrant for murder out for your arrest. Mr. Lawson, the state of Kentucky has a warrant for rape for your arrest. And Mr. Bates, the state of Oklahoma has a warrant for murder for your arrest. Each of these states has indicated that they want to extradite you to return to answer to these charges. In accordance with the state laws of Georgia, you are brought before me for an explanation of this proceeding. You have the right to contest the legality of this warrant and all extradition proceedings, or You may waive your right to these proceedings and voluntarily return to the state demanding your return. Before you inform me of whether you wish to waive extradition, let me explain to you the following rights. You have the right to be represented by an attorney. If you cannot afford one will be appointed to represent you. If you decide to contest the legality of this proceeding, then you must file or have filed for you a writ of habeas corpus. You'll be allowed a reasonable amount of time to file that writ. You may file a writ of habeas corpus to contest extradition for only the following things: whether or not the documents are in order on their face, whether you are charged with an actual crime in the demanding state, whether you are the person named in the request, and whether you are in fact a fugitive. You cannot raise the issue of your guilt or innocence in this state. As stated, you are entitled to the advice of counsel in deciding whether you wish to waive extradition. If you waive, for you, Mr. Washington, the state of Florida, for you, Mr. Lawson, the state of Kentucky, and for you, Mr. Bates, the state of Oklahoma, will respectively have 30 days to come get you. I'm trying, y'all. Give me 1 second. If the state does not come get you within 30 days, you will be released. If you contest extradition and they are unable to extradite you, please, I know he's trying to get the paperwork, but let me finish. I want to make sure he understands, so please don't talk to him while I'm doing this as you. If you contest extradition and the state is unable to extradite you within 30 days, you may be committed to the county for an additional 60 days while awaiting your extradition. I will ask each of you, do you wish to move forward? Mr. Washington,
Yes, ma'am.
do you wish to waive and return voluntarily to the state of Florida?
Yes, ma'am.
Are you doing this decision freely and voluntarily?
Yes, ma'am.
Mr. Lawson, do you wish to waive and return to the state of Kentucky?
I have a real quick question. How long do they have to get me again?
Answer first. Answer
Yeah, no, I don't want to waive it.
If you don't want to waive,
No, I'm trying to understand. I'm sorry because I got thrown off. I apologize. No, I don't want to contest it. So if I want them to come get me as fast as possible.
that's waiving.
Okay, yes, ma'am. I want to waive it. Yes, I want them to come get me.
And to answer your question, if you waive, they have 30 days to come get you.
Okay, and then the additional time if they want to continue, what's the word? Extend it, yeah.
That will be up
How
to
long
the
do they have?
jail to determine if they want to release you. If after 30 days they have not come to get you, it will be up to the jail to determine if they made steps to try to come and retrieve you.
Okay, so the max time they got is 30 days to get me.
The jail has discretion to give them more time if there's been extenuating circumstances, a snowstorm, a rainstorm, COVID-19, I don't know. So, but yes, 30 days is generally the time if they have not gotten you. But do you make that decision freely and voluntarily?
Yes, I do.
Mr. Bates, do you waive and wish to return to the state of Oklahoma to answer to these charges?
Yes, ma'am. Waving like I'm waving now.
And you freely do this? Okay. And you all will have several original orders. You will sign each of them. They will return them to me. I will sign them and they will be processed. Mr. Washington, you raised your hand.
Yeah, I had a question. You said my
You said it was murder,
Yes,
not the A, not attempt?
murder.
All right.
You gentlemen have a good day.
All right, thank you.
You're welcome.
You guys go sign.
Is that it, Azul?
That's it, Judge.
Good morning again, everyone. Please raise your right hands.
Buenos días a todos de nuevo. Por favor, levanten su mano.
Do you swear or affirm that the information given to this court, as well as the information on your applications for court-appointed counsel, are true and correct, so help you? If so, say I do.
¿Juran o afirman que la información que le van a dar a la corte, así como la información en su solicitud para la corte, es correcta hasta donde saben, así les ayude Dios?
Sí.
This is your name David? David, interpreter?
Sorry, once again?
What is your name? I'm sorry.
The name is David.
David. Okay, thank you. We have David here, who is our interpreter. This is your first appearance before the Magistrate Court of Clayton County.
Tenemos aquí a David, es el intérprete. Esta es su primera comparecencia entre la corte del magistrado de Cameron County.
Clayton County.
Clayton County.
We are not here to try your case or to take a plea.
No estamos aquí para probar su caso o para tomarles una declaración.
You are here for the court to inform you of the charges against you, advise you of your rights, and set bail for those offenses which I am authorized to set bail.
Estamos aquí para que la corte les informe de los cargos en su contra y que les digan cuáles son sus derechos y fijar una fianza para los que tengan una fianza.
I will also schedule your preliminary hearing and determine whether you require the assistance of an attorney.
También les voy a agendar una audiencia preliminar. En ese momento podrán tener asistencia de un abogado.
You have the right to remain silent and say nothing, but should you give up this right, anything you say may be used against you if this case goes to trial.
Tienen el derecho de permanecer en silencio y no decir nada. Si renuncian a ese derecho, todo lo que digan podría ser usado en su contra si es que se lleva a juicio.
During this and all other proceedings, you have the following rights.
Durante este y todos los siguientes procedimientos tienen los siguientes derechos.
The right to the presumption of innocence until the state proves your guilt beyond a reasonable doubt.
El derecho a ser presuntos inocentes hasta que el Estado compruebe su culpabilidad, más allá de cualquier duda razonable.
The right to the indictment by grand jury for most felonies or by accusation for misdemeanors.
Sir, would you mind repeating one more time for the interpreter?
Yes, and I want to apologize. My voice is very hoarse, but we're going to get through this, okay? I said you have the right to indictment by grand jury for most felonies or by accusation for misdemeanors.
Tienen el derecho de tener una condena por un jurado, por un gran jurado, por cualquier delito mayor o acusados por algún delito menor.
You have the right to a speedy and public trial by jury.
Tienen el derecho a un juicio privado por un jurado.
You have the right to see, hear, and cross-examine witnesses who are brought to testify against you.
Tienen el derecho de ver, escuchar y hacer examinación cruzada de testigos que testifiquen contra ustedes.
You have the right to compel the attendance of witnesses on your own behalf by the use of a subpoena.
tienen el derecho de pedir la asistencia de testigos por su propia cuenta utilizando un citatorio.
You also have the right to testify and offer evidence if you want to, but nobody can make you do that.
También tienen el derecho de testificar y ofrecer evidencia si es que quieren, pero nadie puede obligarlos a hacerlo.
Should you choose not to, you will still remain presumed innocent until the state proves your guilt beyond a reasonable doubt.
Ustedes van a seguir siendo considerados como inocentes hasta que el Estado compruebe su culpabilidad más allá de cualquier duda razonable.
You also have the right to have an attorney represent you. At this point, I will appoint each of you an attorney.
También tienen el derecho de ser representados por un abogado. En este punto, yo les estaría asignando un abogado a cada uno de ustedes.
You always have the right to hire your own counsel or to represent yourself.
Siempre tienen el derecho de contratar a su propio consejero o de representarse a ustedes mismos.
Some of you will be allowed to post unrestricted bond pending your case. While you're, excuse me, sorry. Let me start over. David, let me start over. Some of you will be allowed to post unrestricted bonds for your release from jail while your case is pending.
Algunos de ustedes van a tener permitido que se coloque una fianza para ser liberados de la cárcel mientras su caso siga estando pendiente.
This bond may be commercial, cash, or property bond.
Esta fianza puede ser comercial o una fianza de propiedad.
If you use cash, someone will bring the full amount of your bond in cash, the full amount of your bond in cash to the sheriff's office, who will hold it until your case is closed.
Si cubren su fianza por completo en efectivo, la oficina del alguacil va a guardarlo hasta que se cierre su caso.
Once your case is closed, they will return the cash bond to the person who posted your bond.
Una vez que el caso sea cerrado, le van a devolver la fianza en efectivo a la persona que haya colocado su fianza.
You may also use a commercial bonding company who can take a fee of up to 15% of the total bond as a service, the fee for the service they provide.
También pueden utilizar una compañía comercial de fianzas que cobrarían hasta un 15% del total de la fianza por el servicio proporcionado.
You may also post a commercial bond using your property, a property bond using your property.
También pueden colocar una fianza de propiedad utilizando su propiedad.
But your property must have at least a net equity of 3 times the total amount of bond to qualify.
Pero la propiedad debe de tener en valor líquido al menos 3 veces el valor total de la fianza para calificar.
The commercial bond that I mentioned earlier will not be returned to the person who posted it.
La fianza comercial que les mencionaba antes no sería devuelta a la persona que la colocó.
Everyone will have special conditions on your bond. At minimum, you will not be allowed to violate any laws while out on bond.
Cada uno va a tener condiciones especiales con sus fianzas, pero por mínimo, todos no van a tener permitido infringir ninguna ley mientras están en fianza.
Some of you will have additional conditions that prohibit you from going around certain people or returning to certain places.
Algunos de ustedes pueden tener condiciones adicionales les prohíban acercarse a ciertas personas o acercarse a ciertos lugares.
The court takes these conditions very seriously, and if you violate any special condition, your bond will be revoked, and you will not be entitled to a new bond while awaiting trial.
La Corte toma estas condiciones muy en serio, y si violan alguna de esas condiciones especiales, sus fianzas serían revocadas y no tendrían derecho a una nueva fianza mientras está el caso.
Additionally, you may have new charges that carry fines up to $20,000 or incarceration of up to 10 years in prison.
Adicionalmente, pueden tener nuevos cargos de hasta $20,000 o hasta 10 años en prisión.
If you have family members or friends who are watching and will help you with your bond, they should wait about 3 hours until the court is concluded before attempting to make your bond.
Si tienen familiares o amigos que les estén cuidando y ayudando con la fianza, tendrían que esperar 3 horas después de que el caso sea concluido para poder pagar la fianza.
If a family member or friend is an alleged victim, they will not be allowed to post bond.
Sir, would you mind repeating one more time for the interpreter, Your Honor?
Yes, if the family member or friend is an alleged victim, they will not be allowed to post your bond.
Si el familiar o el amigo es la víctima, no se le va a permitir a esta persona pagar la fianza.
Some of you are charged with offenses for which the court is not authorized to set bail.
Algunos de ustedes están acusados por delitos para los que la Corte no tiene autorizado imponer una fianza.
In this event, a bond hearing will be set in order for you to have your bond revisited at that time.
En este caso, una audiencia de fianza sería hecha para que les puedan fijar la fianza en ese momento.
If you are currently on active probation, the court is not authorized to set your bond because your probation officer has to review these charges to see if they wish to take out a probation warrant.
Si están actualmente bajo libertad probatoria, la Corte no podría autorizar una fianza, porque el oficial de libertad probatoria tendría que revisar el caso para ver si es que quisiera emitir una orden de libertad probatoria.
We are going to take our Spanish-speaking people first, then we'll take our female inmates, followed by our male inmates.
Van a hablar primero con la gente que habla en español, primero con los internos que sean mujeres y después con los internos hombres.
Juan Carlos Diaz.
Juan Carlos Díaz.
Both of them raised their hand. Which one is Juan?
¿Cuál es Juan? Levante la mano.
Aju, will you please unmute the video?
Por favor, ¿podría quitarle el mudo a su video?
Thank you. Juan Carlos Diaz.
Juan Carlos Díaz.
You are charged with no license.
¿A usted se le acusa de no tener licencia?
Do you understand your charge?
¿Entiende usted su cargo?
Mande, disculpe.
Comprende. You understand your charges?
¿Comprende? ¿Entiende cuáles son sus cargos?
¿Cuáles son mis cargos?
Which are my charges?
You are charged with no license.
Se le acusa a usted de no tener licencia.
Ya, exacto, así es.
Your bond is $1,000.
Yeah.
Su fianza es de $1,000.
Sí,
Your
ya
next court,
traigo un... ¿No? Ok.
un momento.
Ok.
Your bond is $1,000. Go ahead, David. Tell me.
Fianza es de $1,000.
You shall not violate any laws without a bond.
No debe de usted violar ninguna ley mientras está bajo esta fianza de auto.
Are you able to make bond?
¿Usted puede pagar esa fianza?
Exactamente, pero necesito hacer una llamada. Sí.
Exactly, but I need to make a call.
I understand.
Puede hacerlo.
Your next court date is November 22nd at 8 a.m.
Su siguiente fecha de la corte es el 22 de noviembre a las 8 a.m.
Have a good day.
Ok.
Que tenga buen día.
Para hacer la llamada, ¿dónde puedo hablar? Disculpen.
What did he say, David?
This is the interpreter. To let you know, I can play here again, but I could hear him saying to make the call. How can I make the call?
Okay, the jail will tell you how to do that.
Louder.
El carcelero le dirá cómo hacerlo.
Okay.
Have a good day.
Que tenga buen día.
Sebastian Diaz. Sebastian Diaz.
It's me.
Sebastián Díaz. Sebastián Díaz.
Soy yo.
No.
Hold on one second, David. Where is my pen? Give me 1 second, y'all.
Hey.
Where does Sebastian Diaz come from? 7? They are. I have to call you a sandwich.
Mr. Diaz,
Aquí estoy.
Señor Díaz.
Aquí estoy.
you are charged with no tail lights and license violation.
Usted se le acusa de no tener luces traseras y de violación de licencia.
Do you understand your charges?
¿Entiende usted sus cargos?
Sí.
For the tail light, your bond is $500.
Por su luz trasera, la fianza es de $500.
For the license, your bond is $1,000.
Por la licencia, su fianza es de $1,000.
For a total of $1,500.
Por un total de $1,500.
You shall not violate any laws without a bond.
No debe usted violar ninguna ley mientras esté bajo fianza.
Do you understand?
Sí.
¿Entiende usted?
Are you able to make bond?
Ya. ¿Puede usted pagar la fianza?
Sí.
Your next court date is November 22nd at 8 a.m.
Su siguiente fecha de la corte es el 22 de noviembre a las 8 a.m.
Have a good day.
Que tenga buen día.
Gracias.
Alvarado Rivera,
Sí.
Eduardo Rivera.
Sí.
one moment.
Un momento.
Okay.
Mr. Rivera, you are charged with simple battery and battery. Do you understand your charges?
Sorry, would you mind repeating just once again what the charge was?
Simple battery and battery.
Sorry, would you mind just clarifying for the interpreter, what would battering mean, just to get some clarification?
We're back on the record. Mr. Rivera, you are charged with simple battery and battery.
Señor Rivera, se le acusa de haber tenido un choque y un choque sencillo.
Do you understand?
¿Entiende usted?
Sí, entiendo.
Your bond on the simple battery is $3,500.
Su fianza por el choque simple es de $3,500
And on the battery is $3,500.
y del choque es de $3,500
For a total of $7,000.
por un total de $7,000.
You shall stay away from Gihio Alvarado
Debe de usted mantenerse alejado de Yuheil Alvarado
and Moab Alvarado, Moab Alvarado,
y sorry, Your Honor, would you mind repeating the name just one more time?
Gihio Alvarado and Moab Alvarado.
Jael Alvarado y Moed Alvarado.
Moab y Jael, sí.
Joab and Jael, yes.
Okay. Do not return to 500 Pine Place in Riverdale, Georgia.
Sir, would you mind repeating just once again the place, Your Honor?
500 Pine Place, do not return.
No vuelva usted a 500 Pine Place. No regrese.
Sí. Ahí vivo yo en la 500 Pipeline.
That's where I live, in the 500 Pine Plain.
Do not return to 500 Pine Place.
No regrese usted a 500 Pine Plain.
Do you understand?
¿Entiende usted?
Yo entiendo.
Your next court date is November 22nd at 8 a.m.
Mrs. Interrupter, just to clarify, it was at 8 a.m., November 22nd.
Yes.
Su siguiente fecha de la corte es el 22 de noviembre a las 8 a.m.
Have a good day.
Que tenga un buen día.
And thank you, David.
You speak English a little bit?
All right, give me 5 minutes to get my paperwork together. As you, then we're going to start with the female inmate.
Okay,
All right,
Judge.
bye, David. No, we're done. We don't have any more for you, David. Have a good day.
Okay, thank you for using our service.
Thank you. Bye-bye. All right, we're back on the record. Marquita Berry,
Yes, ma'am.
you are charged with possession of marijuana less than an ounce and use or possession of drug-related objects. Do you understand your charges?
Yes, Your Honor.
Your bond on possession of marijuana is $1,500. Your bond on the drug-related objects charge is $1,500 for a total of $3,000. You shall not violate any laws while on bond. Do you understand?
Yes, Your Honor.
Are you able to make bond?
Yes, Your Honor.
Your next court date is gonna be November 22nd at 8 a.m. in room 201. Have a good day.
Thank you, Your Honor.
You're welcome. Stephanie Berry,
Yes, good morning, Your Honor.
good morning. Ma'am, you are charged with simple battery and cruelty to children in the 3rd degree. Do you understand your charges?
Yes.
I have dismissed the cruelty to children charge. However, your simple battery charge does still stand. Your bond on that charge is $3,500, and you shall stay away from Diane Williams. You shall not return to 9362 Houston Road in Jonesboro, Georgia. You may go back with a sheriff's escort for the limited purpose of retrieving your personal property. However, you may not go, thank you. You may not go back to that property unrepresented or without, unescorted until this case is resolved, until this condition is modified by another judge. Do you understand?
Yes, I do.
And you may not violate any laws by out on bond. Do you understand?
Yes, I do.
Are you able to make bond?
Yes, I am. Myself. There's nobody out there that'll do it for me.
Yes, ma'am. Your next court date is November 22nd at 8 a.m. in room 201. Have a good day.
So thank you.
Thank you. Heather Carter. Yes, you are charged with a felony count of violation of the Georgia Controlled Substances Act. Do you understand your charge?
Yes.
Your bond on that charge is $6,000. You shall not violate any laws of out on bond. Are you able to make bond?
I'm not sure. Yes, that's the calculation.
Your next court date is November 21st at 8 a.m. in room 201. Have a good day. Bria Coleman.
Judge, you're missing a Kagel Brittany?
What do you have her charged with, Aju?
She's being charged with the VGCSA and possession of drug object. Do you have?
Cavill? Miss Mary,
Yes, ma'am.
do you see Cavill?
I see it on my calendar, yes.
Could you look through the stack for me? I may have overlooked it. I want to do Bria Coleman while Miss Mary's shaking into that.
Okay.
Come on.
Thank you, Aju.
Welcome.
Miss Coleman, you were charged with simple battery. Do you understand your charge?
Yes, ma'am.
Your bond with simple battery is $3,500. A condition of your bond is you must stay away from Tracy Byers, and you shall not return to 6703 Sunset Hills Boulevard. It is a shared residence. As such, you may go back with a sheriff's escort for the limited purpose of retrieving your personal property. However, you may not go back to that property without a sheriff's escort until the case is resolved. or the condition is modified by another judge. Do you understand?
Yes, ma'am.
Are you able to make bond?
Yes, ma'am.
Your next court date will be November 22nd at 8 a.m. in room 201.
Thank you.
You're welcome. Next is Patrice Hayes.
Yes, ma'am.
Before you go to her, you want me to look for the criminal history? I found the warrant.
You can send me the warrant.
Okay.
Thank you. What was the charge, Ms. Mary, for the lady you're sending me?
Ma'am.
Not you, ma'am.
It's VGCSA.
Yes, ma'am. Please send me the criminal history too.
Okay.
Thank you. Are you Ms. Hayes?
Yes, I am.
You're charged with criminal trespass, family violence. Do you understand your charge?
No, ma'am.
It is alleged that you did commit the offense when you knowingly and maliciously locked Keshante Hayes, who you currently reside with, out of the residence after a verbal disagreement, that you were warned prior to the incident that you could not lock her out of the house, that you were provided information on how to file for an eviction, and that you instructed other occupants to not open the door for her. Your bond in that case is $3,500, and you shall stay away from Miss Keshante Hayes. You shall not
That is
return to, do not interrupt me. I don't know what about this makes you think you can talk while I'm talking. If you have a question, when I'm done, I will allow you to ask it.
Yes.
Please respect me as I've respected you.
Yes, ma'am.
Let me finish.
Yes.
Your bond is $3,500. You shall stay away from Keshante Hayes. You shall not return to 5560 Pine Gate Drive in College Park, Georgia. Since this is a shared residence, I will allow you to go with the sheriff's escort for the limited purpose of retrieving your personal property. You shall not go back to that property without a sheriff's escort until this case is resolved, until this condition is modified by another judge. Are you able to make bond?
Yes, ma'am.
Your next court date will be November 22nd at 8 a.m. What is your question?
Yes, ma'am, and Keshante Hayes is my granddaughter, and my husband recently passed, and I wanted them to come and help me around my home, but they start firing me, all the drug stuff, everybody in and out my house, and I don't
Let me
live
stop you.
like that.
Let me stop you. Aju, we're gonna put her at the end.
Judge.
Put her at the end.
Okay. Come on, have a seat in there. Come on, next.
Miana Hunter,
Yes.
you are charged with no tag and driving on a suspended license. Do you understand your charges?
Yeah.
On the tag charge, your bond is $500. On the license charge, your bond is $1,500. Are you able to make bond?
Yes.
Condition of your bond is you shall not violate any laws on bond. Your next court date is gonna be November 22nd at 8:30 a.m. in room 201. Have a good day.
I have a question for you.
Yes.
When I first came in, they told me that my bond was $25.40 and that's been paid. Is this an additional bond or?
I'm not sure what you were told. If your bond was, if you have only these two charges tag and license, they may have bonded you out now, and it may have happened before they started court. So they may not have had time to let the jail know. So if they've already posted your bond, you'll be released, okay?
Okay, thank you.
You're welcome.
Pick up your hand for me. Put your hands up. Hands out. Hands out. Slide down from yours.
All right, Judge, I just emailed it to you.
Thank you so much.
You're welcome.
Cornisha Jones,
Yes.
you are charged with abandonment of child, and you are charged with cruelty to children and deprivation of necessary sustenance. Do you understand those charges?
I do.
Give me 1 second. For each charge, your bond is $3,500 for a total of $7,000. Ms. Jones, I misspoke. Your cruelty to child charge is actually a first degree cruelty to children. So your bond on the abandonment is $3,500. On the felony charge, your bond is $7,000 for a total of $10,500. You shall stay away from. You shall stay away from Antavius Jones. And you should not violate any laws out on bond. Do you understand?
Yes, ma'am, I have a question.
I'll get your question when I'm ready. Your next court date, are you able to make bond?
Yes.
Your next court date will be November 21st at 8 a.m. in room 201. What is your question?
That's my son, and he lives with me.
I know
he's
that.
14 years.
What's your question?
You say I'm supposed to stay away from him. He has nowhere, so I don't know.
He's the alleged victim now in a cruelty to children charge. The court is not allowed for anybody to have any contact with any of the alleged victims. I understand that's your baby. There may be some other things going on. I have appointed an attorney to represent you. I know, I'm not judging you. I'm a judge. Okay. I'm not judging you. But he's the alleged victim. There is no contact at this juncture. You have an attorney, speak with your lawyer. They may be able to modify that condition, but as of now, that is my order. Do you understand?
Yes, and you said my bond is 10,000?
10,500.
10,500.
Have a good day.
Next question.
Tia Lattimore.
Speak loud.
Hi, good morning.
Good morning. Give me 1 moment. Miss Mary, did you get that? Did I change that bond on the felony? I know I had spoken.
I got it.
Okay, thank you.
Just had before?
Yes.
Yes, I got it.
Thank you. Ms. Lattimore, you are charged with possession of marijuana less than an ounce and no insurance. Do you understand your charges?
Yes, ma'am.
On the no insurance, your bond is $1,000. On the possession of marijuana, Your bond is $1,500, for a total of $2,500. And you should not violate any laws while out on bond. Do you understand?
Yes, ma'am.
Are you able to make bond?
Yes, ma'am.
Your next court date will be November 22nd at 8 a.m. in room 201. Have a good day.
Thank you.
Thank you. What's your name?
Shakina Moore.
Give me one moment. Excuse me. You were charged with driving on a suspended license and driving a motor vehicle with a suspended registration. Do you understand your charges?
Yes, ma'am.
Your bond on a suspended license is $1,500. On a driving with an invalid registration is $500 for a total of $2,000. Do you understand?
Yes, ma'am.
You shall not violate any laws while out on bond. Are you able to make bond?
Yes, ma'am.
Your next court date is November 22nd at 8 a.m. in room 201. Have a good day. Thank you. Are you Miss Paulding? You were charged with a felony violation of the Georgia Controlled Substances Act, possession of a weapon during the commission of a crime, and obstruction of an officer. Give me one moment.
And let's see, and the Courtroom and everything. Doing something. Okay. So. I can take them all at once, but some of them go to intake, so some of them go, none of them go to three. No, you go to three. No, that's the which one y'all want to a housing unit? Who going to the zone? That's it? Number 6. Yeah, I just don't want to be going back and forth, back and forth.
All right, we're back on the record. Ma'am, you're charged with possession of THC oil. And you said you understand your charges?
Yes, ma'am.
Okay. For the possession charge, your bond is $5,000. For the possession of a weapon charge, your bond is $5,000. And for the obstruction charge, your bond is $3,000, for a total of $13,000. You shall not violate any laws out on bond. Do you understand?
Yes, ma'am.
Are you able to make bond?
Yes, ma'am.
Your next court date will be November 21st at 8 a.m. in room 201. Have a good day. What's your name, ma'am?
Janelle Walker.
Give me 1 second.
My charges being.
No, quiet. All right.
All right, Ms. Walker, you are charged with 2 felony counts of possession, violation of the Georgia Controlled Substances Act. You're charged with possession of a marijuana less than an ounce, use or possession of a drug-related object, carrying a concealed weapon, and drugs not in their original container. Do you understand your charging?
Yes,
Yes, ma'am.
yes, ma'am.
Give me 1 second. We're back on the record. You said you do understand your charges, correct?
Yes, ma'am.
For the first violation, your bond is $7,000. For the second violation of Georgia Controlled Substances Act charge, your bond is $7,000. For possession of marijuana, $1,500. Drug-related objects, $1,500. Possession of a concealed weapon, $5,000. Drugs outside of their container, $7,000. For a total of $29,000. You shall not violate any laws on bond. Are you able to make bond?
Yes, ma'am.
Your next court date is November 21st at 8 a.m. in room 201. Have a good day.
And can I say something?
You can, you are being recorded and your lawyer's not here. Go ahead.
Living in Atlanta, Georgia, the worst
Come on.
mistake of my life.
Come on this way. Go that way.
The worst.
All right, Judge, we have a Kagiro.
Yes.
This
The
Kagiro,
good
you
thing
want
about
her now?
mistakes is you can always write your mistakes. It'll be all right. Bring Cargill back and then give me 1 second.
All right, ma'am. Stand right in this schedule. And then put your hand.
Ma'am, you were charged with violation of the Georgia Controlled Substances Act for possession of methamphetamines and drug-related objects. Do you understand your charges? On the possession charge, your bond is $7,000. For the drug-related objects, your bond is $1,500 for a total of $8,500. You shall not violate any laws allowed on bond. Are you able to make bond?
Yes, ma'am.
Your next court date is November 22nd at 21st, excuse me, at 8 a.m. Have a good day.
Thank you.
Thank you. Give me 1 second.
All right, Miss Hayes, stand right here.
Good morning, Mr. Espinal.
Good morning, how you doing?
Mr. Espinal, you have a warrant out of Polk County. Currently, that warrant has bond amounts attached. However, there is a hold from Polk County indicating that there is pretrial conditions before you can post bond. Therefore, you're going to remain on no bond with us. We'll let Polk County know that you're here with us. And
I don't know anything about that.
Can we verify, because according to the warrant, it has.
I don't know nobody.
See, it has count 1 at 1,000, count 2 and 3 at 1,000, count 4 at 1,000, and 5.
subject has pretrial conditions before he.
Yeah, I don't know.
I don't know what those. I see the bond amounts, but not the bond conditions.
We don't have access to their records. If they can just put that on the record, you can notate it on the court minutes.
Right. Ms. Jenkins, can you check into Mr. Espinal Ortega? The bond in the FCIC is indicating bond amounts. However, it says hold. We will pick up. Subject has pretrial conditions before he can post bond. I don't have any pretrial conditions that are referenced in the remarks section of the FCIC.
You can just go and check to see if you have a hold?
Yeah.
Oh, hold on 1 second.
Thanks.
I just want to see if anything.
Those are the Spanish.
Oh. You didn't have a pretrial sheet.
Correct.
Yes.
We'll come back to Mr. Espinal Ortega. State of Florida versus Ramon Gautier.
President approaching, Your Honor. Defense will be requesting a waiver of reading of his charges.
Thanks. Good morning, sir. Sir, you were arrested based on 2 charges. Those are both third-degree felony allegations. Your attorney will be appointed, so the Office of the Public Defender is appointed. They let me know that you are aware of what the allegations are against you. Currently, you're on no bond. You're going to remain on no bond until the attorney can get you in front of the trial judge, and I've got no additional court dates to give you at this point. Thanks. State of Florida versus William Hurt.
Your Honor, if we can recall that one last, he's a keep away from one of the other individuals on the list, and they need to be brought up separately per the jail's policy.
All right, thanks. State of Florida versus Tasha Ibanez Nieves.
President approaching, Your Honor. And Your Honor, I have been informed by PTR that Mr. Espinal Ortega does have a hold from Polk County.
Okay. Of course.
Okay.
So he's on no bond with a hold. That was the
This is supposed to be no bond.
yes. It's got bond amount. He's on a no. We'll do it in a minute.
It's just, I got to if I don't.
I'll recall it on the record.
Okay.
Ms. Ibanez, good morning. You are here based on allegations of battery on a law enforcement officer or a firefighter or an EMT. Court read the charging affidavit. I do find probable cause for your arrest. Your bond's going to be set in the amount of $2,500 with the special condition that you are not to return to the scene where this is alleged to have occurred. That is Osceola Regional Hospital. I'll appoint the Office of the Public Defender to represent your interest.
Your Honor, you do recognize that there are 2 counts of that bat Leo.
Right, it's written on this. Hold on just a sec. That's 2 counts. It's written on the same line on the charging affidavit. There's a handwritten notation that says ×2. In the charging affidavit, there is victim 1 and victim 2. The court's going to set bond in the first count in the amount of $1,250 and the bond in the second count in the amount of $1,250. Condition that you not return to Osceola Regional. Thank you. State of Florida versus Darius Johnson.
President approaching, Your Honor.
Morning, Mr. Johnson.
Good morning.
You and I saw each other yesterday, or I think it was yesterday. You were taken into custody based on an amended affidavit on violation of probation that added some additional conditions, one of which was an allegation that you absconded from probation. Based on that information, the court did issue a new warrant for your arrest. That warrant has no bond. I'm willing to revisit that once I get some additional information. Office of the Public Defender is appointed to represent your interests. They can get you in front of me pretty quick. I've got some time next week.
Okay.
All right, thanks.
Thank you, Your Honor.
State of Florida versus Cordell Jones.
I'll leave it there. Thank you. Just for that.
Morning, Mr. Jones.
Good morning.
Mr. Jones, you were arrested based on, I think it's my warrant, for allegation of violation of probation based on the allegations in the affidavit from your probation officer and your designation as a violent felony offender of special concern. The warrant has no, you're going to remain on no bond until we can get together and talk about it, and I'll appoint the Office of the Public Defender to represent your interests. Thanks. We're going to recall Hector Espinal Ortega on the record.
I'm here, sir.
Mr. Espinal Ortega, your warrant is somewhat confusing. It does have bond amounts. However, there is a designation on the FCIC warrant that there is a hold and that Polk County wishes for you to be held in custody until you get over to Polk County. So you're going to remain on no bond. I believe once we get you over there, you will have bonds, but they want an opportunity to talk to you about special conditions of bond prior to your release. We'll let Polk County know that you're here with us, and we should be able to get you over there pretty quick. Thanks. State of Florida versus Dakota Moore. Thanks. Mr. Moore, good morning.
Morning, sir.
Mr. Moore, you are here with us based on allegations of aggravated battery with a deadly weapon for that unfortunate situation with your father. I do see a witness is present here in court with me. I do find probable cause for your initial arrest. I am going to appoint the Office of the Public Defender to represent your interests, and I am going to consider witness testimony regarding any reasonable conditions of bond. Good morning. If you will get kind of close to that microphone for me, it's pretty directional, and give me your name, please.
Thomas Moore.
Thank you, Mr. Moore. We're going to place you under oath.
Raise your right hands, please. Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record.
Thomas Moore.
Thank you. Mr. Moore, you're listed as the alleged victim in this case with this incident with your son. I have taken a look at it, found probable cause. I'm going to ask for your thoughts about whether you wish to have contact at this time with Dakota and whether you wish for him to return to the family home. Have there been any instances of violence between you two in the past?
Yes, sir.
Okay. All right. And do you believe that alcohol or drugs played a factor in this issue?
No, sir.
Is it your wish to have contact with Dakota at this time?
Yes, but I don't know if you knew, but he was in Park Place Healthcare on Monday and got released to us on Wednesday. And this happened an hour later. So he probably needs to go back and get some help, obviously medication as well.
All right, and this occurred at the Hideaway Beach Lane address. Is that the family home?
Yes, sir.
Do you wish for Mr. Moore to have a separate residence for the time being?
Yes.
All right. Thank you. The most protection the court can afford is a no contact order and a no return, and maintain separate residences. You have requested to have some contact with Mr. Moore. The court would order that that be non-hostile. Do you have a means of communication, like a cell phone, if you were concerned about further acts of domestic violence?
I have a cell phone, yes, sir.
Thank you. Mr. Lopez, do you have any questions for Mr. Moore?
No further questions, Your Honor.
Thank you. Ms. Eugene, any questions for the witness?
No, Your Honor.
Thank you. All right, thank you for that information, Mr. Moore. At initial appearance in a criminal allegation, the court doesn't have a lot of tools in the toolbox to address potential mental health concerns. I see that he does not qualify for pretrial release, so the court's going to do the following. I am going to set bond in this case in the amount of $2,500. Mr. Moore, you're to have no hostile contact with your father. That means exactly what it sounds like. No threatening over electronic devices, social media, no threatening phone calls, no physical altercations, no getting in his face. The court is not going to allow you to return to the Hideaway Beach Lane address. The court will allow you to return one time if you have personal property with law enforcement after that's coordinated with your family, so you can get some personal items while this case is getting sorted out. As a condition of your bond, you are to continue with any mental health recommendations or treatment as recommended by a mental health professional, and any medication compliance. I will appoint the Office of the Public Defender if I didn't previously announce that. Thank you.
Thank you, Your Honor.
State of Florida versus Gregory Reisman.
President approaching, Your Honor.
Good morning, Mr. Reisman.
Good morning, sir.
Mr. Reisman, you were accused of battery domestic violence related. I have read the charging affidavit, and I do find probable cause for your initial arrest.
Your Honor,
Yes.
I'm not sure how they do it in Osceola, but in Orange, when two co-defendants are arrested, they usually see them together just so you can determine whether or not they want to have contact with each other. The case that we bypassed, William Hurt, that is the co-defendant in this case, Your Honor.
Thank you, Ms. Eugene. Right. Well, I have to, pursuant to Osceola County's rules, I need to see them separately as they're being kept separate at the jail facility. So, Mr. Reisman, do you wish to have contact with Mr. Hurt?
Yes, sir.
All right. Do you have a means of communication if you fear further acts of domestic violence?
I'm sorry, sir. Can you say that again?
Of course. Do you have a cell phone or some way to contact law enforcement if you are concerned about further acts of domestic violence?
Yes, sir. Yes, sir.
All right. Thank you. Is it your desire to allow Mr. Hurt, as he is also accused, to return to the family home if you're in the family home?
He come to my house. Yes, sir. Yes.
All right. Thank you. Do you have any fear of Mr. Hurt if the court allows for non-hostile contact?
No, I have no fear, sir.
All right. Thank you. I do find probable cause for your arrest, the allegation of battery domestic violence related. I'm going to probably have you have a seat and then bring up Mr. Hurt to make some bond conditions determinations with Mr. Hurt. You guys cohabitate together under the same roof?
Partners, 25 years.
Gotcha. Understood. Okay. Mr. Reisman, if you'll have a seat for me, I'm going to bring up Mr. Hurt. Have the same discussion.
Your Honor, Mr. Hurt is being transported in here if we can get a moment.
Okay, not a problem. I'll circle back to Mr. Reisman's case.
Thank you.
Luciano Rivera.
President approaching, Your Honor.
Good morning, Mr. Rivera.
Good morning.
Mr. Rivera, you were here with us based on an allegation of battery domestic violence related. I have read the charging affidavit. I do find probable cause for your initial arrest. I see that we have a victim or a witness present. Ma'am, your name, please?
I'm the victim. My name is Cassandra Sagastume.
Thank you. All right. As in the other case, I'm going to be asking some questions if you wish to give me some information about conditions of bond and whether you wish to have contact with Mr. Rivera. We're going to swear you in at this time.
Okay.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Thank you.
If you will give me your name one more time now that you've been sworn.
Cassandra Sagastume.
Thank you. All right. I am finding probable cause of Mr. Rivera's initial arrest. I will appoint the Office of the Public Defender to represent his interests. Do you wish to let me know about your thoughts about contact and whether you wish to allow him? Do you guys live together?
No.
Okay. Do you have children in common?
Yes.
Is the child care visitation or the transfer of the children through some court order, or is that just between you guys?
No, between us.
All right. Thank you. Do you wish to have contact with Mr. Rivera?
Yes, because we have a special need child.
All right, thank you. Have there been prior acts of domestic violence?
If you talk about as claimed, no. Aggression, yes. I've been having a little issues with him, especially with our special needs son, of claiming of abuse, and I have seen him done. So you could say yes.
Do you have family members or friends that could coordinate visitation with your children?
No, we try not to involve. Him and I are pretty good at try to communicate much as I can. I communicate a lot on my part. It's just frustration just escalated. So I think after this, maybe we could sit down, talk, and go back to therapy, and maybe we could have a better relationship and understanding with each other because it's for the sake of the children. Because my son has clinical depression, also with autism, so he's needed present in his life. So.
Do you understand that the most protection the court would be able to afford you at this point is to order no contact and require that you maintain separate residences? You have requested contact. I would order that be non-hostile, but you guys would be on the honor system. Do you understand?
I agree to that.
Do you have a means of communication to call law enforcement if
social
you
media and
feared?
cell phone.
Let me-
Sorry.
I understand. Do you have a means of communication such as a cell phone to call law enforcement if you feared further acts of domestic violence?
Yes.
Right, thank you. Mr. Lopez, any questions for our witness?
No further questions, Your Honor.
Thank you. Ms. Eugene?
No questions, Your Honor.
Thank you. Ms. Rivera, you're in the best possible position to weigh whether you feel that you are in fear of Mr. Rivera or not. You have requested to have non-hostile contact or allow him to have non-hostile contact with you. The court is going to grant that request. I am going to require that you maintain separate residences, Mr. Rivera, from the mother of your child. As a condition of your, the court's going to set a bond in the amount of $500 plus those pretrial release conditions. Also a pretrial release condition, Mr. Rivera, you're not to possess any weapons or firearms. Do you understand, Mr. Rivera?
Yes, sir.
All right. No hostile contact means exactly what it sounds like. No threats, social media or elsewhere. No putting your hands on her without her permission, and no loud verbal arguments. The court could consider that to be hostile contact. Good luck.
That's fine.
Thanks. State of Florida versus Tim Spellman.
I just need some water.
Good morning, Mr. Spellman. Mr. Spellman, you're here with us based on an allegation of petty theft. I do find probable cause. You qualify for pretrial release. Sorry? We heard something out from there. It sounded like somebody said something.
It was the radio, Your Honor.
Got it. All right, Mr. Spellman, you qualify for pretrial release. You'll be released on straight pretrial release. And I'll appoint the Office of the Public Defender to represent your interests.
Your Honor, no return?
Sorry?
Can I ask for a no return?
Of course. Mr. Spellman, you're not to return to the scene where this is alleged to have occurred, which looks like the Walmart on 13th Street in St. Cloud. Thanks. State of Florida versus Kevin Hernandez, a.k.a. John Doe 3229.
Two cases for him?
I do. Thanks.
Your Honor, we would be waiving Mr. Hernandez's appearance. He's currently detoxing.
All right, thanks. Mr. Hernandez is with us currently on a trespass allegation 2022 MM 2464. The court finds probable cause, sets bond in the amount of $150, and will appoint the Office of the Public Defender to represent his interests. We will accept the waiver of his appearance. Unfortunately, he's out on bond on 2021 CF 13376 out of Orange County. The court's going to revoke his bond on that case. Set bond in the amount of none. He can make his pitch with the trial judge over here.
Your Honor, I apologize. Is that the false ID? I'm sorry, my paperwork is confusing at best.
Yeah.
Oh, never mind. Got it.
I do have 2 counts with a bunch of lines crossed through it. So looks like the allegations are trespass and false ID given to law enforcement officer. I'll set bond the amount of $150 is count 1 and $150 is to count 2. So total bond amount $300. These handwritten affidavits are a mess. And bond is currently set at none, revoked in 2021 CF 13376. Office of the Public Defender will be appointed on both cases.
Thank you, Your Honor. And Your Honor, we do have Mr. Hurt here.
Oh, wait.
Is that the same?
Yeah, we've got another case for Mr. Hernandez. Looks like that was reset by Judge Young. I'll appoint the Office of the Public Defender. Mr. Lopez, this is 2022 CF 376. Do you want to waive on that one as well?
Waive on that one as well, Your Honor.
Thank you. Court will accept the waiver. He's been arrested for possession of driving while license suspended and reckless driving. The court finds probable cause for those allegations. Set bond in count 1 in the amount of $2,500 as to count 2 in the amount of $1,000 as to count 3 in the amount of $1,000. And based on probable cause on that case as well, that will be another basis for the revocation of bond in 21 CF 13376.
Thank you, Your Honor.
Thanks. Mr. Lopez, who did you say was here?
Mr. Hurt, the co-defendant from the previous case, Mr. Reisman.
Thanks. Mr. Hurt, State of Florida versus William Hurt, please.
President approaching, Your Honor.
Thank you. Good morning, Mr. Hurt.
Good morning, sir.
Mr. Hurt, you were arrested based on an allegation of battery, domestic violence related. I took a look at the charging affidavit. I do find probable cause for your initial arrest. I'd like to get your thoughts, understanding that your partners with Mr. Reisman, whether you wish to have contact with Mr. Reisman and whether you wish for him to return to the family home. I will appoint the Office of the Public Defender to represent your interests as well. Do you wish to give me any information about those decisions?
I wish to have contact. Since I got hit by a car, I ran over by a car, he controls all my banking and everything.
All right.
And,
as to the issue of returning to the family home, do you have thoughts about that issue?
Oh, no problems at all.
Okay. Do you have any fear of Mr. Reisman should the court allow contact?
No.
All right. Thank you. Mr. Hurt, the court is going to sign a bond in your case in the amount of $500 plus the following pretrial release conditions. You're to have no hostile contact with Mr. Reisman. That means exactly what it sounds like. You've heard me explain that this morning. You will be allowed to return to the family home. And I've got no additional court dates for you at this point.
Okay.
Thank you.
Thank you, Your Honor.
Let's call back. Let's call back up Mr. Reisman.
President approaching, Your Honor.
Thanks, Mr. Lopez. Mr. Reisman, the court has previously found probable cause for your arrest. Your bond will be set in the amount of $500 plus pretrial release with the conditions that you have no hostile contact with Mr. Hurt. You've heard me explain exactly what that means, and you will be allowed to return to the family home. I have no additional court dates for you at this time.
Thank you.
Goodbye. Yes, sir. Mr. Lopez, I had a reset from yesterday on a Mr. Ramirez Rivera indicating that he needs the assistance of an interpreter. Is he present?
He is not present, Your Honor. Defense would be waiving his appearance. I believe he's still detoxing. Or he's
All right, thank you.
some medical condition currently.
Thank you. He's got two cases with us. The first case is 2022 MM2467. He also has a second case that's 2022 CF 3196. The court's going to appoint the Office of the Public Defender, accept the waiver of his appearance. I find probable cause in 2022 MM2467 for the allegation of criminal mischief and set bond the amount of $500. As to 2022 CF 3196, court finds probable cause of molesting a coin-operated machine with intent to commit a theft and criminal mischief of $1,000 or more. Bond in count 1 is going to be set in the amount of $2,500. Bond in count 2 set in the amount of $1,000. And I'll accept the waiver of his appearance on that case as well. Thanks.
Thank you, Your Honor.
State of Florida versus Gordon Vincent Harrison Smith.
Your Honor, the defense would be waiving his appearance, same situation as with Mr. Ramirez Rivera.
Thanks. Court's going to appoint the Office of the Public Defender to accept the waiver of his appearance. He is with us based on a failure to appear in front of Judge Epperson, underlying charges loitering and prowling. Judge Epperson set a bond in the amount of $250.
Thank you, Your Honor.
State of Florida versus Jose Perez.
Your Honor, we would be requesting a 24-hour reset. Mr. Perez is currently detoxing.
All right, thanks. We will reset Mr. Perez's case for tomorrow with the e-duty judge. State of Florida versus Quinto Parachon.
President approaching, Your Honor.
I apologize, Your Honor. I didn't catch the name. There was too much movement.
Defendant's name is Quinto Parachon. Pericchon. He's a reset from yesterday. Nope, he's not a reset. He's from today. Eugene, do you need to come up and take a look at this?
No, Your Honor. I was able to find it. Thank you.
Good morning, sir.
Good morning.
Pronounce your last name for me.
Parishon.
Mr. Parachon, you are with us based on an allegation of battery, domestic violence related. I have read the charging affidavit, and I do find probable cause for your initial arrest. Ms. Officer Jenkins, have we had any contact from the alleged victim?
Your Honor, there was no phone number provided.
Right. I do find probable cause. I'm going to set bond the amount of $500 plus the following pretrial release conditions. I don't have any input from the alleged victim, so at this point it's going to be no contact with Shirley Jimenez. Court's not going to allow Mr. Parachon to return to the Pacifica Drive address. I'll allow him to return one time with law enforcement to get some personal property while this case is getting sorted out, and I will appoint the Office of the Public Defender.
Thank you, Your Honor.
Thanks. Mr. Lopez, do you want to ask, it looks like they cohabitate, but do you want to ask off the record whether that's the case?
Sure, one moment, Your Honor. They do not, Your Honor.
All right. Who stays at the...
I rent an Airbnb, and she's at 12 Pacifica Drive.
Okay, so there'll be no return to the 1215 Pacifica Drive address.
I understand, sir.
Thank you.
Thank you, Your Honor.
State of Florida versus Mark Duran.
President approaching, Your Honor.
Officer Jenkins, the face sheet says that Mr. Duran has 3 cases. I only have affidavits for 2. Nope, I have 3. Take it back. Mr. Duran, you are here with us based on 3 separate allegations. One is driving under the influence. I do find probable cause for that allegation. I'll appoint the Office of the Public Defender, bond set in the amount of $500. That case is... That's the DUI. Charged by citation AFCJZGE. You also have a second issue with us. That's reckless driving. I do find probable cause for that allegation. That bond is going to be set in the amount of $500, and that's pursuant to citation AESR13E. You also have a new felony allegation with us. That allegation is possessing cocaine. I find probable cause for that allegation. Your bond set in the amount of $2,500. I know the court's going to decline its discretion to release you straight PTR, I will appoint the Office of the Public Defender to represent your interests. As a special condition of your bonds, you're not to drive without a valid driver's license. Thanks.
Judge, that was fine, not bond, West pretrial release.
That's correct. All right, I think that just leaves our interpreter cases. All right, thank you. Let me see if I can.
What's the very first?
Mute. More, let's see. Nope.
We might have to hang up with Osceola and start over.
Share, mute, more, add. There we go. Thanks for your help.
Good morning, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have not been sworn this morning, Your Honor.
Morning, Mr. Barreras. Let's go ahead and swear in our interpreter, please.
Can you raise your right hand, please? Do you solemnly swear to translate from Spanish to English, from English to Spanish, to the best of your ability?
I do.
Thank you.
Mr. Barreras, we have three folks that need your assistance. I'm going to have agency case numbers. I don't think I have actual case numbers. The first agency case number is going to be for George Lopez Rodriguez. It's 22I120685.
Thank you, Your Honor.
President approaching, Your Honor.
Thank you. Good morning, sir.
Buenos días, caballero. Good morning.
Sir, you were arrested pursuant to a warrant.
Señor, usted fue arrestado mediante una orden de arresto.
Judge Lattimore found probable cause for the allegations of fleeing or attempting to elude a law enforcement officer with lights and sirens activated.
La juez Lattimore determinó que existen indicios razonables por el cargo de fugarse o eludirse un agente del orden público con las luces y sirenas activadas.
She also found probable cause for the allegation of operating a motorcycle without a valid license.
Y también determinó que existe un motivo fundado de operar una motocicleta sin licencia válida.
You qualify for straight pretrial release.
Usted reúne requisitos para la libertad provisional directa.
We'll release you to pretrial release.
Lo vamos a violar bajo las condiciones del programa de libertad provisional.
As a condition of pretrial release, you are not to drive a motor vehicle without a valid driver's license.
Como condición de su libertad provisional, no se le permitirá conducir un vehículo a motor que no sea que tenga licencia válida.
Thank you, sir.
Gracias, caballero.
Count one is fleeing and attempting to elude lights and sirens.
Okay, what's the bond amount?
Such a bond in the amount of straight pretrial release.
Both counts.
That's
Okay,
right.
thank you.
And I can't recall if I appointed the Office of the Public Defender. I'll appoint the Office of the Public Defender.
Voy a designar las oficinas del defensor público si no lo había hecho anteriormente.
Thank you, Your Honor.
Ryan Montoya Aguilera. Mr. Barreras, the case number is 22-009669.
Thank you, Your Honor.
Good morning, sir.
Buenos días, caballero.
Sir, you were arrested based on an allegation of battery domestic violence related.
Señor, usted fue arrestado basado en una alegación de un cargo de agresión relacionado a la violencia doméstica. Yes.
I have reviewed the charging affidavit and I do find probable cause for your arrest.
He revisado el acta acusatoria y determino que existen indicios razonables para su arresto.
I will appoint the Office of the Public Defender to represent your interests.
Voy a designar las oficinas del defensor público para que represente sus intereses.
At this point, you're not to have any contact whatsoever with Gabriela Velasquez.
No se le permitirá tener trato con Gabriela Velázquez en absoluto.
You are to maintain separate residences from Gabriela Velasquez.
Se le exige mantener residencia separada de la señorita Gabriela Velázquez.
I will appoint the Office of the Public Defender to represent you.
Y voy a designar las oficinas del defensor público para que los representen.
Mr. Lopez, do you want to ask whether he needs to return for some personal belongings?
Licenciado López, ¿usted quiere preguntar si él necesita regresar a recopilar sus pertenencias personales?
Sure, Your Honor, one moment.
Sí, bueno, señoría, un momento.
500 plus pre-trial release.
No return is needed, Your Honor.
Thanks,
No
Mr. Lopez.
necesita regresar.
Thanks, Mr. Lopez.
Gracias, señor López.
Thank you, sir.
I apologize, Your Honor. Was it pretrial release or was it a $500 bond?
Both.
Su señoría, una pregunta, disculpe, ¿libertad vigilada o libertad provisional o una fianza de $500?
Your Honor, he doesn't qualify for pretrial release.
Su señoría, él no reúne requisitos para la libertad provisional.
All right. Bond will be set in the amount of $1,000 with those conditions as announced.
Entonces la fianza será programada en $1,000 con las condiciones que yo había indicado anteriormente.
Thank you.
Gracias.
Sorry about that. That's okay. State of Florida versus Luis Ramirez Lamort.
President approaching, Your Honor.
Thank you. Good morning, Mr. Ramirez Lamort. You have two cases with us.
Buenos días, señor Ramírez Lamort. Usted tiene dos casos con nosotros.
First is 2022 CF 3054.
El primero es el 22CF 3054.
That is pursuant to a warrant.
Según una orden de arresto que fue emitida,
Judge Nix Walker found probable cause for the allegation of petty theft with 2 prior theft convictions.
la juez Nix Walker determinó que existe indicio razonable para un cargo de hurto menor con 2 casos anteriores y condenas de hurto menor.
In that case, your bond is set in the amount of $1,000 with the following conditions.
En ese caso, se le programa una fianza de $1,000 con las siguientes condiciones.
You are not to return to the scene where the theft is alleged to have occurred.
No se le permitirá regresar al lugar de los acontecimientos.
You may not possess or consume any alcohol or illegal drugs without a valid prescription.
No se le permitirá ingerir drogas o alcohol a que no sea que tenga una receta válida.
The time you were arrested, apparently there was an allegation of a new offense.
Y en el momento que usted fue arrestado, existía una alegación de un nuevo delito.
That has an agency case number of 22L120955.
Con el número de agencia 22L120955.
Bonding, the allegations are possessing fentanyl,
Las alegaciones son posesión de fentanil,
possessing methamphetamine,
posesión de metanfetamina
and possession of drug paraphernalia.
y poseer parafernalia de drogas.
Find probable cause for those allegations.
Determino que existen indicios razonables para esas alegaciones.
Bond in count 1 is set in the amount of $1,500.
La fianza está programada en el primer cargo en $1,500.
Bond in count 2 is set in the amount of $1,500.
En el segundo cargo, fianza programada $1,500.
Bond in count 3 is set in the amount of $500.
Y en el tercer cargo, fianza programada en $500.
The Office of the Public Defender is appointed on both cases.
Se le designa las oficinas al defensor público en ambos casos.
Mr. Lopez, that was the last of the potential clients that we have on our list. Do you have anybody that has yet to be addressed?
That is all for this morning, Your Honor. Have a good rest of your day.
You as well. Thanks for your help this morning.
Thank you, Your Honor. The interpreter will be on standby for BRC.
Thank you. Have anyone identified any folks from our Orange County list that need the interpreter's services?
We have.
All right, thanks.
Your Honor, we're going to start with Spanish. The interpreter.
Yes, please. Thank you. Oh, Mr.
Your
Interpreter,
Honor, will you be calling back, Your Honor? I believe that's the normal procedure.
let me see.
Uh-oh. You stopped for 1 brief second.
Is anybody else having trouble hearing her?
Yes.
Yes.
And okay, we hear you now.
Mm-hmm.
Okay. Okay, go ahead, ADA Freeman.
Tell us your name and how you're employed.
Kyle Bradford, Clayton County Sheriff's Office.
And how long have you been working with the Clayton County Sheriff's Office?
About a year.
And is it Deputy or Sergeant Bradford?
Sergeant Bradford.
Sergeant Bradford, okay. Sergeant, were you working with the Clayton County Sheriff's Office on June 2nd of 2020?
Yes, ma'am.
And on that particular day, let's see, this says 15:30 hours. What is that in regular time?
3:30.
3:30. And that's that 3:30 p.m.?
Yes, ma'am.
Okay. On that particular day, were you working with the Cobra unit patrolling the area of Thurman Road and Conley Road?
Yes, ma'am.
Okay. On that particular day, was there a Deputy Washington who was also out there?
Yes, ma'am.
Were you working as his supervisor at that time?
I was.
Okay. And were you made aware of contact or that Deputy Washington had with a white Honda Accord for a defective center brake light?
Yes, ma'am.
Okay. Now, when Deputy Washington made that stop, were you also there?
Not at the time of the stop, no, ma'am.
Okay. When did you arrive there?
Upon the subject being, he tried to flee from the stop and he got tased.
Okay. And when you say the subject tried to flee, would that be Mr. Tillery or Mr. Frazier?
That would be Mr. Tillery.
Okay. And did you have contact with Mr. Frazier from the incident?
Briefly, just when I arrived. Yes, ma'am.
Okay. When you arrived on the scene, where was Mr. Frazier?
Give me just a second. I'm going to refer back to this if you don't mind. Okay, so both of them would have been in the car by the time I got there.
Okay.
Yes,
And from your review of the report, did Mr. Frazier also flee?
He did. Mr. Tillery.
Judge, I'm going to object to personal knowledge because this individual, Sergeant Bradford, doesn't appear that he was present until after a certain set of events occurred, and I just don't know that this witness has personal knowledge to give this testimony.
Response?
Well, Your Honor, the fleeing, I don't believe Mr. Let me double check before I answer. I don't believe Mr. Frazier was charged with the fleeing. I was just trying to get to I guess where the narcotics were located, and I believe that Sergeant Bradford was there, and so I can certainly move on, Judge.
I'll just put a pin in this, that certainly an officer can reply, respond, rely on a representation of another officer when they make their report. So personal knowledge is not absolutely required. If Sergeant Bradford spoke to or looked at the report and indicated there was something that another officer made in his report, then he can rely on what the other officer made in his report. So I just want to put the pin in that for your objection, Counselor.
Thank you, Judge. Sergeant Bradford, just so we can be clear with the testimony, tell us what was going on when you arrived on the scene.
By the time I arrived on scene, because initially when they put out over the radio that they had one running, I immediately started in that direction. By the time I got there, they had the Mr. Tillery in custody and Mr. Frazier in custody at that time. They were walking. When they walked Mr. Tillery back is when Mr. Frazier actually attempted to flee too. But they searched the vehicle once both of them were in custody. So I was on scene at that point, but I did not search the vehicle.
Okay. Can you tell us, based on your review of the report that was submitted from the search of the vehicle,
Yes,
what was located?
So both deputies stated to me and in the report that there was an odor of marijuana coming from the vehicle. In the back seat, there was a red bag on the back seat floorboard. Inside the bag was approximately 140 grams of a green leafy substance, which was identified as marijuana. There was a digital scale and also packaging materials known as like bags. There was also a firearm located in the center console. It was a Springfield Armory XD9. The weapon was checked over GCIC, but did not come back stolen at the time. And then when Deputy Myers was going after Mr. Frazier, he retrieved a bag from him. And in the bag was a suspected ecstasy, approximately 20 grams, and 4 pills that were later identified as acetaminophen with hydrocodone. Neither either Mr. Frazier or Tillery claimed possession or stated that any of the things found in the vehicle belonged to either one of them.
And just so we're clear, the suspected ecstasy and the 4 pills that were later identified as the acetaminophen with the hydrocodone, those were located in a bag taken from Mr. Frazier?
Yes, ma'am.
Were these items field tested?
Yes, ma'am.
And what were the results of the field test?
Let me just refresh my... the only thing that we would have field tested was the ecstasy. We don't field test marijuana.
Right.
But the field tested positive for methamphetamine.
And the marijuana that was found, were you able to observe the marijuana?
Yes, ma'am. Just from all the cases, I've made hundreds of cases, been to multiple controlled burns. I was able to identify it as marijuana.
And just so we're clear, where was the firearm found?
In the center console. And both subjects were checked criminal history, and both were convicted.
Okay. When you were on your way to the scene, and I know you touched on this because one of the charges regarding Mr. Frazier was an obstruction.
Yes, ma'am.
When you were there, you were able to hear from dispatch information regarding Mr. Frazier's status?
Yes, ma'am. Mr. Frazier was, he had active warrants at a Clayton County Sheriff's Office and the Forest Park Police Department at the time.
And when you were also there, did he remain on the scene at all times?
No, ma'am. He attempted to flee as well.
And which deputy apprehended Mr. Frazier?
Deputy Myers.
And was Deputy Myers also one of the deputies that you supervised?
Yes, ma'am.
You indicated that there was a scale and other materials found in the car. Is that correct, Sergeant?
Yes, ma'am. In the bag with the suspected marijuana, there was a digital scale and packaging material, things that are commonly used or found with large quantities of drugs for distribution, for packaging of narcotics.
Did all of this take place in Clayton County?
Yes, ma'am.
Sergeant Bradford, and I know you indicated Deputy Myers was also there. Based on the information that you reviewed in the report, was there anything else found on Mr. Frazier's person?
Your Honor, I'm going to object from Sergeant Bradford just reading directly from the report in response to the questions. If he doesn't know, that's fine. You can just say, I'm not sure. And then Ms. Freeman can ask him if looking at the report would refresh his recollection.
And we could go through an extra step if you want to, or we can just allow him to refresh his recollection.
Outside of the
Hold on. There is an objection on the table.
Well, Judge, I don't believe that Sergeant Bradford was reading straight from the report. What I asked him is from his review of the report, was there anything that Deputy Myers found on Mr. Frazier's person?
Okay, so you say not that he's not reading the report, he's just reviewing the report.
I think exactly. I think what Attorney Cleaver says that he objected to Sergeant Bradford reading. And correct me if I'm wrong, reading exactly from the report. And what I asked him is that from his review of the report, that he recalled did Deputy Myers find anything on Mr. Frazier's person?
Attorney Cleaver, is there any? Do you want to?
I'll withdraw my objection, Your Honor.
All right, thank you.
Just based off the knowledge that I had of when I arrived on scene and speaking with them and then reviewing the report, the ecstasy, the pills, he was being patted down. I know he had a small amount of marijuana. I think it was approximately 6 grams. And that was, I guess, prior to him fleeing the scene was when he was being patted down. And he located approximately 6 grams of marijuana.
Okay. And again, all of this did take place in Clayton County?
Yes, ma'am, it did.
Thank you, Sergeant. I believe that's all I have, Judge.
Okay, cross-examination, Attorney Cleaver.
Thank you, Your Honor.
Yes, sir.
Good morning, Sergeant Bradford.
Good morning, sir.
So if I understand it correctly, you did not arrive on scene at all until after Mr. Frazier was already in custody.
Yes, sir.
And now that we understand when you arrived, I want to back up to the initial stop of the vehicle. This vehicle was stopped because of a defective brake light and alleged window tint violation. Is that right?
Yes, sir.
But again, you weren't there to observe the headlight or the brake light?
Not the brake light. I did watch them test the window, and the window tint was 18%, which is under the legal limit is 32% in the state of Georgia.
And that would have occurred after the fact, though, right? Not during the time of the stop.
Go get him.
Well, I don't think that they put the window tint on after they were stopped, sir, but that's just going off what I was told by my deputy.
And then once the vehicle is stopped, you also were not present for that initial interaction between Deputy Washington or Deputy Myers and Mr. Tillery or Mr. Frazier.
No, sir.
So you weren't there when either Deputy Myers or Deputy Washington conducted an investigation as to who owned the vehicle?
No, sir.
So you don't know who owns the vehicle?
I don't. I just know who was in possession of it that day.
Do you know who was in the driver's seat?
If you allow me to refer back, because I've made a bunch of cases myself since then. That would be Mr. Tillery that day. Mr. Tillery was in the driver's seat.
And from your understanding and review of this case, was Mr. Tillery the owner of the vehicle?
I'm not sure, sir. I didn't run the tag myself, so I don't know for sure.
And you're relying on the police report in regards to this particular information?
As far as who owns the vehicle?
Correct.
I have no knowledge of it, and I don't believe it specifies in the police report who actually registered owner of the vehicle is.
Doesn't the report state that Mr. Tillery provided his driver's license to either Deputy Myers or Deputy Washington?
He did provide his driver's license, yes, sir.
And then you testified that there was an odor of marijuana in the vehicle?
That is what Deputy Washington and Deputy Myers both stated to me while on scene and in his police report. Yes, sir.
So your testimony nor from your memory, do you ever recall detecting an odor of marijuana?
I do remember seeing a large amount of marijuana that came out of the vehicle and smelling that while we were looking at it and taking pictures of it.
But again, you weren't there with Deputy Washington or Deputy Myers to detect that initial odor of marijuana, which led to the pat down of Mr. Frazier.
Was not.
And similarly, you weren't there to conduct the pat down or observe personally the pat down of Mr. Frazier.
No, sir.
You again personally did not observe Mr. Tillery flee the area.
Heard it on the radio, but I didn't see it with my own eyes.
You didn't personally observe Mr. Tillery be tased by Deputy Washington?
I did not.
You didn't personally observe Mr. Frazier leave the area?
No, but in regards to both of them, I did have to come and speak with him due to him being tased. I do know he was tased because he told me he was tased.
You didn't observe the marijuana or alleged marijuana being taken from Mr. Frazier's pocket?
No, sir.
So when you arrive, it's after everybody's already in handcuffs, or are they in handcuffs, or are they in the car, or both?
They're in handcuffs. Excuse me, they're in handcuffs.
Standing outside the vehicle?
No, they were inside a patrol car when I got there.
Together or separate patrol cars?
If I recall correctly, they were in separate patrol cars. It was in the gas station parking lot. I don't remember exactly.
Now, you say you had a very brief contact with Mr. Frazier. Is that right?
I mainly had to speak with Mr. Tillery in reference to the use of force for him being tased. I just spoke briefly with both of them. Yes, sir.
What was your conversation with Mr. Frazier?
To be honest with you, I don't remember. He wasn't tased, so as far as the use of force, it wasn't really needed to speak with him much. I mainly needed to speak with Mr. Tillery, who got tased, advise his injuries and stuff like that.
So basically your whole role or your purpose of being present during this investigation is to speak with the individual who was tased.
Well, that's part of being their supervisor, but also to arrive on scene to see what they have and what's going on. Yes, sir.
And I think your direct testimony was that you were not present or you did not observe the search of the vehicle.
I didn't.
So again, you're relying on the statements of others to describe where things were found.
I'm relying on the deputies. Yes, sir.
So you didn't personally observe any of these items in any of their described locations?
I did not.
So based on your own personal observations, you don't know what items belong to who?
No, sir. Based off what I read, neither one of them claimed anything.
But based on what you saw when you were there personally, you don't know what items belong to who?
I know what my deputies told me.
I understand that. The firearm, was that checked to see if it was stolen?
Through GCIC, yes, sir.
And that result came back negative for stolen?
At the time it did. I haven't followed up. I know sometimes they're just not on GCIC, but as far as that day, it did not come back stolen on GCIC.
Was there any indication of who the firearm might be registered to?
That's something that has to take place afterwards. And like I said, I haven't followed up on that particular firearm to see who actually owns it.
So at this point in time, we don't know who the firearm is registered to?
No, sir.
What does it take to determine who a firearm is registered to?
Our evidence custodian conducts the ATF trace, and all that does, though, that traces it back to actually who purchased from whatever store. But then they have to reach out to them and ask, do they still currently own it? Did they sell it to somebody? If they did, who did they sell it to? So, I mean, it could be hit or miss. That's something I could follow up with, but I have not had a chance to follow up on.
Now, you're the supervising sergeant of these two deputies, correct?
This is correct. Yes, sir.
Do you know why they searched the vehicle?
The odor of marijuana.
Just based on the odor alone?
That's probable cause in the state of Georgia.
Do you know if they had been arrested prior to the search?
I don't believe that would be the case, because that doesn't make sense or go with what the report says.
So you don't recall any statements that Mr. Frazier might have made to you?
Not to me. No, sir. Now, if he made a statement to someone else, I can't even tell you that because I'm not sure either.
So even if he had discussed with Deputy Washington or Deputy Myers the circumstances of what had happened, you wouldn't know what was said?
I wouldn't. No, sir.
You don't know the circumstances of why either Mr. Tillery or Mr. Frazier ran on foot?
I know Mr. Frazier had active arrest warrants and also a bunch of drugs located on his person. And I know Mr. Tillery, there was a bunch of drugs pulled out of the car with a gun. So to me, that sounds like a pretty good reason to run.
You testified that there was a red bag with marijuana and packaging materials in a digital scale.
Yes, sir.
That was, your testimony is pursuant to the search, that was located in the back seat floorboard?
Once they searched the car, that was located in the back seat floorboard. Yes, sir.
You don't know which side of the vehicle, passenger or driver side floorboard?
I don't want to. Give me just a second so I can tell you for sure. I'm going to just briefly look at it again. I couldn't tell you if it was the driver's side or passenger side. No, sir.
And for the center console, do you know at the time of the search of the center console whether the center console was open or closed?
I don't. No, sir.
So in regards to the firearm in the center console and the red bag in the back seat, you don't have any knowledge that Mr. Frazier would have known those materials were in the vehicle?
I couldn't tell you for sure, no, sir. I know that the bag that was covered off of his person when he fled on foot.
That's on his person, but the bag in the back seat, did the search reveal any identifying information about who the bag might have belonged to?
I believe so, no, sir.
And you never made any inquiries or between either suspect about who belonged to what or what belonged to who?
Outside of them, the deputies on scene speaking to them about that, that's not something I would come out on scene and do. I don't step into their particular cases, but based off what I read from the report, neither subject claimed possession of any of the items located.
So Mr. Frazier, according to the report, never admitted to possessing those items?
Correct.
No further questions, Your Honor.
Redirect.
Just 1 minute, Your Honor. Your Honor, I don't have any further questions.
All right, any other witnesses for the state?
No, Your Honor.
Okay.
The state rests.
Any witnesses for the defense, Attorney Cleaver?
No, Your Honor.
Argument?
State waives opening.
Your Honor, can you hear me?
Absolutely.
Okay. All right. So, Your Honor, when looking at this investigation, who is our best source of information? It's going to be Deputy Myers and Deputy Washington. They're the ones who observe a traffic violation. They're the ones who conduct the stop. They're the ones who have personal contact with Mr. Frazier and Mr. Tillery. They have there's an exchange of driver's licenses. They get them out. There's a detection of odor of marijuana. They get them out of the vehicle. And then, according to the testimony, Mr. Tillery flees on foot, and then Mr. Frazier later does. That would be great if we heard this, and then the search is conducted by these two deputies, but that'd be great if we heard the testimony from them. But unfortunately, that's not the source of information presented to Your Honor. We're getting this information to Your Honor secondhand through Sergeant Bradford, that he arrives way after the fact. He doesn't get there until, per his testimony, both individuals are in custody and an arrest decision has already been made. He has brief contact, in his words, with Mr. Frazier, but he can't remember what was said. He can't remember. He doesn't know what statements were made either by Mr. Frazier or by Mr. Tillery. He's relying entirely on secondhand information from these other two deputies. He doesn't know how the search was specifically conducted. He's stated specifically to Your Honor, he doesn't know what items belong to who. He could only surmise that the items found on Mr. Frazier, which was some marijuana in his pocket, and I think hydrocodone and ecstasy pills were in his backpack on his person. Your Honor heard testimony that the firearm was located in the center console. There's no inclination of who owns the firearm. We do know that Mr. Tillery's the driver of the vehicle. Presumably he owns the vehicle, but there's not even information presented to Your Honor by the state that, well, this, the vehicle's registered to him, that the driver's license was checked out. But it seems to be that it's Mr. Tillery's vehicle. He's got a gun in his center console, which is closed, and he's got a bag in the back seat that's closed, that Sergeant Bradford also testified that he's not sure who it belongs to. There's no follow-up investigation on the firearm. he doesn't know specifically in the back seat where this red bag with the marijuana scale and packaging materials are located. I don't know if he's the one who conducts the field test. It's just very attenuated, his testimony, Your Honor. And I don't believe there's sufficient evidence to support a probable cause determination for the marijuana that's found in the red bag, for the trafficking material or the scales or the packaging, which is supposed to support the state's possession with intent to distribute charge. There's no inclination that Mr. Frazier ever knew that those materials were in the vehicle. There's no indication of the circumstances of why Mr. Frazier was in the vehicle in the first place. We're just not getting good information from Sergeant Bradford. I understand these other witnesses might not be available, but they would be the best source of information for the court to make a good, for the court to be fully informed about whether there's probable cause or not. At most, Your Honor, I would say there's probable cause to support charges for the items that are found on Mr. Frazier's person. What the ecstasy and hydrocodone pills in his backpack and the marijuana found in his pocket, but not in relation to the firearm that's in the center console, not in relation to the marijuana, the felony amount of marijuana that's found in the red bag, nor the possession with intent to distribute based upon the packaging materials or the scale. I'm just looking over my notes here, Your Honor. Don't want to miss anything. And there's no conversation between Sergeant Bradford and Mr. Tillery that could give the court some additional information. It's just all based, and I know hearsay is admissible at these types of hearings, but it is hearsay information. I think that is part of the court's analysis in just determining the credibility and weight that should be given to the evidence presented. So in our estimation, Your Honor, there's probable cause for the items that are found on his person, but I don't believe Mr. Frazier knew, and they have to prove knowingly possess. Just because they're in the car with him and he's a passenger doesn't mean he knew about those items. And even with a lower standard of probable cause, I still don't believe there's sufficient evidence. So I would ask Your Honor to dismiss those charges.
Right. Thank you, Counselor. A.D. Freeman.
Thank you, Your Honor. So first, I would like to say a lot of what Attorney Cleaver wants to argue is certainly for whether it's suppression motions or arguments to be made in Superior Court. And while I understand what he would like for the testimony to be, you know, at this stage, we believe that the testimony from Sergeant Bradford, who was a supervisor of Deputy Washington and Deputy Myers, was sufficient. I would like to say that one of the things Attorney Cleaver indicated, and it was misstating the testimony of Sergeant Bradford. He said that Sergeant Bradford stated that, or that he said something to the effect of that he didn't recall if anybody made any statements to talk about their circumstances. What Sergeant Bradford testified to was that based on the report that no one claimed the items that were located. And he could certainly review that information from the report. And Mr. Frazier's not charged with anything regarding the stop, regarding the defective equipment or anything of that nature. Sergeant Bradford did testify to, he was aware that Mr. Frazier did try to flee, and that's when Deputy Myers located the items located on his person, which were the ecstasy and the items that were located in the car, Your Honor, was that based on the testimony from Sergeant Bradford, which he based it on the information that he received from his two deputies with the gun that was found in the center console, as well as the other items that were found in the bag. There was a digital scale, which certainly in the packaging materials would certainly go to the possession with intent to distribute. And then the gun, we heard Sergeant Bradford testify that Mr. Frazier did have active warrants, and so we were asking at this point that all the charges be bound over to Superior Court.
All right. So I have a problem with this case. First of all, that center console, was it open? Was it closed? If it's closed, you can't impute the ownership, the possession, even if Mr. Frazier had access to the center console. If it's open, then you got a better argument. If it's closed, he's not the driver. So, and I agree with Attorney Cleaver that Sergeant Bradford was not the best witness to bring for this particular hearing, because if I have questions, then you know I'm not going to find probable cause. So I'm going to tell you where we are. I do not find probable cause for the weapon, because there's no testimony, there's no information as to if that console was open or closed. Bradford never said, I don't know. And if I don't know, I'm not going to assume otherwise. So I don't find probable cause for the two weapons. Well, one weapon, two charges, so that's gone. And that's warrant number, that's the 1611-131, possession of firearm by a convicted felon, and possession of firearm during a crime, 1611-106. Those are both gone. I don't find probable cause for either one of those. The VGCSA, there's two VGCSA schedule. I guess those are for the, hold on, let me go back to the notes. All right, so there was ecstasy and hydrocodone. I find probable cause for 16-13-30 twice. Those two warrants I find probable cause for. The possession of marijuana, I believe the marijuana was in a red bag, 5 ounces of marijuana in a red bag on the floorboard of the back seat. I do find probable cause for obstruction, possession of drug-related objects. Those, apparently there was a digital scale. I wouldn't have understood this until Attorney Cleaver brought it to my attention. There was a digital scale in the bag with the marijuana, and that red bag was in the rear of the vehicle, on the floorboard of the back seat. I'm going to find probable cause for the marijuana. Everything except for the two weapons is what I find probable cause for. And that's it.
Judge, maybe Sergeant Bradford be excused.
Yes.
Thank you, Sergeant.
Thank you, Your Honor.
I'll give my arm a second. No problem.
All right. So I think that Attorney Reddick wants to talk to her client at the jail. Powell, is your client?
Yes, Your Honor. Yes, Your Honor.
All right, let me bring you to breakout room 3. No, 2. I'm going to move you to breakout room 2. And then I'm going to move the jail to breakout room 2 as well. So Attorney Reddick can speak with her client, Mr. Powell. If you would bring him to the podium and let him speak to his attorney.
And I think Attorney Cleaver was still there, and Judge, Attorney Cleaver and I had been going back and forth about a bond. And what I just text him, if he wants to respond to my text before he leaves off, because I think Mr. Frazier, he's not on a bond calendar until the 4th.
You're right, Ms. Freeman. I think it's September 4th at 8 a.m. is when we're scheduled for a bond hearing date.
Mm-hmm.
Okay.
And so, given that the 2 weapons charges were dismissed, the amount that you were asking me for, I will consent to it if you want me to write it up.
Let me just absolutely confirm that with Mr. Frazier before, just in an abundance of caution, just to let him know what your most recent offer is. That way I can get his express permission, and then we can take care of it.
Okay, and the jail went away. Or is the jail in the breakout room, Judge?
They're in the breakout room.
Oh, okay, okay.
Attorney Reddick is speaking with her client, Mr. Powell.
Okay. So, Casey, if you want to wait to see if you can get a breakout room.
Sure.
Okay.
Do you need to make a call to where are you supposed to be? What county did you say you're supposed to be?
Gwinnett County, Your Honor. They're in a Zoom. I think we're pretty far down the calendar. And I had emailed the solicitor handling the case that I was before Your Honor. So I don't think it'll be an issue if I sit for another couple minutes to let Mr. Frazier know.
All right.
And Your Honor, I have an updated announcement if that's possible.
All right. Absolutely.
After speaking with Mr. Beatles, he referred me to a family friend who indicated that they in fact had hired an attorney. I'm not sure if that attorney received notice. He was able to give me the last name of the attorney as well as the attorney's phone number.
Who is the attorney?
The last name is Heron, Herron, Heron.
Okay.
Does the court want the phone number also?
I don't. I'm not going to call. Ms. Moultrie, can you send a chat to Ms. Moultrie? Let me come off YouTube. All right, we are now on YouTube. All right, very good. So let's go ahead and start over. Officer Joseph, you have been sworn in. Attorney ADA Freeman, you were asking him about where he was employed and how long he was employed. Detective.
Yes, Detective, you can repeat that. Tell us your name and where you were employed and how long you've been employed there.
Detective Henry Joseph, Clayton County Police Department. I've been employed since May 23rd of 2016.
Detective, were you working with the Clayton County Police Department on July 25th of 2020?
Yes, ma'am.
And around that date, did you receive an assignment to investigate the case involving a victim, Frank Satera Salvatore?
Yes, ma'am.
And did this involve our defendant, James Brown?
Yes.
How did you get involved in this investigation?
And I was on call for that week, for that weekend, and basically I got called out by Sergeant Sawyer. We got called out to Southside Inn, 6370 Old Dixie Road, in reference to a vehicle, the victim's vehicle, crashing into the hotel, one of the hotel rooms. Then during the investigation, excuse me, my son. Hey, go over there, please. I'm on the phone. Okay, well, go pee. Excuse me. I'm sorry. Okay, go ahead.
If you could, I think you were telling us, so was there a call regarding an accident?
Yes, there was the initial call was a vehicle crashing into one of the rooms out the south side end over there at 6370 Old Dixie Road. Upon arrival, officer made contact with the victim, who was in the driver's seat of the vehicle. He stated that he had been shot. They observed a gunshot wound to the right side of the back of the victim.
When did you arrive on the scene?
Once uniform, upstairs. Excuse me. Go upstairs now.
Detective, you make sure.
I apologize.
No, we understand. Make sure you mute yourself when you have to do that. Yeah. So you were saying, did you go to the scene?
Yes. Once officers got the victim transported to the hospital, once they, blocked off the area, they contacted Criminal Investigation Division, and that's when we responded out to the scene.
And just so we're clear, when you got to the scene, the victim had been transported for...
Yes, the victim had already been transported to AMC. When I got there, the vehicle was still, of course, was still inside the hotel room, crashed.
And just so we're clear, you said this was at, the car went into a hotel room?
Yes, over at the south side end.
So when you got there, were you able to speak to any witnesses about what happened?
No, I spoke to the officers that were on scene, and they stated that during the investigation, they found skid marks from the hotel next door, the American Inn Suite, 6358 Old Dixie Road. They could see that the skids led to the south side in which he struck into the hotel room.
With that information, did you go to that hotel to try to speak to anyone to see what happened?
Well, once I arrived on scene, officers had already obtained written statements. They talked to witnesses. Not two of the witnesses, but the victim did hit two vehicles during the incident.
And what else did you learn from the statements that had been gathered from the scene?
Well, what we learned during the investigation was that we observed video. We looked at video surveillance during that time of the incident, and we observed the black Chevy Impala that the victim was inside, and we observed through the victim sitting inside the vehicle, and we observed three of the males outside of the vehicle, standing around the vehicle.
Where was the video surveillance from?
American Inn Suites, next door to the South Side Inn Suites, where the victim struck his vehicle into.
What were you able to gather from watching the video surveillance?
What we gathered from was what we see. The first initial watching the video, we see that the victim is in the black Chevy Impala. We see three males outside standing. We see the defendant, James Brown, enter the front passenger side of the vehicle, and we see the one of the other suspects standing outside, and then we see another suspect enter the rear side of the vehicle. Once that third suspect enter the rear side of the vehicle, you see the victim jump up. Once the victim, you can see him jump up, and you see him put the car in reverse, and the car immediately reverses. One of these suspects is still standing there watching the vehicle reverse. When the vehicle reverses, you see the suspect walk off, and then you see the vehicle come, because the vehicle, when it reverses, it leaves the screen, and you just see one of the suspects. Then when the suspect leaves and walk off, you see this black Chevy Impala come back across, and you see the vehicle speeding ahead of the south side end, which it struck one of the hotels on the other side.
Could you tell when the car came back across? Could you tell if the defendant, James Brown, and I think you said another occupant, were still in the vehicle?
No, you could not tell due to how fast the vehicle was crossing the screen when you watch it. But when the vehicle did reverse, James Brown and the other suspect, Demetrius Tarrant, was in the vehicle. The only person that was not in the vehicle was the other suspect.
Were you able to determine, I guess, what went on in the vehicle or before they got in the vehicle?
We could not tell what was going on between all parties. All we know that basically something occurred to where the victim reversed his vehicle and wind up, putting his vehicle forward and crashing into the hotel room. That was the first initial. We didn't know, but of course, gathering more information, we found out that it was a drug deal gone bad, a planned armed robbery.
And how were you able to determine that, Detective?
Well, this happened early Saturday morning. Monday, the 27th, one of our sheriff deputies, well, let me back up. During the investigation on Saturday, we found that there was a white Toyota RAV4 that was leaving the scene, okay? So that Toyota RAV4, basically, we put out a bolo for that vehicle, that all officers in the county look out for that vehicle because it is in relation to an incident that occurred with the victim. On Monday, one of our sheriff deputies seen that same RAV4 in the same property of where the incident happened at 6358 Old Dixie Road, okay? That deputy made contact with one of the suspects, D'Angelo Millette. He was involved in another incident where it was another incident where he was detained. The deputies called us and told us that we might have somebody that was involved in the incident. So myself and another detective went out to that locate 6358 on the 27th and made contact with D'Angelo Millette, the suspect. He came back to our headquarters. He spoke with us, read a Miranda, and he stated that there was a planned drug deal that basically went wrong. James Brown and Demetrius Tarrant was part of that drug deal that went bad.
Detective, this was information gathered from Mr. Millette?
Yes, Millette, yes. During the interview, he basically stated what happened. It was a drug deal that gone bad, involving heroin. He stated that James Brown and Demetrius Tarrant planned to buy drugs or sell drugs to the victim.
Were you able to speak to the victim at all during this investigation?
No, the victim is not responding. The last time I went to the hospital at AMC, he's paralyzed from the waist down, and he's not even awake.
Were officers able to locate anything in the victim's vehicle regarding what was going on?
On that's the 25th of when the incident happened. No, but we did get a search warrant for the vehicle, which I executed that search warrant that Monday, the 27th, which I found clothes, money, and I did find what looked to be cocaine, or it could be some other drug substance wrapped up in a dollar bill.
Were you able to get a statement from the defendant, James Brown?
No, I interviewed him. It was audio recorded.
Did Mr. Brown make any admissions about this drug deal gone bad?
Yes, when we got the warrants for James Brown, because D'Angelo Millette stated that he identified James Brown as being on the scene, the one in the vehicle with Demetrius Tarrant. So when we got the warrants for him, and when the fugitive unit from the sheriff's department was able to go and get Mr. James Brown, of course, I spoke with him about the incident, He stated that on that day, on the 25th, he was working at the Texaco. Okay. A female that he knows around the neighborhood named, I think, Joyce, he stated, came to him and stated that the victim wanted to buy, I guess, heroin. Okay. So he met with that victim, and the victim told him that he wanted to buy some heroin, but he needed to get some money. James Brown stated that the victim went inside the Texaco over there on Terra Boulevard, Upper Riverdale Road, and I think he said he took out $40. Okay. James Brown stated that him and the victim drove to 6358 Old Dixie Road over there at the American Inn Suites. As the victim was waiting inside his vehicle, James Brown went around different rooms trying to find someone that had heroin so he could sell it to the victim. Okay. James Brown said he went to a couple of people to try and try to find out who has heroin so they can sell it to the victim. James Brown stated that he met with D'Angelo Millette, who he called Hit. He identified D'Angelo Millette. He said that Hit didn't have any heroin, but he's gonna call Truth. He called him Truth, which he identified as Demetrius Tarrant. He basically said Hit D'Angelo Millette called Demetrius Tarrant. Demetrius Tarrant came to the location, 6358 Old Dixie Road, and basically he told him that, hey, your victim wants to, buy some heroin. But I think he did say that they didn't have any heroin, but cocaine. It was cocaine. The initial thing was cocaine. He wanted some cocaine. But when Tarrant got on scene, they said that they didn't have any cocaine. But the James Brown said, okay, well, the victim says he has heroin that he's going to sell and that he has a gram. So he said they walked up to the vehicle. He walked up with D'Angelo Millette and Demetrius Tarrant inside to the vehicle. He got inside the passenger vehicle, I guess to do the drug deal. He stated that D'Angelo Millette and Demetrius Tarrant was there behind him. He stated that if I can remember that, he stated that he don't remember him getting in the vehicle, but he thinks he said somebody did get in the back of the vehicle. He doesn't know if it was Hit or Tarrant. He said as he was sitting in the vehicle, he said some words was exchanged between the victim and Demetrius Tarrant, and basically a gun went off, and the vehicle went in reverse. He said when the vehicle went in reverse, it crashed and hit two vehicles, and basically him and Demetrius Tarrant got out the vehicle and ran and left the location. James Brown left with the shooter, Demetrius Tarrant, left the location and drove to Econo Lodge on Upper Riverdale Road with Demetrius Tarrant, the shooter. He stated that. Go ahead.
You said they drove to Econo Lodge?
Yes. Well, the Demetrius Tarrant drove a brown Buick, which James Brown got inside the vehicle with him and left the scene and drove to Econo Lodge. James Brown said he seen the weapon that Demetrius Tarrant used to shoot the victim while they were inside the hotel room at the Econo Lodge up Riverdale Road. James Brown stated that he seen sheriff deputies arrive on scene at 6358 Old Dixie Road due to the victim crashing into the hotel room. I said, well, why you didn't call the police? Why you didn't go back over there? He said he was scared. I said, and he had enough amount of time. He said that he wasn't involved. He didn't know they was going to rob him. But I said, you had enough amount of time to tell the police what happened. Mr. James Brown facilitated this drug deal. He planned this drug deal with Demetrius Tarrant and D'Angelo Millette, which led to the victim being shot in the back, which the victim is now paralyzed from the waist down. I can't hear you.
Did all of this happen in Clayton County?
Yes.
at this point, Detective, have you all been able to arrest Mr. Tarrant?
No, we have not. The last time I checked, he was still on the run, I guess. And I asked James Brown, does he know where Mr. Tarrant might be? Demetrius Tarrant. He said by now he should be in Detroit. So I'm still working on trying to find out where he is. But we do have James Brown, of course, in custody, and we have D'Angelo Millette in custody as well.
Judge, I believe that's all I have. Thank you.
Okay, cross-examination, Attorney D. Williams.
I have some questions leading up to the actual accident, okay? You said that Mr. Brown told you that he met Mr. Salvatore at the Texaco?
Yes, on Cherry Boulevard in Upper Riverdale, yes.
Okay. And did you go to that Texaco to verify his story?
No, I didn't know. I did not do that yet, no.
Okay. And were you guys able to find Joyce to verify that part or no?
I actually was looking for Joyce a week and a half ago and I could not find her. I actually live in the area and I think I know who he's talking about, but I have not been able to find her.
Okay. And was Mr. Salvatore a guest at the America's Inn and Suites?
Was he a guest? No, he was not.
Was Mr. Brown a guest at American Inn and Suites?
He said he lived in a shed on property. There's a shed back there somewhere on property. But he does live on property over there at 6358 Old Dixie Road.
Okay. And what about Mr. Mallet? Did he have a room there?
Mr. Mallet, no.
And did Mr. Tarrant have a room there?
No, Tarrant is at Econo Lodge.
Oh, okay. Do you know how many days Mr. Tarrant was at the Econo Lodge?
No, I do not.
Okay. And I know you said you watched the surveillance. So was anyone in Mr. Salvatore's vehicle when you drove into the parking lot of American Inns and Suites?
Well, when we see the vehicle on the video surveillance, I mean, talking about the initial incident with the vehicle reverse and everything, we just see him we just see him inside the vehicle at first, and then we see James Brown, Demetrius Tarrant, and D'Angelo Millette walk up to the vehicle, and then you see James Brown enter the front passenger side of the vehicle.
Okay. So when he drives up initially into the hotel, you can't really see in the vehicle?
No, I didn't know.
No, okay. And did you see Mr. Brown knocking on room doors at the hotel?
No. He stated that's what he was doing.
Oh, that's what you stated, but you didn't see that on surveillance?
No.
Okay. And so all three defendants got into the vehicle?
James Brown got into the vehicle, and Demetrius Tarrant got into the vehicle. D'Angelo Millette was standing outside the vehicle while they were doing the drug deal.
Okay, so he never got in.
D'Angelo Millette did not. He never got in. He would open the back door, look in, but that's it.
Oh, okay. So the surveillance that you viewed, how far before the accident did you view the video?
Say that again?
For the video the surveillance that you viewed, how far in advance after the accident, before like when the accident happened, did you watch it like 20 minutes in advance before the accident happened?
No, we just watched when the initial incident, because some of the cameras at the hotel did not catch everything. So we basically that was a good shot that we had, and we focused on that shot because that's the important shot where the incident happened, where he was shot, where the vehicle reversed, and when the vehicle drove past and went into that hotel room.
And did the surveillance have sound?
No.
And did you get a copy of the surveillance footage?
Did I get a copy of the surveillance? Yes, we did. Our CSI obtained that surveillance footage.
And is that part of the file you will provide to the DA's office?
I'm still working on the file. The file is not, the case is not closed yet. We haven't got Demetrius Tarrant yet. So the case is, we're still gathering more evidence.
Okay. Have you turned over this? Never mind. Okay, so we're going to talk about the actual accident, okay?
Yes.
I just want to make sure I have all the defendants in the proper location. So you had Mr. Brown in the front passenger seat?
Yes, in the front passenger seat, yes.
And Mr. Tarrant was in the back, right behind Mrs. Salvatore, or behind Mr. Brown?
Behind James Brown.
Behind James Brown. Okay. And I saw on the warrant that Mr. Malik got hit by a car door. So which was the door open?
Demetrius Tarrant door was open. His door was open because when Demetrius Tarrant went inside the rear passenger vehicle, when he opened that door, it's like he instantly pulled out the weapon, because you could see once he opened the door and once he gets in, the victim jumps up. So he instantly pulled out that weapon, and that the door still open. So when and matter of fact, I take that back. James Brown door was open as well. When he reversed the vehicle, James Brown, the side of the vehicle he was on, that door hit D'Angelo Millette and spun him around.
Okay, so Mr. Brown's door is open, Mr. Tarrant's door is open, and when the vehicle backed up, both doors are open.
Mm-hmm.
Okay, okay. And Mr. Malik was standing next to the rear passenger door.
Mr. D'Angelo Millette was standing like in between it.
Okay, okay. And were the Impala windows tinted?
No, it was not.
And Mr. Salvatore has his back against the window because of the, I guess, because of the commotion.
If you're looking at me right now, when Demetrius Tarrant enters the vehicle, you could see the victim go like this, and that's why he got shot on the right side of the back. In the back, he got shot on the right side because he does this, and then when he reverses, he's still at that position because he sees the gun.
Oh, I see. Okay, okay. So on the surveillance, you're actually able to see Mr. Tarrant shoot Mr. Salvatore.
And you look at you cannot see the gun, but you could see the victim's movements. You could see him jump up.
Okay. Oh, so you can't actually see the gun shoot him?
No, you can't see that. You just see his maneuvers to the victim.
Okay. And the two vehicles he hit the white RAV4?
No. He hits two other vehicles.
Do you know the type of vehicles they were?
The type of vehicles, I'll have to refer to I'll refer to my notes. Give me a second. He hit a Dodge Caravan and a Ford Fusion.
Okay. And was anyone injured when the victim went in reverse?
As far as all parties involved in the incident or other bystanders?
Bystanders.
No.
No. Okay. And when he put the car, Mr. Salvatore put the car in drive?
I take that back. I take that back. When the vehicle reversed, no. But when the vehicle went forward and hit and went inside that hotel room, yes. I think the lady she suffered minor injuries, but she wasn't transported.
Okay. And that was Route 119 that the vehicle hit, correct?
Yes.
And were you able to get a statement from the young lady?
Oh, I'll have to look at the case file.
Do you know the victim's name?
You talking about the victim of the shooting?
No, the one who got that was in the room 119.
No, I'll refer to my notes. Give me a second. No, we don't. Not at this time. No, not at this time.
Okay. Do you know which EMT treated her at the scene?
Plain County EMS. You want the end? It was engine 1.
Now I want to talk about what happened immediately after the accident.
Mm-hmm.
Which officers were on scene?
What officer was on scene? We had the first initial officers. We had Officer M. Anderson, Sergeant McDaniel, Lieutenant Thrift, Officer Branham. Yeah, that's who I seen when I arrived on scene.
Okay.
But M. Anderson, Officer Anderson is the reporting officer, and Sergeant McDaniel was also on scene as well.
And do any of them have dash cam?
Body cam, yes.
Okay. And you said that Mr. Brown and Mr. Tarrant ran. Which direction did they run into?
We don't know. All we know that when that vehicle reversed, of course they got out the vehicle, because when it went back and crashed, they went inside the vehicle. So we don't know that area where he reversed. There's only one way to run, and that's towards Old Dixie, because that way is blocked off. So they have to run towards the Old Dixie Road. There's no other way to run to, or towards the hotel in between the halls. That's the only way they could run to, because you don't see them. You don't see them on camera. So if they're back in the vehicle, they're going to run to the nearest getaway area, which is I guess like the far right side edge of the hotel.
Okay, but you weren't able to see them running on surveillance, just the actual accident.
Mm-hmm.
Okay. So you don't even know where Mr. Mallet walked to after he got hit by the door.
No, he just walked off. And he said he walked off and he went to,
Okay. Do you know which EMT responded to Mr. Salvatore's injuries?
Talking about the EMT, it was engine 1. Engine 1.
Oh, so the same one. Okay.
Yes.
AMC, what's AMC?
Atlanta Medical Center.
Oh, okay. So Mr. Salvatore wasn't able to speak to officers that night?
Not about in detail, as far as in detail of the incident. When the officer arrived on scene, when he was in the vehicle, he just stated he had got shot. He got shot.
Okay.
Mm-hmm.
So that was just on this. So when was the last time somebody spoke to Mr. Salvatore or tried to talk to Mr. Salvatore at the hospital?
I tried to speak with him. He cannot speak. He's not even awake.
And when's the last time you went to the hospital?
This was about two weeks ago.
Okay.
I don't. Matter of fact, I have my notes of when I went. Give me a second. Okay, August 4th. I was there August 4th at 1700 hours. I was at Atlanta Medical Center in an attempt to talk to Mr. Salvatore, but like I said, he was not able to talk because, of course, he's not awake.
Is the hospital listing him as critical condition?
He's stable now. When the nurse told, when I talked to the nurse, he's stable.
Okay.
But he does have a feeding tube and a ventilator.
Okay. So when the officers are trying to talk to him, that's all on body cam, correct?
Yes, that should be on body cam. Yes, we have body cam, so that body cam, I mean, should be on there.
And that's part of the file that you're going to provide to the DA's office?
Body cam is on Avail, so you guys will be able to obtain it.
Okay.
So it's on our Avail web, which is our body cam, where all the body cam video footage is placed on.
Okay. And what items were stolen from Mr. Salvatore?
We don't know what items were stolen. We just during the execution of the search warrant. There's money around, there's drugs in the vehicle, but we don't know exactly what was taken. But of course, there was an intent to rob Mr. Salvatore, the victim.
Okay. Was there surveillance at the Southside Inn? That's the one where the car ran into the hotel room.
I do believe I haven't seen any video as of yet. This initial case was several detectives involved in this investigation. Of course, I'm the lead detective, but I only have the video of the actual incident where we could see. But we have that. We don't have not obtained any video of him actually crashing inside of that room.
And there were witnesses at the Southside Inn?
Yes, there was. We had one witness that stated they heard the gunshot, but we believe that was from the American Best Inn suite 6358.
And so that's the only witness you guys spoke to, one?
She just said she heard it. She didn't see it. She just heard it.
Okay. And pictures were taken at the scene?
Yes, pictures were taken at the scene, yes.
And what were the pictures of?
Pictures of the vehicle, pictures of the two vehicles that were hit by the victim's vehicle and all the scene.
Okay. And were any informants used during the course of this investigation?
Any who?
Informants?
Oh, no.
And all the defendants were identified by Mr. Mallet?
D'Angelo Millette, yes, he stated who everyone was. I showed him pictures. He stated that was James Robert Brown. I showed him the other piece that was Demetrius Tarrant. And I also showed him other pictures as well. Well, we have other pictures as well of Demetrius Tarrant at the Connell Lodge, which matched the same description of when he was on scene during the incident.
Okay. And you say you spoke with Mr. Brown. He was brought to the precinct when you spoke with him?
No, when the fugitives unit went ahead and placed Mr. Brown in custody, which he was at the same incident location, 6358 Old Dixie Road, they took him to jail. I didn't speak to him until like a week later.
A week later. And you have your whole interaction, the whole interaction was recorded?
Yeah, it was audio recorded, yes, at the jail.
And did he also write a statement? Did he also write a statement? Sorry.
No, he did not write a statement.
Okay. And the recording was entered into evidence?
Say again now?
The recording was entered into evidence?
It will be entered into evidence. I just have to transfer it from the computer to a DVD.
Okay. And you were the only one who questioned Mr. Brown?
No, I had me and Detective Marshall he was interviewing with me as well.
And was Mr. Brown Mirandized?
Yes, he was.
Did he have to sign a waiver?
Yes, he signed a Miranda statement for him.
Okay.
Signed and dated.
Okay. And the three parties, the three defendants, they knew each other prior to this incident?
Yes. They'll see each other around.
They saw each other around?
Yeah, they'll see each other around, but not like close friends, but they'll just see each other around. Like James Brown said in the interview, everybody knows him.
Okay, so they're just like acquaintances?
Yes.
Okay. I have no further questions for this witness.
Redirect?
No additional witnesses, Judge.
All right. Well, do you want to redirect this witness is what I was asking.
No, Your Honor.
Okay. All right. All right. So it sounds like the state is resting. The state has no witnesses. Do you have any witnesses, Attorney D. Williams?
No, Your Honor.
Okay. Argument?
The state waives opening, Judge.
So I just have closing. This state has not met their low burden of probable cause for armed robbery. The relevant part of the statute reads a person commits the offense of armed robbery when he takes property of another. The state will argue he was at the scene of the robbery. However, that is not enough for even probable cause. The statute reads, a person may only be charged as a party to a crime if he directly commits the crime or he intentionally causes some other person to commit the crime. In certain circumstances, the other person is not guilty. And in this case, we know Mr. Tarrant was the one who shot the weapon or allegedly shot the weapon. Another part of the statute is he intentionally evades or abets in the commission, or he intentionally advises, encourages, hires, or procures another. And in this case, the officer didn't present testimony that my client aided the robbery or encouraged the robbery, perhaps a drug deal, but not a robbery. We know who had the gun and who was likely the shooter, but it wasn't Mr. Brown. Even the officer testified that the wound was in the back of Mr. Salvatore. Yes, he did run away after witnessing something traumatic, but that was a reaction to being scared. Fight or flight, and my client decided to choose flight. It was a chaotic scene, and based on the testimony and the statute, I would ask for the court not to find probable cause for our armed robbery.
Thank you. Okay. Attorney Freeman?
Thank you, Your Honor. We're asking that this one charge be bound over. We heard from Detective that based on the video surveillance and the footage, they were able to determine what was going on. It is our attention that Mr. Brown helped to plan the armed robbery of Mr. Salvatore, that he did actively participate in this drug deal and the plan to rob Mr. Salvatore of the heroin. Certainly, there may be some other charges to come later, given when the victim is able to be interviewed as well as medical records. But we're asking that based on this detective's testimony of his observations from the video surveillance, talking with Mr. Mellette, one of the co-defendants, as well as Mr. Brown's statement himself, that this one count be bound over to Superior Court.
Okay. There's a lot of information, a lot of testimony to sift through. I'm just trying to.
Mm-hmm. It was, Your Honor.
Yeah, just come for one part court.
I do find probable cause for this charge. I'm looking at the testimony of D'Angelo Millette, who ID'd Mr. Brown as being in the vehicle in the front seat. There's some inconsistencies with what your client said to the detective in terms of what he was trying to do, his role in this. And I find probable cause for the armed robbery. Frankly, I was trying to see if there was probable cause for more than that, but for now there is probable cause for the armed robbery. Okay?
Thank you, Your Honor. And this is one that's on the bond calendar Friday.
Thank you, Your Honor.
Am I still on YouTube?
Yes, Your Honor.
All right, thank you. All right, good morning, ladies and gentlemen. This is the Clayton County Magistrate Court, Superior Court bond hearing. I am Judge Richard Brown, sitting by designation as Superior Court Judge for the purpose of determining Superior Court bonds on felony cases. Representing the state is Assistant District Attorney Cheryl Freeman. And the calendar has already been called. The first case that we will hear will be the state of Georgia versus Manuel Marquez Martinez. He is represented by Attorney William Matos. And to assist will be certified Spanish interpreter, Ms. Deja Bermudez. At this time, I will administer the interpreter's oath. Solemnly swear affirm you'll faithfully translate Spanish to English, English to Spanish, the proceedings before the court in an accurate manner to the best of your skill and knowledge.
I do.
Thank you. It should be noted that due to the coronavirus, this case is being handled through Zoom video conference as well as live on YouTube. The cases against Mr. Martinez. On the calendar, there are a total of 3 cases, and we will hear 2 of them. Ms. Bermudez, you need to go.
Yes, sir. Solamente para que conste en el acta, este caso se está llevando vía Zoom. En el caso del señor Martínez tenemos 3 cargos, pero solamente vamos a proceder en 2 cargos.
The 3 charges, the first one is statutory rape, warrant number 2020 CW 53799.
En estos 3 cargos, el primero es de estupro y la orden de arresto es 2020 CW 53799.
And Attorney William Matos, on behalf of Mr. Martinez, has advised the court as well as the district attorney that they are waiving that particular charge or case straight up to the trial court without a hearing this morning.
Y el abogado William Matos, de acuerdo con la fiscal, le ha notificado a la fiscal y al juez que él va a renunciar a la audiencia preliminar por este cargo y que lo está enviando directamente a los tribunales de litigios.
The 2 remaining cases that will be heard today, the first one is harassing phone calls, warrant number 2020 WA 11160.
Y los dos cargos que restan en este caso, uno de ellos es el 2020 CW 11160 y ese es por acoso a través de llamadas telefónicas.
The second charge is computer pornography, warrant number 2020 WA 11161.
Y el segundo cargo es pornografía por ordenador o por computadora, y la orden de arresto es 2020 CW 11161.
All parties have announced ready to proceed.
Las partes han anunciado que están listas para proceder.
And I forgot to mention that today's calendar is heard by me, Judge Richard Brown. I did say that, sitting by designation, and the date is August 21st, 2020.
Y se me olvidó decir que la lista de causa está siendo escuchada por mí, el juez Richard Brown, sentado por designación como juez del Tribunal Superior, y que la fecha es 21 de agosto del 2020.
And representing the state is the attorney, Assistant District Attorney Cheryl Freeman.
Y que representando al Estado está el asistente de la Fiscalía, Cheryl Freeman.
Attorney Matos, it's your case. You may proceed.
Your Honor, I just want to, and I think me and Ms. Freeman have discussed that when we do the bond hearing today, it will be for all three warrants, so that we don't have to come back and redo and reinvent the wheel. So we just wanted to make, I guess he needs to understand that, so that it's just not simply waiving the preliminary hearing, but that we will consider bond on all his cases, so he understands, I guess, and his family understands.
Mr. Matos, the interpreter couldn't hear you well. Can you please repeat what you just said?
Just that me and Ms. Freeman have discussed this before, that when we do the bond hearing this morning, it'll be for all three charges, so that we're not coming back and redoing another bond hearing.
Que la señorita Freeman y yo hemos discutido en la mañana de hoy que la audiencia que vamos a tener es para los tres cargos, para no tener que regresar a tener una audiencia solamente por el otro cargo.
For the bond hearing.
Para la fianza, para pedir fianza.
Thank you, Ms. Bermudez. Okay. All right, Your Honor, real quickly, Mr. Manuel is 32 years of age. He's been in Forest Park about 8 years.
Su señoría, el señor.
Slow down, Ms. Bermudez.
And Mr. Matos, I don't know if it's the volume, but the interpreter is having trouble being able to hear you.
All righty. You hear me now?
Yes, sir. Thank you. Just to make sure that that's what you said. You said that Mr. Marquez is 32 years of age and he's been in Forest Park for the last 8 years, correct?
That's the first part. Go ahead, yes.
Thank you. El señor Marquez tiene 32 años de edad y él ha vivido en Forest Park por 8 años.
He has several relatives in Forest Park.
Él tiene varios familiares en Forest Park,
which include 3 brothers and 2 sisters.
Lo cual incluye 3 hermanos y 2 hermanas.
Okay. As far as his criminal history,
y cuando tiene que ver con antecedentes penales,
I believe all he has a no license.
Yo creo que todo lo que él tiene es un cargo por no licencia.
Okay. He works at a stone and stucco company.
Él trabaja en una compañía de stones y estuco.
Okay, it's called escapes.com.
Se llama escapes.com.
And he's been there around 4 years.
Y él ha estado ahí por 4 años.
Okay. I don't think Mr. Manuel is a risk of flight.
Yo no creo que él es un riesgo de darse a la fuga.
His family is in a position to post a bond.
Sus familiares están en una posición de pagar fianza.
Okay. And obviously as it relates to these charges, there were 2 initial charges and then there was a 3rd charge added.
Y obviamente cuando tiene que ver con estos cargos, inicialmente eran 2 cargos y luego se le añadió un cargo.
Okay. I'm assuming the 2nd charge was based on a forensic interview.
Y yo asumo que el segundo cargo estuvo basado en una entrevista forense.
Okay. Which obviously we have at this stage of the legal proceedings we wouldn't have access to.
Lo cual en esta etapa del procedimiento legal, nosotros no tenemos acceso a ella.
So basically, we'd ask the court to set a reasonable bond.
Básicamente le estamos pidiendo al juez que le conceda una fianza razonable.
I'm aware that the 90-day rule may not apply.
Yo tengo conocimiento que la regla de los 90 días puede ser que no aplique o no califique.
But at the same time, I don't, assuming that we're looking at probably 2021 when we get to his court date.
Can you repeat that, Mr. Matos?
But assuming that we will not get to his court date until 2021.
Porque yo estoy asumiendo que él no va a poder tener una corte hasta el 2021.
I don't think the court order would allow just definitely indefinite detention.
Y yo no creo que el juez va a permitir que esto solamente no se le dé una atención o no se le preste atención de manera indefinida.
That's the goal. We understand that the bond may be high.
Yo entiendo que quizás la fianza podría ser alta.
And it's going to require various conditions.
Y que se le va a requerir varias condiciones.
But we'd ask the court based on his criminal history.
Can you repeat that for the interpreter, Mr. Mato?
I will, but based on his criminal history.
Pero basado en sus antecedentes penales.
And again, the delays that we will have in appearing in court.
Y también el retraso que tendríamos para poder comparecer ante los tribunales.
We'd ask the court again to set a reasonable bond with conditions, Your Honor.
Una vez más, le pedimos al juez que le conceda una fianza razonable con sus condiciones.
I hear from the state.
Thank you, Your Honor.
Voy a escuchar por parte del Estado. Gracias, Su Señoría.
Mr. Martinez does not have a bond on the statutory rape nor the computer pornography and child exploitation charges.
El señor Martínez no tiene fianza en el cargo de estupro y de pornografía por ordenador y por explotación infantil.
Regarding the computer pornography charge and the harassing phone calls, Judge.
Con relación al cargo de pornografía por ordenador y acoso a través de llamadas telefónicas, Su Señoría.
The defendant admitted to law enforcement.
El acusado le admitió a los agentes de la Fuerza del Orden Público
about having the photos and making the phone call to the 15-year-old victim.
De que él tenía las fotografías y que le había hecho las llamadas a la víctima de 15 años.
The defendant actually stated he was angry at the victim for not coming to see him.
El acusado dio declaraciones de que él estaba enojado con la víctima porque ella no lo había ido a ver.
He admitted that to who?
The police officer. This was with the, let me see which law enforcement agency.
Y él se lo...
I'm sorry, Deja.
It's okay. Y él se lo admitió ¿a quién? A los agentes de policía, y esto fue con el Departamento de Policía de Forest Park.
This is with the Forest Park Police Department, Judge.
Thank you.
Esto fue el Departamento de Policía de Forest Park, Su Señoría. Gracias.
He actually admitted to have at least 4 pictures of a provocative nature of this victim.
Él admitió haber tenido por lo menos 4 fotografías de naturaleza provocante de esta víctima.
Judge, I'm not sure if the alleged victim of the child pornography or the computer pornography is the same as the stat rape. I don't have that warrant in front of me.
Su señoría, yo no sé si la víctima en el caso de pornografía por ordenador es la misma víctima del cargo de estupro, porque yo no tengo la orden de arresto enfrente mío.
That certainly is a recent charge. In looking at the computer, it says confined date August 18th.
Y esto es un cargo reciente, y mirando a la computadora, dice que esto que se arrestó, se ejecutó el 21 de agosto. Can you repeat the date, Ms. Freeman?
August 18th.
18 de agosto. Thank you.
Well, given the information that we have, Judge.
Y dada la información que nosotros tenemos, su señoría.
The state is asking that Mr. Martinez.
El Estado está pidiendo que el señor Martínez
remain on no bond status for the 2 felony charges.
Permanezca sin fianza por los 2 cargos por delito grave.
Thank you, Your Honor.
Muchas gracias, su señoría.
All right, the court has a couple of questions. Attorney Matos.
El juez tiene un par de preguntas para el abogado Matos.
Do you have any documentation to confirm this employment?
¿Usted tiene alguna documentación que confirme que él está empleado?
I can provide that to you. I don't have it with me now, but I can provide it to you. I got that straight from his brother, Your Honor.
Yo no lo tengo conmigo, pero yo se lo puedo hacer llegar, su señoría.
Next question.
Próxima pregunta.
Do you show where he was living and who he was living with?
Yes, he was
¿Muestra dónde él vivía y con quién vivía?
Yes, he was living with his 3 brothers and 2 sisters. It's actually the address that's listed on the warrant, Your Honor.
Sí, su señoría, él vivía con sus 3 hermanos y sus 2 hermanas en la dirección que está nombrada en la orden de arresto o registrada en la orden de arresto.
Are any of them present on this Zoom this morning?
No, Your Honor, they're not, Your Honor.
¿Hay algunos de ellos que estén presentes vía Zoom en la mañana de hoy? No, su señoría. No.
Next question.
La próxima pregunta.
Is he a U.S. citizen?
He's not, Your Honor. There's I believe, an immigration hold on him with Clayton County, Your Honor.
No, él no lo es, su señoría. Yo creo que él tiene una orden de detención de migración en el condado de Clayton.
Attorney Matos, do you know if the alleged victim of the statutory rape is the same alleged victim as the child exploitation?
I believe it is, Your Honor. If you read the police report did the initial interview, and then in the report they mentioned that they're going to take her to do a forensic interview. 99.9% sure that it's the same victim, Your Honor.
Señor Matos, ¿cree usted que la víctima del caso de estupro es la misma víctima del caso de explotación infantil? Yo creo que sí lo es, su señoría, porque se nombra la víctima en la orden de arresto y ellos dicen que la van a llevar a una entrevista forense. Yo creo que 99% que sí lo es.
Those are all the questions I have. Is there anything else you'd like to say, Attorney Matos?
Again, Your Honor, we'd ask the court to set a reasonable bond. I understand the emergency order, but unless you can't have it both ways. We can't have an emergency order and no grand juries and no trials. This isn't Guantanamo Bay. We'd ask the court to set a reasonable bond, and obviously we'll go from there. But to hold someone indefinite when there is no idea when we're going to have either a grand jury or trial, I don't think that is the basis of a no bond condition. No bond is, you've got grand juries running. You can indict cases pretty quickly. In this situation, we're not even close to that, Your Honor.
Do you know how long your client's been in jail?
Since the date of arrest, since the same day that's on the warrant, Your Honor. He was arrested that same day.
I think that's June 28th this
That's
year.
correct. That's correct.
So it will be 90 days and how long, June?
August 28th.
Okay.
Or June, July, August, June 20, July, or September 28th.
September 28th.
I'm sorry, September 28th.
All right, Attorney Freeman, anything else you wish to say?
Your Honor, just that we're asking that he remain on a no bond status given the charges.
Abogada Freeman, ¿algo que usted quiera decir? Solamente que él permanezca sin tener fianza basado en los cargos.
All right, considering the considering what's been presented by both the defense and the state, the court is going to deny bond for the following reason.
Considerando todo lo que ha sido presentado por parte de la defensa y por parte del Estado, el juez va a denegar la fianza por las siguientes razones.
First, regarding significant ties to the community, although it's been stated that he has a job that he's been working for a number of years, there's no documentation to confirm that.
Primero, por los vínculos o los lazos con la comunidad, aunque se ha dicho de que él tiene empleo, pero no ha habido documentación que apoye esto.
Next, there's not a clear, confirmed information regarding the living with 3 brothers and 2 sisters. The court would need to get more information regarding that living situation, which is not available this morning.
Segundo, la información no está clara o confirmada de que él vive con 3 hermanos y 2 hermanas. El juez tendría que recibir información con relación a cuál es su situación con lo de su vivienda.
Next, given the fact that he's not a United States citizen, the court has concern about him being a flight risk or potentially failing to return back to court.
Y dado el hecho de que él no es ciudadano americano, al juez le inquieta de que él podría darse a la fuga y que él no podría comparecer ante el tribunal.
Regarding Attorney Matos' concern about being held indefinitely,
y con relación a la preocupación del abogado Matos de que a él lo podrían detener de manera indefinida,
that is the purpose for the requirement under law that that the person be indicted within 90 days. And so that we have another month at least before that time frame, which would address that concern.
y ese es el propósito de la ley, de que la persona tiene que ser acusada formalmente antes de los 90 días, y a nosotros todavía no queda más o menos un mes antes de que podamos lidiar con esa inquietud.
And then we have an additional charge of statutory rape for which there's needs to be confirmation regarding whether it is the same or different alleged victim.
Y luego tenemos el cargo de estupro, donde también necesitamos tener información que nos confirme si la presunta víctima es la misma.
However, that is additional. That additional charge is another consideration that the court cannot overlook regarding its decision on bond.
Y ese cargo adicional es algo que el juez no puede no tomar en consideración. en el momento de otorgarle una fianza.
Given the court has no reason to necessarily doubt that Mr. Martinez is employed and is living with brothers and sisters. It just needs confirmation.
El juez no tiene ninguna razón para dudar de que el señor Martínez está empleado y de que vive con sus hermanos y sus hermanas. Solamente necesita confirmación de esto.
And the court is not overlooking the fact that it appears that he cooperated with law enforcement.
Y el juez no está dejando de tomar en cuenta de que él cooperó con los agentes de la fuerza del orden público.
So with that additional information, the court could reconsider its position, and if not within the next, before the next 90 days, it can definitely would have to set a bond after 90 days.
Okay, thank you, Your Honor.
Y tomando esta información adicional, el juez podría reconsiderar el concederle fianza, aunque le tienen que conceder fianza antes de los 90 días.
Anything else, Attorney Matos?
No, that's it. Thank you, Your Honor.
Attorney Freeman?
¿Algo más, abogado Matos, abogada Freeman?
All right, so that will conclude the hearing on the Martinez case. All parties associated with this case, and if you have nothing else, you can be excused. And I'll ask the jail to Mr. Martinez, you can go back with the deputy.
Sure, I'll email you that waiver like within a few seconds, okay?
All right, thank you.
And Ms. Bermudez, you can be excused. Thank you for your, well, let's make sure we don't need you for anything else.
Yes, sir.
Attorney Freeman or any other attorney?
I don't think we need Ms. Deja for any other cases.
All right. Okay. Thank you, Ms. Bermudez. Have a good weekend.
Thank you, everyone. Have a good weekend.
Have a good one.
Bye.
All right. That'll conclude this case. So now let's go to, I think, Anthony Smith is what I heard Attorney Freeman say. We'll start that one in about 2 or 3 minutes when we get the paperwork ready, so stand by.
Judge, you want Smith Anthony?
Please.
Okay.
Your Honor, is it possible for Matthew Hunt to go next because the witness has to get back to work?
There's no objection. If the jail can hear us, if you can bring up Matthew Hunt.
I got you.
Instead of Anthony Smith. Thank you.
Got you, Ms. Freeman.
Thank you.
Okay, we're ready for Anthony Smith.
Judge, they switched.
If we could do Matthew Hunt, Mr. Williams, her witness has to get back to work. And I said I had no objection to doing Hunt instead of Smith, since the witness is already on the call.
Okay, so I have to go now and pull that paperwork. Hold 1 minute.
Oh, we apologize, Judge.
No problem. We're ready for Matthew Hunt. All right, court is calling the case State of Georgia versus Matthew Jeffrey Hunt. 1 second. The state's represented by Assistant District Attorney Sheriff Freeman, and Mr. Hunt's represented by Assistant Public Defender Angela D. Williams. All parties have announced ready to proceed. Mr. Hunt has 5 charges. Aggravated assault by strangulation, warrant number 2020 CW 52863. Cruel to the children in the 3rd degree, 52864. False imprisonment, 52865. Aggravated assault with a deadly weapon, 52866. And battered family violence, 52867. Attorney D. Williams, you may proceed.
Thank you, Your Honor. So my client, Mr. Hunt, has been in jail for 52 days, and he could afford a total bond of $38,500, which would be it's already written out, $8,500 for the aggravated assault, $5,000 for the cruelty to children. He doesn't have a bond on the false imprisonment, so I'm asking for $5,000 for false imprisonment and $15,000 for the other aggravated assault charge, and to keep the battery charge at $5,000, which he already has. Mr. Hunt has worked at the T&K Discount Meats in Riverdale for the past.
All right, I'm sorry. Can you repeat that and go a little bit slower?
Oh, the numbers?
No, you just said about he worked somewhere. Is that what you just said?
Yes, he works at T&K Discount Meats, which is in Riverdale.
All right, go ahead.
He's been there for 10 years. His cousin is the owner of that store, and he has kept him gainfully employed. Mr. Hunt has 3 kids with the victim in this case, Ms. Turner. His kids are 3, 2, and 6 months. If Mr. Hunt is granted a bond, he would live with his aunt, who I'm going to call as a witness. She works for the Department of Labor and is willing to let Mr. Hunt live in her home as long as he follows the family plan that they have in place for him. And if the court allows it, he has close family throughout the metro Atlanta area. His mother lives in Covington. His father lives
just a little bit slower.
I'm sorry.
Okay, so follow the family plan to live with the aunt. And then what did you say after that?
His mother, if the court will allow the family plan to happen, I'm going to lay it out for you when I call the aunt as a witness. Okay. His mother lives in Covington, Georgia. His father lives in Atlanta. He would have no problems getting to court either by Uber are one of his family members. He also has a 17-year-old son and an 11-year-old son by other women, but they do live in Atlanta. His father is a commercial plumber in Atlanta, and his mother works for the state of Georgia. She goes into homes doing inspections, and she reports her findings to the court. He does have a bit of a criminal history, and I believe just one felony conviction. I'm sure the state will correct me if I'm wrong about that. His felony was for marijuana possession in 2015. He does have an open aggravated assault and battery case with the same victim. However, when that went to a preliminary hearing, that case was dismissed and it was brought back by a true bill. The victim contacted me and informed me that she exaggerated to the police a bit about this case. And she wants contact with Mr. Hunt, and she has no fear or concerns about him getting a bond. I believe the victim spoke with the victim's advocate office, and I'll let the state relate any concerns the victim may have that I'm not aware of.
Oh, I'm sorry to interrupt. When was the open aggravated assault and battery case?
It's current. There is open in Clayton County. There is a case number from October of 2019, case number 2019 CR 02704. Charges are aggravated assault and a battery.
All right, thank you. You may continue, Attorney DeWee.
Thank you. I spoke with Mr. Kirk Walker, which is Mr. Hunt's uncle, and Mr. Walker has a job ready for Mr. Hunt, and he will learn a trade of commercial plumbing under the tutelage of his uncle as a commercial plumber. That's the same profession as his father. His uncle let me know that he could use help with his business because he has a lot of work and he has contracts that will take him well until the middle of 2021. Coronavirus did not impact his business and he is busy. And I would like to call my client's aunt, Angel Rollins, to the stand as a witness.
All right.
Ms. Rollins, would you please raise your right hand? Do you promise to tell the truth, the whole truth, and nothing but the truth so help you God?
I do.
You may put your hand down. Would you please state your name for the court?
Angel Rollins.
And how are you acquainted with Mr. Hunt?
I'm his aunt.
And what do you do for a living?
I work for the Georgia Department of Labor.
And what is your job title?
I'm a business services recruiter. I service 6 counties in the state of Georgia. I work primarily with employers. And at this moment, due to COVID-19, I'm in the house actually working with aliens, fraud, and trying to get our Georgians paid.
Okay. And would Mr. Hunt be allowed to stay with you if he was to get a bond today?
Yes, he would.
And would you please tell the court the plan that the family has come up with for Mr. Hunt if he was to get a bond?
Well, the plan that we would like to petition the court for is for him to be able to bond out and come to my residence and potentially leave to go to North Carolina to start employment. My brother has several opportunities for him on different job sites down the coast. And I have spoken with my brother and he has agreed to be in full communication and liable for Matthew with Clayton County courts.
Okay. And so if he was to have a court date, would he be able to stay with you in Georgia?
Absolutely.
Okay. And how would he get from North Carolina to Georgia to get to your home?
My brother would transport him, or either I would provide transportation to get him there.
Okay. And when Mr. Hunt is in Georgia, would Ms. Turner be allowed to come to your home?
Absolutely not.
Okay. And is the family in general okay with Ms. Turner being around Mr. Hunt?
No, we are not. We fear for his safety.
Can you identify who Ms. Turner is, Attorney DeWee?
That's the victim in this case?
It hadn't been mentioned, so I just want to make sure that we're clear on that for the record. Okay, so the victim, the last victim's name is what? Say it again, please.
Ms. Turner, I believe Aquisha Turner.
All right, you may continue.
And how much money would Mr. Hunt be earning if he was to work for your brother, Mr. Walker?
On a weekly basis, between $800 and $1,500 a week.
Okay. I have no further questions for this witness.
Attorney Freeman, any questions?
No, Your Honor.
All right. Ms. Rollins, thank you for joining and thank you for your service.
Yes, sir.
And I have no other witnesses, just.
Hold a minute. Sorry. I have some questions. Ms. Rollins, Mr. Hunt is your nephew by what, sister or brother?
By my brother.
Is this the brother in North Carolina?
No, that's our baby brother. His father is Marvin Hunt.
Okay. All right. Do you know where Mr. Hunt was living prior to this alleged incident?
He was living with the alleged victim.
Do you know the alleged victim?
I do not know the alleged victim personally. I have had to come into family court. I met her on one occasion, but she is not welcome in our home or around our family.
From what I heard from the attorney D. Williams, Mr. Hunt has 5 children.
Yes, sir.
All right, those are all the questions I have. Any other questions, Attorney D. Williams, Attorney Freeman, based on the court's question?
No, Your Honor.
No, Your Honor.
All right, anything else, Attorney D. Williams?
Just closing.
Okay, go ahead.
Okay. I would ask the court to grant Mr. Hunt a bond total of $38,500. The family has an airtight plan for Mr. Hunt to be productive while he is waiting to go to trial. He wants to fight these charges and clear his name. We asked the court for permission for Mr. Hunt to be with his uncle when he is not in Georgia working. When he is in Georgia, he will stay with his aunt. He will be sure to get to court. The only way she will allow him to stay with her is if he works for his uncle, or if he is working. He has to be gainfully employed if he is to live under her roof. He will be learning a family trade, earning extra income, and he will be around positive male influences if he's allowed to go work with his uncle. He is not a flight risk because North Carolina is extremely closed. And like I already stated, when he has court, he's going to be with his aunt to ensure he's ready for any court dates and he doesn't miss any court dates. He knows that he has to keep an updated address on file with his attorney and the court. And in order to learn his trade, he will have to have essentially no physical contact with Ms. Turner. So witness intimidation is not an issue because he will be in North Carolina unless he has court. And if he is in Georgia, he's going to stay with his aunt, who will not allow him to have her at the house. And he can't be around her around their residence. When I spoke with his uncle, he told me that his schedule is from 5 a.m. to 8 to 9 p.m. and he'll be working the entire time. So when he is done with work, his uncle told me that he'll only have time to probably take a shower and go to sleep because he has to wake back up to be ready to work at 5 a.m. I know the state's going to ask for no bond, but I asked the court to please consider the plan that his family has come up with for Mr. Hunt to guarantee his success and to move forward with his life and not to waste his time being idle in jail waiting for a bond, because a high bond is essentially no bond. So once again, I just asked the court to consider the family plan and allow him to learn the trade of the family business and to earn money so he can take care of his children. And if he needs a curfew when he's in Georgia, we can do a curfew to ensure he's at the home and not, of course, being idle. And that's all I have.
All right, before Attorney Freeman, there's something I forgot to inquire about, and that is, I understand that he has an open case that was initially, I think, dismissed and then picked back up by the state.
Well, I don't have that information, Judge. That's what Mr. Williams stated, but I don't have that. But it it has been indicted.
All right, so my question is, if it's been indicted, was Mr. Hunt, but did he get out of jail and get rearrested?
No, Your Honor.
He did not. Okay. So
Judge,
then,
I don't know. I don't know that.
all right, so let me just say this. I cannot make a decision about granting bond until or unless I get the additional information on the other case to include whether he had a bond condition to have no contact with the alleged victim. And there should have been a bond order. So the determining the status of that previous case is going to be a necessity to make any further determinations. So if we need to go to another case while we try to recover that information, either through the DA's office or through the court, we're going to need that. So we might need to come back to it.
Well, Judge, I will say, because I don't want to represent that that's information that I can get right now, but I will say this, according to CPU 8, the indictment was filed on October 9th of 2019. The case came into our office in July of 2019. So I don't know after if Mr. Hunt had a true bill bench warrant on that case or what happened, but the current charges occurred on June 22nd of this year. If the court wanted to go into recess, I don't know how much information I can find to try to see if I can locate the case that's in our office. I don't, just because half of the attorneys in our office are not here, half are here, and it's just trying to figure out where that file may be. But it was indicted on October 9th of 2019.
Indicted on October 2019, and you said this second set of charges occurred in June of 2020?
Yes, Your Honor.
Okay. All right, then.
And in court case inquiry states that it was dismissed by Judge West.
Okay. Well, was it dismissed before, not the indictment, not after it was indicted?
Right, it was not. Exactly. So whether or not it was dismissed by Judge West at this point, it was indicted. And at this point, we don't even know if it was dismissed based on a hearing or a witness, but he was indicted on those charges.
All right. Okay. So, so I'm going to go ahead and make a decision on the case. Anybody else have anything?
Do you want me to go over the history other than the open case, Your Honor?
Please.
Or, okay. And just for the record, the state is asking that he stay on no bond status. These were serious charges. And one of the things in the case which stands out is where the victim indicated to the officers that Mr. Hunt made her get on her knees and apologize to him and indicated that he wanted her to refer to him as God. And the officer noted that he did observe discoloration and bruising to her knees from her having to get on her knees. But just going through the history of Mr. Hunt, because he does have some probation violations. So let me start at the beginning. So from, 2006, there was an obstruction. 2007, misdemeanor possession of marijuana. There was a probation violation on that possession of marijuana. 2008, there's another obstruction and a probation violation. When we get to 2015, There is a possession with intent of marijuana, which of course is a felony that was here in Clayton County. In 2011, we have a harassing phone calls. In 2011, we also have a probation violation, or a probation revocation in 2011. We have another probation violation in 2014. In 2015, there's a criminal trespass and with 2 counts of criminal trespass. 2015, there's a probation violation. In 2016, there is a hit and run, as well as a driving with a suspended license. There is a probation revocation in 2017. And then we have the current charges. And I'll also state that in the police report, they stated that that Mr. Hunt had an outstanding warrant for the city, in the city of Forest Park.
That was regarding the case we were talking about that was indicted.
Okay. So given his history, and his history does show that he has probation violations, probation revocations, and I certainly heard what Mr. Hunt's aunt said about the plan the family has in place. But given his history and the charges, the state believes that there is a substantial likelihood that he will reoffend. He's shown by the numerous probation violations and revocations that that there's certainly a propensity to not following what he's been instructed to do. So the state is asking that for the charges where he does not have a bond, that he remain on no bond status. If the court is inclined to grant a bond, we are asking on the false imprisonment.
The court's not going to.
Okay, thank you, Your Honor.
All right, the court will adopt the state's position as to no bond, that the Mr. Hunt has shown a continued and repeated disregard for probation, and he also has 2 obstruction evictions, which shows either a concern for flight or failing to appear. In addition to that, he has a pending charge of the same or similar nature, potentially against the same victim or another victim, but the nature of the charges are the same, so the court finds he poses significant risk of committing felonies pending trial. He has a good family in his corner. He has resources and all these great things that he could choose to take advantage of, but it appears up to this point, he may be taking people's kindness for weakness. And at this point, the court will deny the bond for all the reasons stated. That'll conclude this case. Mr. Hunt can go back with the deputy. And then Ms. Rollins, I'm sorry, we're not able to grant a bond, but thank you for making yourself available. And unless Attorney D. Williams have anything else on this case, we're going to prepare to go to the next case.
No, Your Honor. Thank you. Thank you, Ms. Rawlings.
Thank you.
All right. Okay, so the next one I have is, we said Anthony Smith.
Anthony Smith, yes, Judge.
Okay.
Judge. Come on.
Stand by.
Mr. Smith, I did speak with her. Okay.
Okay, we are about to go on the record with next case. The state of Georgia versus Anthony Jerome Smith. Mr. Smith has 2 charges: aggravated assault and warrant numbers 2020 WA09360, Crew to the Children 09361. Cheryl Freeman representing the state. We have attorney Camille Reddick with the Public Defender's Office representing Mr. Smith. All parties have to proceed. Attorney Reddick, you may proceed.
Morning, Your Honor. I want to draw the court's attention to, in particular, the one count that Mr. Smith does not have a bond on. It would be the aggravated assault. He currently does have a bond on the cruelty to children of $4,000. Your Honor, Mr. Smith and I are hoping that you grant him a bond on that one count not to exceed $5,000. The biggest basis for our request is that Mr. Smith has been in custody 84 days. And as the court is well aware, at the 90th day, he would be entitled to a bond if he is not indicted. The court is also aware that we are still under a judicial emergency and that grand jurors will not be brought in prior to September, which would take Mr. Smith well beyond his 90th day, since we are already at 84 days. So that is the biggest reason we are asking, Your Honor, to set a bond, because he's going to be entitled to one, and the court knows that it won't get indicted prior to his entitlement date. We are not able to kind of get him on the calendar right at the 90th day, but I believe that because we're only 6 days away, the court could make the determination that he would not be indicted timely, and thus he should be guaranteed a bond on that one count. In addition, Your Honor, looking at the Ayala factors, I myself, as well as I believe the DA's office, has spoken with the victim, Ms. Pamela Greason. She indicated that she is not concerned or does not have any safety concerns with regard to Mr. Smith. So that means that he is not a danger to harass, intimidate, or otherwise harm witnesses in this case. The main witness would be Ms. Greason, and she has no concerns for her safety or that of her children. I asked her when I spoke with her whether or not she needed him to stay completely away. She indicated that she has no concerns with him communicating with her because they do share a child. Although they are no longer in a relationship, she made that abundantly clear, and I need Mr. Smith to hear me say that. She said, y'all not in a relationship anymore, Mr. Smith. She does not have concerns with communicating with you regarding your child that you share with her. And so, Your Honor, she has no safety concerns. He is not a flight risk. He has been a resident of the metropolitan Georgia area since 1997. He has worked. His job is still waiting for him at the mechanic shop where he was at when he was arrested on this case. So he would have a job to go back to earn an income. He is not a flight risk. He does have a history. Let's not hide that from the court. We're going to be forthright. He does have a history. And in fact, he is on a probation for a criminal damage charge that involves this same young lady. But again, she has no concerns for her safety. So we would ask the court to set a reasonable bond of no more than $10,000 on the aggravated assault. He is not a flight risk. He is not at risk to reoffend or commit offenses while out on bond. He is not a threat to harass or otherwise intimidate witnesses because she has no fear of because the main victim has no fear of Mr. Smith.
Attorney Reddick, let me ask you this. Do you have any documentation regarding him being gainfully employed?
Miss Greason has all his paperwork, and I could get it from her, but I did speak with her and she's available by phone. She told me last night that if anybody had to ask. Well, the answer is in my hand. No, I do not have it. I can get provided to the court today if it's something that's required.
Right, I get it. Now, the next question, do you have any information about where he was living or will be living?
He was living with Miss Greason. He will be living with his sister, a family member. We can provide that address to the court. I just don't want to do it on YouTube, Judge.
Okay, so is that sister available this morning?
I didn't ask her if she was going to be available this morning. I did not, but I can find out and let the court know.
Well, no, we're in the hearing now. So now let's see. All right, then those are the few questions I had before I allow Attorney Freeman to proceed. Go ahead, Attorney Freeman.
Thank you, Your Honor. Just a little bit about the case before I get into his history. This defendant poured gasoline on the victim. When the police got there, the victim smelled of gasoline, as well as there was gasoline smell in the residence. There was a 17-year-old who was there, who was not the child of the defendant, who had indicated that she woke up to her mom screaming and yelling. And she said that she saw...
Your Honor, at this point, I'm going to object. I believe the standard for a bond would be the Ayala factors, not necessarily the facts of the case, but whether or not he meets or does not meet, in the court's opinion, the Ayala factors as outlined by the court.
Well, Judge, I believe, given the serious nature of this, of the allegations, as well as what the one witness says, certainly goes to the possibility of flight, as well as intimidating the witness. The victim, the 17-year-old I was speaking of, is not a child of the defendant, but she was a witness there who indicated she saw the defendant pouring the gasoline and holding a black lighter in his hand.
Then, Your Honor, I believe it would be appropriate, would be testimony of that young lady saying whether or not she does, in fact, have a fear or safety concern, as we had to find out from Ms. Greason, who is the main witness, who's the alleged victim in the case. But to go into the facts or what the state believes the facts are of the case to try to use that is not appropriate. As the court is aware, the Supreme Court of Georgia, in a case of murder, has indicated that those facts on his face were not sufficient to overcome whether or not the client met the Ayala factors to warrant a bond.
Attorney Freeman, what's your response to Attorney Reddick citing the case and what the proposition of what it stands?
Your Honor, again, I stand on my argument is that, and that's not all the information I was going to provide. So it's not just standing on the facts alone, but that's an example of the possibility for witness intimidation. The witness indicated to the police that was the scariest moment for her.
Attorney Freeman, I'm sorry to interrupt. Okay. But I'm understanding Attorney Reddick to say that under the law, you're not allowed to go into this type of information. And she cited made reference to a case. I'm asking you, do you share that understanding? Or are you aware of that case, or do you disagree with that?
Well, Your Honor, my understanding of the interpretation of that case is I'm not standing on the facts of this alone, and I'm not giving the entire facts. What I was merely submitted to the court is that there certainly is a potential for witness intimidation. And I don't believe that I have to have her, that witness testify in today's hearing, but given that she indicated to the police that was the scariest moment of her life.
In Your Honor, I will bring the court's attention to what the court's history has been. When we have cases where the victim has been reached out to.
Which court's history?
Well, magistrate courts I've dealt with in Clayton County. Judge Dallas and Judge West have relied on when the state says we spoke to the victim and the victim has safety concerns. They've relied on that. In this case, we've spoken to the victim. She does not have safety concerns. Now the state is trying to not allow that to stand as it has allowed it to stand when it works in their favor. And that's my concern, that when it works in their favor, when they reach out to the victims and the victims say, we have safety concerns, that's sufficient. But today, when both sides have reached out to the victim and she does not have safety concerns, that's not being allowed to stand. Now we're going back to something that was said to law enforcement almost 90 days ago. And I acknowledge the victim told me herself when she was in the moment, she felt that way. But today, currently, she does not feel that way. So I'm not understanding why it's good when it works in their favor, but the fact that it's not working in their favor today is not sufficient to show that he is not a danger to harass, intimidate, or otherwise threaten witnesses.
And Judge, I didn't say anything about Pamela Greason. I was speaking of the other victim, who is Ms. Greason's daughter.
But that's a victim you haven't spoken to. Because I reached out and I spoke to her.
Hold on, Attorney Reddick. She didn't interrupt you. Go ahead, Attorney Reddick.
And so certainly Pamela Greason has indicated that she does not have safety concerns. She has indicated that. But again, Your Honor, that I have not even completed my argument, so I have not gone back on anything regarding Pamela Greason.
Okay, so let me rule on the objection. I overruled the objection. Number one, as far as what Judge West or Judge Dallas may have done, or the reason they have done it, the court is going to stand on its own decision based on its case-by-case basis. And number two is the court is allowed to consider the facts and circumstances surrounding this particular case, each case as it relates to issues of bond, to even form a framework from which to put in context anything else. And number three, the argument that the alleged victim has no safety concerns. We still have minor children as well, and the court has to consider their interest and welfare and safety as well. So I overrule the objection. Attorney Freeman, you may proceed.
Thank you, Your Honor. And just going into the history of Mr. Smith, because based on the history, I do believe that there is a substantial likelihood that he'll reoffend. Starting in 1997, there was an entering auto where he received probation. That was in Brunswick. Going to another case in 1997, there was a burglary that was in Glenn County. Going again to 1997, it says in Brunswick, that may still be Glenn County, but there was a VGCSA. It doesn't state what type of drug it was, where he received 7 years confinement. He was paroled in 2000 for that one. In 2002, there was a public indecency that was in Clayton County. In 2004, theft by receiving stolen property, a possession of marijuana less than an ounce, and that theft by receiving was a felony. That was in Clayton County, where he did get 5 years confinement. In 2006, there was given a false name. There was a parole violation in 2006. There was another parole violation in 2008. In 2014, there was a possession of a firearm by a convicted felon. That was in Clayton County. He got 5 years probation. In 2019, there was a conviction for 3 counts of criminal damaging in the second degree. That's in Clayton County, where he received 5 years probation. And that was out of Judge Powers' courtroom. And then we have the current charges. And so Mr. Smith is currently on probation, and he was on probation when these charges occurred. So we believe that given that there is a substantial likelihood that he will reoffend. I'm not sure if a BOP has been filed, but the state is asking on the aggravated assault that he remain on no bond status. And that's all I have.
Okay, stand by 1 second.
taking a motion to the back.
All right, sorry about that. So anything else, Attorney Reddick?
Yes, Your Honor. The other witness, the alleged 17-year-old in the case, resides with Ms. Greason. And again, I had conversations with Ms. Greason last night, and she indicated that she nor the other witness, her 17-year-old daughter who came downstairs, have safety concerns. So I don't believe that that is a factor. But the better part and the stronger part of our argument, Your Honor. I apologize, Judge. I'm having a bit technical difficulty.
No problem.
I did post in the chat, Your Honor, the information where Mr. Smith works. We literally were calling and verifying while Ms. Freeman was making her argument. It is JD Auto Repair. We spoke with the manager. Her name is Rebecca, and we put the phone number in there. So Your Honor could have that information regarding employment. But again, I believe the better part of our argument, the stronger part of our argument, is that the statute for the 90 days does not matter. It does not consider any of the Ayala factors. It's a blanket statute that says if the case is not indicted within 90 days, he is entitled to a bond. I believe that the court in its discretion could use that statute at this time to provide my client with a bond, as he has been in 84 days. He will reach his 90th day in 6 days. The court is well aware that our Supreme Court Chief Judge has just extended our judicial emergency into September, which means Mr. Smith would not have an opportunity to even be indicted prior to hitting his 90th day. So that is our better argument. We understand that he has a significant history. I believe that my client is now a different person. But of course, Your Honor could find that that difference came about because of the 84 days in custody. He does not have current VOP hold out of Judge Powers. And he is not, I don't believe that my client would be a flight risk. Every time he's gotten in trouble, he stayed in the jurisdiction. He's never had an FTA, never absconded, never had to be hunted down by any jurisdiction that he's had a case in. He's always submitted himself to the jurisdiction of the court. So, Your Honor, considering the statute and the Ayala factors, we are asking that Your Honor set a reasonable bond of no more than $10,000 on the aggravated assault.
Do you think he's a different person after 84 days and he did 7 years on burglary?
Yes, Your Honor. You know, we don't know when changes occur in people.
Oh, you're right.
And they're defining moments in everyone's life. So,
I got you. Okay. Attorney Freeman, what you got? You're on mute.
Your Honor, again, I stand on everything that I presented to the court. And I do realize that the 90-day mark is coming up and he will be entitled to a bond. If the court is so inclined to grant a bond on the aggravated assault, this is one of those cases, Judge, where, like I said, the allegations that he poured gasoline onto our victim, I don't think the victim has denied that at all, even when she spoke to Ms. Reddick. And
she has not. She hasn't acknowledged that. Right.
And it is one of those cases where, this is not a victim who is saying it didn't happen or does not want to go forward. And so if the court is inclined to grant a bond because the closeness of the 90th day, we will certainly ask for a really high bond on this ag assault, given that he is currently on probation and his other history. We would ask for, a minimum of $75,000 at least, and a GPS, as well as a stay away. And I know the victim is asking for contact, so it will be a no violent contact. I guess my concern is for someone to pour gasoline on someone. I still, I have concerns about that, even though the victim is asking for no violent contact. Just because, especially if there's an allegation that he did have a lighter in his hand. I mean, I have concerns about the contact. And again, that's if the court is inclined to grant a bond.
Right. Considering everything, I think for judicial economy, the court is inclined to grant a bond, but given this prior history and the nature of the fact and circumstances surrounding this case, given the fact that he's presently on probation, and given the fact that the court has concerns, as we know, oftentimes alleged victims lack certain things to protect themselves, let alone their minor children. So the court will set a bond in the amount of $75,000. It really doesn't have much discretion to go against the state's recommendation for all the reasons indicated, and the court would not allow contact, especially without hearing directly from the alleged victim. But that would be the order of the court. $75,000 on the aggravated assault. There's already $4,000 on the other charge, and no contact.
I'll give that to you, Your Honor. Give me like 2 minutes or 5 minutes.
So the total bond amount, Your Honor, is $79,000.
Correct.
Thank you, Judge.
All right, unless there's anything else, then Mr. Smith can go back with the deputy. That'll conclude this case. We'll prepare the orders and we'll get them signed and sent out.
Right, and Judge, given that this is an order from the court, would you like for me to send it to the public defender's office so they can sign off on it, or just send it directly to you?
Yeah, let's get them to sign off too.
Okay, if I could have 5 minutes.
Okay, yes. Court recess for 5 minutes.
All right, thank you.
Thank you. The next case will be Thompson, Devon Thompson.
Judge Brown, you need Thompson?
Yes, sir.
Yeah, a little bit.
Yes.
Your Honor, before you begin the next hearing, may the public defender's office be excused? We have no more matters pending before the court.
Yes, ma'am. Thank you very much. Have a great weekend.
Thank you, Judge.
They bringing it up now?
Please mute your phone. We're standing by for Attorney Freeman.
Judge, I'm not sure whose iPhone that is that's on.
Miss Thompson, can you hear me?
Yes, I can.
Okay, do you see a little mute button on there? Can you hit the mute button?
Yes, sir.
Okay.
All right. So we're ready to go forward on the next case. Court is calling the case State of Georgia versus Devon L. Thompson, represented by Defense Attorney Kenneth Muhammad. State's represented by Assistant District Attorney Cheryl Freeman. Mr. Thompson had 11 charges. They are listed in chronological order, starting with the case of 2020 CW 504383940414244454647 and 48. Corresponding charges are driving with no tag or expired tag, serious injury by vehicle, failure to make, and it's got cut off something, failure to make something. And that's on 40. On 41, reckless driving. 42, improper lane change. 43, fleeing from police. 44, obstruction, firefighter. 45, hit and run accident. 46, strike and fix object. And 47 is cut off, and 48 is cut off. So they will be announced as we proceed. So all parties have been announced ready to proceed. Attorney Mohammed, you may.
Thank you. Thank you, Judge. Excuse me. Judge, this case involves an attempt by Clayton County police officers to negotiate a traffic stop. And near the end of that attempt, the officer performed a pit maneuver on the vehicle that my client was driving. The vehicle, as a result of a pit maneuver, spun, hit an object, and the passenger of the car, who was my client's fiance, passed away. It's alleged that before the pit maneuver was performed, the various incidents that are charged happened. I have my client's mother on the phone. If he is granted a bond, he would live with her. I don't know how much time she has, so would the court allow me to question her at the start and then go into the rest of my presentation?
Any objection from the state?
No objection.
You may.
Okay, Ms. Thompson, are you able to make it where we are able to see you, or is that possible?
Yes, sir.
Okay.
Can you see me?
I can. Okay.
Yes.
Can you raise your right hand? Okay. Do you swear or affirm that the testimony that you will give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Okay. You can put your hand down. And can you state your full name for the record?
Angelique LaShawn Thompson.
Okay. And what is your relationship to Devon Thompson?
That's my second born son.
Okay. If he is granted a bond, would he live at the residence that you are living in?
Yes, sir.
Okay. And what do you do for a living?
I'm a certified chef.
You said certified chef?
Yes, I cook.
Okay. And who all lives at the residence?
My daughter, Erica, and my son, Jacob.
Okay. Judge, I have no further questions. Oh, and what city is that? Don't say the full address, but what city is the residence in?
Stone Mountain.
Okay. No further questions, Judge.
Any questions, Attorney Freeman?
I guess, I'm sorry, ma'am. First, my name is Cheryl Freeman. I'm with the Clayton County District Attorney's Office. Tell me your last name again.
Thompson.
Ms. Thompson, okay. And your current address is in Clayton County, you stated?
It's Stone Mountain.
It's Stone Mountain, okay.
It's in Stone Mountain, Gwinnett.
Okay. Before your son was incarcerated in Clayton County, where was he living? I think you froze.
All right, we'll stand by, see if we can get her back.
Okay.
Oh, it looks like she's back.
Right, Ms. Thompson, you froze a little bit.
Can you see me?
Okay, yes, I can see you.
Okay.
Okay, are you on your way to work or somewhere?
Yes, ma'am.
Oh,
yes, ma'am.
Okay, all right.
Clean.
Okay, before your son was arrested, where was he living?
He was living between me and his fiance house.
Okay. So he didn't have just one stable residence. He moved between the two?
No, he didn't move between the two. Wherever I stay, my son can always stay with me. He lived with his girlfriend, but he'll come stay at my house home.
Okay. The address that that I have on most of my documents is an address from Chicago, Victoria Lane in Chicago.
Okay.
Who resides at that address?
That is my cousin. That is my cousin Tracy, who he does call mom too. But that's, I'm sorry, that's my cousin.
Okay, so how often did he reside with your cousin?
He lived with my cousin before he moved to Georgia about 5 years ago.
Okay. One second. Is that the address that he normally used on documents or his license?
Yes, because that's me. Like, even though I live in Georgia, even when I lived in Illinois, I always use 1524 Seymour. That's a family house, you know, so even if you're moved, you know, your mail is going to go to that address.
Okay, so so even though he moved to Georgia, you said 5 years ago, he still used your...
No, he didn't use that. I'm saying if he did put that down, that's just probably a comfortable address he remembers.
Oh, but you don't know. Oh, okay.
Yeah, I can't tell you that.
Okay.
I'm just saying.
Okay.
Out of my own era, I've done it too. Familiarity. That's a family home. I always use that address.
Okay. Where was your son, or did your son work before he was arrested?
Did he work before he was arrested? I can't tell you that. I don't have no knowledge of that. He didn't tell me he was working.
Okay.
I can't tell you that.
Okay, I understand. Thank you.
I do know that he was proud to be engaged and he was having a little a baby. That is the furthest that I got.
Okay, I understand. Judge, I believe that's all I have for Ms. Thompson.
Judge, a very brief follow-up.
Go ahead.
Ms. Thompson, you mentioned 5 years he's been in Georgia. The information that I have, if it showed that he was been in Georgia for 6 years. Do you have any reason to doubt he's lived in Georgia for 6 years?
Look, can I tell you something? It might be 6 years. Like I said, I'm 45 years old. I may have made a mistake, but I know that it's been more than 5 years. It's been 5 years or more that he's not been in Illinois.
And am I correct that all of his immediate family live in the state of Georgia, including you and a sister that he has?
Yes, we moved to be with him. Yes, me, his sister, all his siblings live in Georgia.
Okay. All right. No further questions.
Thank you.
I don't have any other questions for Ms. Thompson. I would like to go into Mr. Thompson's history.
Well, I hadn't finished.
Oh, okay.
I was saying that I wanted to put her on because she was going to work.
Oh, go ahead.
Okay.
Well, hold on a minute, because I didn't get a chance to ask the question, but if she has to go to work, there's no problem.
Ms. Thompson, are you still there?
Okay.
Okay.
No problem.
Oh, no, there she is.
Hello? Yes.
Yeah, I think the judge may have questions for you.
You go ahead and finish. Did you have anything else with her?
I don't have any more questions of her. I had more to my presentation.
All right. So let me ask Ms. Thompson, let me ask you this. First thing you said, you make mistakes because you're 45 years old. But then I get a clear waiver for anything. But anyway.
Yes, sir.
So anyway, how old is your son?
She's frozen.
Attorney Mohammed, how old is he?
27.
All right. So I'm gonna let her go to work. I have no questions.
Okay. You can log off, Ms. Thompson. If you can hear us, you can log off.
Thank you. All right, go ahead, Attorney Muhammad.
Okay. So, Judge, he has lived in Illinois as a juvenile, but he's lived in the state of Georgia for 6 years, and as indicated, his entire family now resides in Georgia. He owns his own recording studio. He actually is an audio engineer and is employed through both work that he does at his recording studio and
How old is my son? He's 20. He's like, all right.
Yeah, Ms. Thompson, if you could log off.
Judge, there is a way for you to, you can exit her out.
Well,
okay.
She's gone. Mm-hmm.
All right, good.
Okay, yeah. So at the time of his arrest, he had two businesses that he had going. He's an audio engineer and operates his own recording studio, and he also had recently started a moving company with another individual. And his companies were doing well, both in the state of Georgia. He's lived in Georgia for 6 years. I discussed his criminal history with the state. It's my understanding from talking to my client that his Illinois history, with the exception of 2 offenses, are all juvenile. The state indicated that they saw a number of offenses out of Illinois. So I don't have a copy of the Illinois history, but I would just state that if it's anything beyond a theft charge, which was a shoplifting incident when he was 22 years old, which would have been 5 years ago when he was visiting in Illinois. And then another incident when he was 19, which was a robbery by snatch. Other than those 2, anything else out of Illinois, is my understanding, would have been when he was a juvenile. I don't have anything to contradict that right now, but like I said, I don't have a copy. In the state of Georgia, he has one 2017 misdemeanor offense, which is an obstruction, and a 2018 felony shoplifting. Those are the extent, that's the extent of his criminal history. There is an open charge in DeKalb County that is unresolved with charges that arise from his presence in a vehicle as a passenger with other individuals. And there was misdemeanor amount of there was marijuana inside of the vehicle, a financial card, and a firearm inside of the vehicle. My client was charged, but I would just state to the court that my client was only a passenger, and it's our belief, our strong belief, that that entire case should resolve without any conviction as it relates to my client. So with that being stated, we have the one felony shoplifting in Georgia, the misdemeanor obstruction, and then the 2 incidents in Illinois, one when he was 19 years old, as the extent of his history. So, Judge, it's my understanding that all of the charges have a bond except for 3. That would be the hit and run, fleeing from a police officer, and serious injury by vehicle. We're asking that the bond that you set for those 3 charges in the aggregate be no more than $50,000. The remaining charges, if I've added them right, the bond and fees total $14,250. And so whatever you impose for these 3 that don't have a bond would be in addition to that $14,250. My client's been in custody since January 26 of this year without bond on those charges. It's my understanding from talking to the state that they prefer that my client stay in a no bond status, and that their recommendation, if the court were going to impose a bond, would be at $150,000. $150,000 bond would effectively be a no bond. I'll state to the court that really, in truth, anything over $50,000 would be at a no bond, would place him in a no bond situation. I've spoken to my client. He has indicated that he has been in contact with the victim's mother. We would relate to the court that as of yesterday, they have been in communication, and I don't want to overstep it, but our understanding is that she did not oppose bond, and I'll just leave it at that. Ms. Freeman indicated that she's spoken to some family member, and they didn't indicate that, but I don't know if it was necessarily the victim's mother. I believe those are all of the issues that we wanted to present to the court. I guess the last thing is the shoplifting offense. There is still an open probation for that 2018 felony shoplifting. It's my understanding that even upon posting bond, my client would still have to be transported over to Gwinnett County to deal with the probation revocation issue. I've discussed this extensively with my client. There have been discussions with the probation officer over there, and particularly given the fact that it's now been 7 months without indictment. My client is just sitting here in the COVID-19 situation with regard to trials. We believe it's in his best interest, even given the fact that he would be transported over to Gwinnett. We anticipate it'll be in his best interest to go over and to resolve that, and that he would ultimately be able to handle this case after resolving that from the street. We also discussed the possibility of him getting a GPS ankle monitor to alleviate any concerns that the court may have. My client is prepared to do that, and we'd ask the court to consider a GPS ankle monitor and any restrictions with regard to the timing that he could leave the home or whether he could leave the home at all, if the court would consider that as well. With that, we'll submit to the state.
All right, Attorney Freeman.
Thank you, Your Honor. This is a case where this young lady lost her life. This case, when police were trying to pull the defendant over, instead of stopping, he accelerated, and it turned into this police chase that resulted in this young lady losing her life. And so as Mr. Muhammad, talked about, Mr. Thompson is on probation out of Gwinnett for felony shoplifting, and he does have an open case in DeKalb. It is still open. I don't have the facts of that case, so I'm not going to represent what happened in that case, but it is for a felony possession with intent for marijuana. I think Ms. Muhammad indicated it was a small amount. Well, he was charged with a possession with intent, financial transaction card theft, as well as possession of a firearm during the commission of a crime. And those are still pending in DeKalb. And I did indicate to Mr. Muhammad that the history out of Illinois, now the information that is on file that was presented to police when Mr. Thompson was taken in was his address in Illinois. And I know his mother has indicated that she thinks that maybe he used that because it was familiar. But whether that's the case, the address that Mr. Thompson has been using is in Chicago. So, and I think based on the mother's testimony, that was her cousin or aunt, I can't recall, but he still has family there. So I certainly will say that there is a chance that he would flee. But looking at his Illinois record, let's see, going through here, and I'm not going to try to figure out if he was a juvenile or not. Just looking at the years, it doesn't state juvenile, and so if it is, I don't know. But looks like from 2004, there was a shoplifting. And what is this? 2004, looks like felony larceny. In 2006, it says there was an assault, and it says a felony. And it looks like it started as an aggravated battery / school employee. And I apologize for it. It takes a minute to go through the way Illinois has their GCIC. There was
Judge, if I could interject, it looks like he turned 17 years old in 2010. So I just want to state that.
All right, thank you. There were some traffic offenses that are on his history, and that says 2012. And what year is this? Again, a battery in 2005. There was a robbery in 2006 where he received probation.
It was a robbery in what year?
Sorry, in 2006, he got probation. There was a battery in 2012. It looks like in 2009, a burglary.
Oh, that's juvenile, right?
Everything she mentioned except for the 2012 is all juvenile.
I don't need to hear anymore. Thank you on that one, on the juvenile.
But then so going to 2010, looks like there was larceny, disorderly conduct. In 2012, looks like there was a theft of stolen property and a larceny. In 2016, looks like there was a theft, larceny. And it says theft, control, intent. I'm not sure what that means, but it says felony. And then it looks like in 2017, it says escape, failure to return from furlough. And it sounds like that may have been possibly a work release or something, but it says failure to return from furlough. And then it appears that there may have been a violation, and then from 2017, he was sentenced to 2 years imprisonment. And so so that's what I have out of Illinois. I think that was the last. Yes, that was the last thing I have out of Illinois. So so Mr. Thompson certainly has ties to Illinois, and certainly there may be the potential to flee. And Judge, I indicated to Attorney Muhammad, I don't have an indication from the decedents, from anyone in her family, that they are for or Mr. Thompson receiving a bond. That is not information I have, so I cannot represent that to the court. But we heard the testimony from Mr. Thompson's mother when I asked her if he had a job before he was arrested. She couldn't answer. She didn't know. She indicated that he lived between the decedent and her house. So it doesn't sound like there was a stable living arrangement. And so given all of that, Your Honor, and I know he's been in for quite some time, but the state would ask that the charge where he doesn't have a bond, that he remain on no bond status. But in the alternative, given how long he's been in, if the court is inclined, and what I indicated to Mr. Muhammad, what I would be asking is for a minimum of $150,000 total, as well as a GPS. And we would certainly need the address where he's going to reside, given his ties to Illinois and the instability of where he resided before he was arrested.
Judge, brief response.
There's one question, Attorney Freeman.
Yes, sir.
He's been in 90 days without indictment.
Yes, it appears this, let's see, the warrant was taken out on January 26th. And give me 1 second, I can pull up his confined date.
So what would be your basis for asking for no bond if, in fact, under law, he's entitled?
Well, again, the information I have just based on the family, given his ties to Illinois, and it seems like he had numerous run-ins with the law in Illinois. He's currently on probation here, and so that would be my basis. But I understand it's been after 90 days and that he is entitled to a bond. And that's certainly why I said in the alternative, I would ask for a minimum of $150,000 with a GPS.
Attorney Muhammad.
Yes, Judge. My first concern is there was a number of juvenile offenses.
Okay, I heard the juvenile offenses, but I think in addition to that, I don't have to dwell on the juvenile. Okay, and then we heard there may have been this and there may have been that, but may have is a loaded couple of words as far as a couple of things that were mentioned in 2017 with regard to Illinois, and I would just say that just we don't have anything to corroborate those 2017 statements, and there seems to be a lack of clarity on that. What we have are the two incidents, one, that I had mentioned. Okay, we don't have to go back over it.
Okay. So the other correction I wanted to make, he is not charged with intent to distribute in that open DeKalb County case. There's a co-defendant on that case who was a driver, and as I indicated, they charged my client as well, but every indication is he is not going to be convicted. I just want to state that to the court, that is not one of the charges. I have the accusation right here in front of me. And then lastly, my client was engaged they were set to be married in March. So I think what the state is doing is describing a situation where a couple is going to move in permanently with one another, and that the situation is, he has one living situation. He's also living with his girlfriend. They're going to be married, and that will be his permanent residence, and describing it as instability. It wasn't instability. It's that he was going to be married. He would have been living with his fiance. And so those are the only points I wanted to correct for the record. He's been in custody for 7 months without bond on these charges.
All right, after considering the evidence in the case, the court is not in a position to oppose the state's amount of bond of $150,000 with conditions, if any, if they are feeling appropriate by the state, given the fact that by the very nature of the charges, even which Attorney Mohammed has indicated that they had to perform a pit maneuver to get him to stop after all these other traffic violations in and of itself is enough to cause serious concern for his flight or failure to appear. And that's in addition to the fact that he's on probation. That's in addition to the fact that he has pending charges and has several felony convictions. And the other concerns the court shares, arguments, concerns, and positions by the state regarding actually where he lives and regarding his still using the Chicago address, and regarding his position, his ties to the community. His mother really can say too much about him. The person he was supposed to be married is deceased, unfortunately. And so we don't really know what his living situation will be. You made reference to recording studio and own some businesses. I don't have anything to confirm that at all. So based on everything, the court would deny, the court will not oppose the state's position of $150,000 bond on those charges that had no bond, or whatever was communicated to the Attorney Mohammed by Attorney Freeman. And I find he posed significant risk of flight or failure to appear in committing felonies pending trial. That will conclude this case.
Judge, can I ask one question? Would the court be inclined to make the total bond with all charges $150,000? I think the way the state even referenced the recommendation was a total bond of $150,000.
I'll go with whatever the state agrees to.
That's what I was in a total.
All right, then that's what it'll be.
Yes, Judge.
Okay.
All right. Then Ms. Thompson, go back with the deputy. That'll conclude this case. I'll ask state to prepare the order, and we'll get signatures by you, Attorney Mohammed, and we'll get that back so that can be sent over to the jail.
Thank you.
All right, that concludes this hearing. Thank you very much.
And Judge, if I could have about 10 minutes to finish writing this up to send to Mr. Mohammed.
All right, 10 minutes.
All right, thank you.
All right, we got 2 left with Attorney Toles, right?
Yes, sir.
All right.
Judge, I'm back. I'm ready for the next hearing. Chris,
Okay,
I'm
coming. I'm sorry.
Which one are we doing first?
Let me talk to the judge about Sturdivant, because that was it's gotten so.
Wait, we're still on YouTube.
Yeah.
Okay. Judge, we're still on YouTube. If you can hear us.
Okay. All right. What do we need to do?
Judge, I wanted to be on Sturdivant. I wanted to address a couple of things on his before maybe the court consider some things.
Well, can we do Nolan first then, since we're on YouTube, and then do Sturdivant last if you need to speak with a judge? before the hearing?
That's fine. I just was wanting to get it, maybe to release some folks.
It doesn't. Okay, whichever way.
Yeah.
All right. Is someone suggesting I go off of YouTube right now?
Well, if Mr. Tolles needed to discuss something with you, either you can send the three of us to a breakout room or go off of YouTube.
All right. So, ladies and gentlemen, we got what would in effect be in the courtrooms approaching the bench. So I'm going to put the three of us in the breakout room, and we will be back to move forward with these last two cases. So let me see. This is a new one for me, so let's see what we do. But it shouldn't take but a minute. All right. So we got Attorney Freeman, can you hear me?
Yes, Judge.
Okay, I have the box open for you and Attorney Tolles, but what about, doesn't say anything about how I get in. You
have to assign yourself to the same breakout room.
I don't see mine.
And I don't have anything that came up assigning me to a breakout room, but it's the same way you would do everyone. You have to assign yourself.
Okay, I don't think. All right. I don't see how I can assign myself because I don't see where it has something for me on the option.
We can just go off of YouTube if it's, and then that way, whatever Mr. Tolles wants to bring up won't be on YouTube.
Let me.
So I now have a breakout room invitation.
Okay, let's see. Still don't see what I can do that. All right, well, let's do this.
And I have an invitation too as well, Judge.
Right, I'm going to send you guys to the breakout room and see if I can get in, figure out a way to get in. If not, then I'll bring you back and then we'll go off YouTube. Yeah. All right. What happened? You all left and came right back?
It didn't let us go.
Okay. Okay. All right. Didn't do it. So anyway, I think what I'm going to just do is go off YouTube right quick. Okay. All right, ladies and gentlemen, I'm going off YouTube and we'll be right back.